I'm Representative Aaron Dana. I represent the Passamaquoddy tribe, Medalkamiguk and Zibayak.
Good morning. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Welcome. I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Good morning. I'm honored to be here with all of you. My name is David Sinclair for the people of House District 50, the city of Bath.
Good morning and welcome. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Good morning, all. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Hanover, Milton, Roxbury, and my hometown of Rumford.
Good morning. I'm Danny O'Halloran, and I proudly represent District 20, which is the industrious city of Brewer.
I heard Dave Hagan, Senate District 10, 12 towns surrounding Bangor, not Bangor.
Good morning, everyone, and welcome. My name is Rachel Talbot Ross. I proudly represent Senate District 28, which is on the peninsula of Portland and includes the University of Southern Maine campus.
Good morning. I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee. Welcome.
And I'm Ann Carney. I represent Senate District 29. That includes South Portland, Cape Elizabeth, and some of Scarborough, and I serve as the Senate Chair. And I also want to extend a warm welcome and thanks to everyone who's here today, especially the leadership of the Wabanaki Nations. Thank you for honoring us with your presence. And so we are going to start by opening the hearing on LD 395. This bill is entitled An Act to Restore Access to Federal Laws Beneficial to the Wabanaki Nations. It's being presented by our colleague, Senator Talbot Ross. Before you get started, Senator, I wanted to give Representative Caruso an opportunity to introduce herself. She has joined us online.
Good morning, everyone, and welcome. My name is Elizabeth Caruso. I represent the people of House District 72, which is much of northern Somerset County.
And then, Senator, your mic needs to be turned on. Thank you.
So good morning, everyone, once again. Senator Carney, Representative Kuhn, and esteemed members of the Committee on the Judiciary. I'm Rachel Talbot Ross, as I just introduced, and I proudly represent Senate District 28, which you learned is part of Portland, part of the Casco Bay Islands, and includes the University of Southern Maine campus. It is my pleasure to be with you today to introduce LD 395, an act to restore access to federal laws beneficial to the Wabanaki Nations. Before I begin, it's important for us to all recognize that the land we stand on today is most recently the ancestral unceded land of the Nan-Rantsoku Band of the Abenaki Indians, a name meaning people of the still water between the rapids, who were the last native stewards of the land between the Kennebec and the Androscoggin rivers, where they lived as farmers and fishermen until European contact. They merged into the tribes that make up the larger Wabanaki Confederacy, the Holton Band of Maliseet Indians, the Micmac Nation, the Passamaquoddy tribes, and the Penobscot Nation. It is important to recognize this as ancestral territory, now referred to as Maine, where there were once 20 distinct Wabanaki tribes in present-day Maine. Now only these 4 remain. I also want to just take a moment to give thanks to the many people, including tribal leaders, tribal citizens, the Attorney General, the Governor, elected officials, and the people of Maine, who have worked for decades to advance positive tribal-state relations. I specifically want to acknowledge the current effort by Governor Mills and tribal leaders who are working collaboratively to move the issue of self-determination of the Wabanaki people forward. I believe they are operating in good faith, and as a result, we will be able to make significant progress toward that goal of self-determination this legislative session. The Holton Band of Maliseet Indians, the Micmac Nation, the Passamaquoddy tribe, and the Penobscot Nation are all recognized under federal law. But unlike the 570 other federally recognized tribes, the tribes in Maine are unfairly excluded from the very laws and programs expressly created by Congress to benefit them. The Maine Indian Claims Settlement Act of 1980 and its corresponding Maine legislation, the Maine Implementing Act, imposed a unique legal, jurisdictional, and regulatory structure on the tribes in Maine. It diminished the tribes' sovereign claims and reduced their standing to that of municipalities. Even more harmful, the Settlement Act contains unusual provisions that block most federal Indian law from applying to the Wabanaki nations if the federal law affects the application of Maine law. Quite simply, this allows state law to be prioritized over federal law. Any federal law enacted for the benefit of Indian tribes, which would, quote, affect or preempt the civil, criminal, or regulatory jurisdiction of the state, does not apply to the Wabanaki nations unless the United States Congress explicitly makes that law applicable in Maine. This means that the Wabanaki nations are the only federally recognized tribes routinely denied benefits of federal legislation that help all of the other tribes in the United States grow, flourish, and prosper. I have introduced LD 395 to correct that historical anomaly and give the Wabanaki nations the opportunity to improve the lives of not only all tribal citizens in Maine, but every person who calls the state of Maine home. You will see in my testimony that if the Wabanaki nations are granted the benefits of federal legislation that applies to all other tribes throughout the country, they will have the opportunity to build their tribal governments, engage in meaningful economic development, access federal programs that were created in part to remedy our country's historically brutal treatment of our only Native residents, reduce unemployment, poverty, and improve housing and infrastructure. We know, I believe we know, that when the Wabanaki realize those opportunities, the lives of Mainers residing in surrounding communities will be improved as well. So I am going to, you have a copy of my testimony. What I do in my testimony is I refer to two publications that help explain the history of why we've treated the Wabanaki Nation so unjustly under the Settlement Act and the Maine law, and the devastating consequences of that mistreatment. The first report, I know you're familiar with some of this information, so I'm going to skip over it. The first report is that of the Task Force on the Changes to the Maine Indian Claims Settlement Act, Implementing Act, that was issued in January of 2020, which we all know as the Maine Task Force Report. The second report was issued in December of 2022 by the Harvard Project on American Indian Economic Development. I know you're familiar with that report. If not, we can make sure that you have the copies of it. But those two reports focus in part on the sheer volume of federal legislation that's been enacted since the Settlement Act and the Maine Implementing Act came into law. The Maine Task Force report specifically listed 151 federal laws enacted after 1980 that benefited other tribes where the Wabanaki have not. I include a list of those federal acts in my testimony. I would ask that you take some time to read it. It is devastating when you think about the volume of all of the beneficial laws that have not been applied to the tribes in Maine. I will also skip down because I know that you're familiar with the task force report, but I want to make a direct connection. In the task force report, unanimously adopted consensus recommendation number 20, which I do think is important to read. This is a recommendation out of the task force report. Recommendation number 20, amend the Maine Implementing Act to specify that the purposes of, and this relates to the federal law, subsection 6H and subsection 16B of the Federal Settlement Act, federal laws enacted for the benefit of Indian country do not affect or preempt the laws of the state of Maine. So many of you have served on this committee in the past know this language, affect or preempt. And you've heard directly from the tribes and several legal experts about this affect and preempt. I know, like you, that that's a very vague terminology. Preempt the way I know preempt is in a preemptive strike. Affect is not effect. And so this very vague and quite ambiguous language has been used really to weaponize the act so that anything that is perceived that could interrupt the state's interest or be in the state's interest allows for the tribes to have to then appeal to Congress to explicitly name them in that benefit. Otherwise, it is not realized. I believe, I want to also just draw your attention, and I won't read it, to some of the data that was contained in reports, the Harvard report specifically. I really, really encourage you to take a look at it. These disparities are not just for fodder. Every number, every figure represents a human being, an Indian adult or child who's not able to reach their full potential and live a life full of hope and the dignity that they so well deserve. These are real people in these figures, and I hope that you would take the time to look at them. Unfortunately, the trajectory of these disparities have not gone away. And in fact, generation after generation lives under this mistreatment. So with that, I actually had plans to walk you through every piece of the bill, but I will not take the time to do that. I know that we've got tribal chiefs here and other tribal leaders that are here, and I know that you're anxious to hear from them. But I will be able to answer any of your questions regarding this piece of legislation if you so choose at another time. And therefore, Madam Chair, I would like to take this opportunity to ask the tribal chiefs if they will help me introduce this legislation and present this critical bill to you this morning. And I will start with Chief
Senator Talbot
Sabattis.
Ross, I could take
Let's
care of
start
that
with
if you'd
Chief
like.
Sabattis. I thank the committee for their time, and I look forward to working with you on this bill. Thank you, Chief.
Yes.
Thank you. And committee members, I'd ask if we can defer questions until the work session, because Senator Talbot Ross will be with us for the work session. And at this time,
I do have
you have written testimony. Okay. And at this time, I'd like to welcome Chief Sabattis.
Here. Willie Zabawo, Senator Carney, Representative Kuhn, and esteemed members of the Joint Standing Committee on Judiciary. Notably was Clarissa Sabattis. I am the chief of the Holton Band of Maliseet Indians, and we're located in northern Maine. As most of you know, I see some unfamiliar faces in the room, so I'll try not to skip over important details. I am not going to read my written testimony today. I just wanted to touch on a few things and the importance of this bill. So I am testifying today in support of LD 395, an act to restore access to federal laws beneficial to the Wabanaki nations. I think that looking back into history, there was a shift from an era of termination to self-determination for our tribes, and that ended harmful assimilation policies that really created extreme poverty within tribal nations. It dismantled governments and really threatened cultural survival. But the United States saw that the benefit of creating laws that would help us thrive and survive and be strong governments was important. And unfortunately, with some of the stuff that was created in 1980 with the Settlement Act and the Implementing Act, it really denied us access to those very things that help to make us strong and thriving governments. I will say that despite that, we do have very strong infrastructures, and we've been able to create, some wonderful things for our own people. But that doesn't mean that we have been treated equitably or equally when compared to the rest of the tribes across the whole nation. So being the only tribes here in Maine, we have different laws that we have to go by than every other tribe. And so we have to be creative, and we have to, do things in ways that are a little bit more difficult. It creates disparities with us. So, for example, these federal beneficial acts that are created before 1980 and after 1980 that we don't have access to unless the state says so, they've created economic hardships compared to other tribal nations. That trickles down to our people, our services, our ability to fill gaps. But also, it's kind of created this cyclical inequity that happens, not only with our people, but as a government. So when there is federal legislation that's created and passed, it is a blanket coverage for all of tribal nations. So all of Indian Territory except here in Maine. And we already have said that we have inequities. We have struggles economically compared to other tribes, but then we have to turn around and find resources or devote resources to chase after laws that should just apply to us. So it not only has created that inequity, but we also have this other piece that's added to it. So it's compounded. Every time there's something that comes out that should apply to us, that is meant to benefit us and help us be stronger as governments and help us to help our people, we have to figure out how to have access to those when they just should apply to us. So I'll talk a little bit about this and that'll be it. I think that I appreciate Representative Talbot Ross. She has, I'm sorry, Senator Talbot Ross now. She has been a tireless advocate for us and our sovereignty over the years and a wonderful friend. So I appreciate her willingness to submit bills and language for us that supports what we're really working for. And I will acknowledge that there have been conversations with the governor's office. We're working in good faith and hoping that we can come out at the end with some language from this bill and the other, the sovereignty bill. That may not be everything, but could be incremental changes in the right direction. But I feel like it's my responsibility as a tribal leader, regardless, to make sure that these bills are seen and heard in their entirety, regardless of what the end product is. So this bill would ensure that our nations receive equal treatment, which I've said, with the other 570 plus federally recognized tribes nationwide under laws passed by Congress for benefits of Indians. I really feel like it's a small request. I think what I've been asking for really has been, even if we could stop the clock and look at everything moving forward, it wouldn't change any current laws in Maine, but would mean that everything moving forward, we just know that we would have access to. And that's less that we have to try to figure out how to fight for. While the fundamental purpose of MICSA in 1980 was to really settle land claims, it also imposed this restrictive jurisdictional model, granting the state broad civil and criminal jurisdiction, including civil regulatory authority over the Wabanaki nations, our citizens, and our reservations and trust lands, unlike the rest of Indian country. But it went further in denying our citizens the benefit of any federal law passed by Congress that might affect or preempt jurisdiction. And I appreciate Senator Talbot Ross for kind of going into detail about that. I think that, it's difficult to come here and ask for these things and spend time and resources when we know that, and we work with side by side and see other tribes who are really flourishing and able to just have access to these things. It's hard to come here and ask. It does feel sometimes like we're begging for things that really just should be inherent to us. I think that I want to also highlight the Harvard report that Senator Talbot Ross talked about and the task force recommendations. The Harvard report does talk about really the success of the tribes also being a success for the state of Maine. It talks about tax benefits that would be here for the state of Maine. It talks about revenue that would come into the state of Maine, and it talks about job creation, just to name a few things, if we had access to these laws that were meant for Indian country, like everywhere else except for Maine. So, I guess that's all I'm going to say for today. I don't want to go through, I've written down my testimony. I think that it's very thorough and you might hear the same things over and over again. So I'm going to spare you that today, but I thank you for listening to me. And if you have any questions, I will be sticking around so you can ask. So,
Thank you, Chief Sabatis. Would you be open to committee member questions at this time?
yeah, absolutely.
Committee members, are there any questions for Chief Sabatis? Not seeing anything.
Thank you.
Would the next leader of the Wabanaki Nations please step forward? And you can step forward in any order that you see fit. Thank you. Thank you for being with us.
Police Boswell. Sagam William Nicholas Tillyways. Pescatamuk Nil. Madak Migog Nujayal. Good morning. My name is William Nicholas. I'm the chief of the Passamaquoddy tribe at Madak Migog. I'm here on behalf of the Passamaquoddy tribe to testify in support of both LD 785 and 395. I'd like to begin by thanking Chair Carney and Kuhn and the rest of the committee for your time. I'd also like to thank the legislature as a whole for its consideration of these important bills and for your support for tribal legislation over the past several years. The tribe has always been and continues to be in favor of a full recognition of the Wabanaki Nation's sovereignty, including access to all federal laws applicable to tribes. When the legislature convened the task force on changes to the Settlement Act in 2019 to start a process aimed at that goal, the Passamaquoddy tribe poured in significant resources in both time and money into the process. We attended every meeting with tribal leaders and attorneys, and the product of that work was LD 785. LD 395 also evolved out of that effort. The tribe was and continues to be very proud of that effort and the work that's been done to advance Wabanaki sovereignty in the past 6 years. As part of that investment, the Passamaquoddy tribe is the only Wabanaki nation to have seated a tribal representative, Representative Dana, in the legislature for each of those legislative sessions. Representative Dana sits on the committee now, and former Chief Rena Newell sat on this committee before. The tribe wanted its representatives on this committee because this is where the sovereignty issues have historically been addressed in the legislature. It's always been about sovereignty for us, pure and simple. Going into this legislature, the tribe designated pursuit of economic development as its top goal for 25 and 26, given the most recent outcomes of the sovereignty legislation in the state. That decision was not about taking the foot off the sovereignty gas pedal. Instead, it was about shifting gears out of recognition that legal sovereignty is most attainable when there is a strong economic foundation to work from. We are proud to say that we made major progress towards that goal of economic sovereignty through the governor's decision to allow LD 1164 to become law. That outcome was the product of months of work between tribal leaders, attorneys, and the governor's office, and we are grateful for that successful and ongoing collaboration. Over the past couple of months, the tribal state dialogue shifted to LD 785 and legal sovereignty related issues. Therefore, I'd like to focus my testimony today on the issues under current discussion among the tribes and the governor's office, including 3 items that the legislature can easily accomplish during this session. These low-hanging fruit, so to speak, expand on good work that the Wabanaki Nations and the state did through LD 585. Specifically, we're advocating for amendments to the tax code that would provide 3 tax exemptions beyond what was included in LD 585. First, we're advocating for an amendment that would extend the income tax exemption to tribal members who work for one of the 4 Wabanaki nations, regardless of where the tribal member lives. Under LD 585, tribal members who work for a tribe and live on tribal land are exempt from state income tax. The exemption brings some economic relief to our tribal member employees and is consistent with federal Indian law principles that apply in other parts of the country. However, there's no reason to limit the exemption to folks who live on tribal land. The work is being performed on tribal land, so it doesn't make sense that a person's residence determines whether they're subject to the tax. Instead, the legislature should amend the tax code again to broaden the exemption to any income that a tribal member earns working for any of the Wabanaki nations. This is a common sense change that would give more much-needed economic relief to our tribal member employees and is in line with how tribal member employees are taxed in other jurisdictions. Second, we are advocating for an amendment that would extend the tribal entity sales tax exemption to purchases occurring on certain tribally owned fee land. Like the amendment that I discussed a second ago, this amendment would expand on a change that LD 585 introduced. LD 585 created a sales tax exemption for sales sourced to a location on tribal land. In other words, state sales tax does not apply if the services or property are received on tribal lands. Tribal land under LD 585 is limited to tribal trust land, but we have limited ability to convert fee lands into trust lands for purpose of this taxation. We want to see an amendment that defines tribal land as including both land and certain fee lands, both trust lands, and fee lands that each Wabanaki Nation owns. The tribes would designate particular fee lands to be subject to the exemption, and those lands would expressly be called out in the legislation. The fee lands where the tribe operates Passamaquoddy, operates businesses near Jackman are one example where the change in law could bring benefit. These businesses are very close to our trust lands and support the tribe's hunting and fishing activities in that region. It's consistent with the thinking behind LD 585 that goods and services that these businesses purchase would be exempt from state sales tax. As some of you may be aware, it can be difficult for us to get land into trust because of federal red tape and because of limitations imposed under the Settlement Act. This amendment would allow us to enjoy tax benefit on lands where goods and services are frequently delivered, even if the lands are owned in fee and the tribe hasn't been able to put them into trust yet, such as Moose River. Lastly, we are advocating for an amendment that would create a sales tax exemption for purchases of manufactured homes by tribal members to be installed on tribal lands. This amendment would make clear that a manufactured home is subject to the tribal member exemption that LD 585 created. It would also clarify that the tax exemption applies even if a contractor or subcontractor purchased the manufactured home before the tribal member does. The idea here is to leave no question that these sales are exempt from the tax. The folks that are living in manufactured homes are more often than not facing some degree of economic hardship and may not have the means to get legal counsel or other assistance to contest the tax if they get a bill in the mail. In sum, at this time, we're advocating for a narrow set of simple amendments that expand or in one case clarify the tax exemptions provided in LD 585. Ultimately, our goal is to deliver an amendment to the committee in time for the work session on LD 585. So for now, we'll continue to do as we have, and we'll continue to engage with both sides of the aisle and with the governor's office on Wabanaki sovereignty legislation. There's a lot of good momentum right now, and we want to see that keep up. The amendments that I discussed today will maintain that momentum, foster collaboration between the state and the Wabanaki nations, and allow us to keep making progress together. With that, I conclude my comments. Willie One, thank you.
Thank you very much, Chief Nicholas. Are you open to having questions from the committee at this time? Committee members, are there any questions for Chief Nicholas? Seeing none, thank you.
Thank you.
Would the next Wabanaki leader who wishes to speak, please step forward?
Willis Buzzaway, good morning. Senator Carnes, Representative Kuhn, and distinguished members of this Judiciary Committee. My name is Craig Sanborn. I am in-house legal counsel for the Mi'kmaq Nation, and I have been sent by the chief and the tribal council to speak with you today. Chief McCormick offers her apologies. She had a longstanding appointment that prevents her from being here today. I've listened to the testimony of the chiefs that have preceded me, and they have hit a lot of the items that I wanted to look at, but there were a couple that I wanted to highlight that is personal to the Mi'kmaq Nation. With this bill before you, 395, we're talking about federal beneficiary acts being held applicable to the native tribes of Maine. So historically, or the federal Indian policy towards the tribes has changed multiple times. It's gone from eras of termination to eras of self-determination. And that's where we currently are. And so all of these bills that they have talked about were designed to help strengthen tribal independence and self-determination. Currently, it could be argued that Maine's Indian policy lags behind the federal Indian policy. And so what we have always been trying to do these last few years is to bring parity to the two policies. But we recognize that just like federal Indian policy has taken multiple years, decades, to arrive to the position that it is now, that is probably where we are going to be with the state of Maine as well, with Indian policy. We want to celebrate our past collaborative efforts with the administration in this legislative leadership. Senator Robert Toss, we really appreciate all of the efforts that you have done to try to bring parity to the two different policy intents. We've worked closely with the governor's office, and we have made tremendous progress in this last couple of years. One of the most important for the Mi'kmaq Nation is the Restoration Act. And so we have been trying to work with the administration of the state of Maine for close to 20 years to deal with our jurisdictional miss. And up until working with the current governor and her council, that door has been closed for us. But it has since been opened, and we're able to pass that legislation. We are looking for that same type of collaborative effort in this legislative session. We understand that the session is abbreviated and that there is not a lot of time, and that these issues are complicated and far-ranging. And so we have chosen to celebrate that, again, that collaborative effort of working together to try to come to some resolution on some issues, maybe not all of the issues, in order to move the ball forward for the next generation. I thank the governor for her help with us. So with this particular act, I think that everybody has pretty much spoken to the issues of 395. For 785, there is one other change that might be unique in the request for the Mi'kmaq Nation. And that is, we have, as a result of the Restoration Act, we have been able to establish jurisdiction for our judicial system. And to that end, we have created a tribal court. We have purchased land that abuts our property in Presque Isle, Maine. And we are in the process of converting that land into trust land. But you should understand that that fee to trust process is arduous through no fault of the tribal nations. It is the federal government, the land in the trust often takes 5 or more years to complete. In the meantime, our court, we are finding, is being subjected to property tax. And while that amount for some people might not be a lot, for us, it's fairly significant, especially if we're looking at that occurring over the course of the next 5 years. And the idea that our judicial center would potentially be subject to, forfeiture, liens, I don't really foresee that happening, but the idea that that exists is a little bit frightening to us. So what we did was we looked at the exemptions, the current exemptions at 36, Title 36, Section 351. There are exemptions under that provision for property held by the United States government, that is exempt. Property held by the state of Maine, that is exempt. And there is another provision of a quasi-municipality corporation is also exempt. We ask that the tribal nations be added to that. And we're making our exception more limited. And I think that would be easier for you. So what we're looking for is if we purchase land that abuts our property, for governmental services only. So we're not looking for for-profit properties. We're looking to focus on properties that is providing essential governmental services, whether it be our courthouse or housing for our low-income families. That would be a very simple fix. We have been working together collaboratively with the governor's office, and we think that we are able to come up with an agreement that will require your review and your vote, and we ask that you do that. Thank you for your time, and if there are any questions, I would be happy to answer them.
Thank you very much, Attorney Sanford.
Thank you.
Are there questions, committee members? I'm not seeing any. Thank you. At this time, I'd like to recognize Chief Francis, who is joining us remotely. He will appear in just a moment on the screens in the committee room.
Good morning, Senator. Can you hear me?
Yes, we can hear you. Thank you for the honor of your attendance today remotely. We're happy to see you.
Well, well, first of all, good morning, Senator Carney. Good morning, Representative Kuhn, members of the committee. Kirk Francis, I am the tribal chief at Penobscot Nation, and I'm obviously not there today, but I am in full support of LD 395 and would like to testify on that bill. And I do apologize for my lack of attendance. I figure even as much friends as we've become over the past few years, I don't think you'd appreciate me sharing what I'm dealing with right now in those close quarters. So as members of the committee have learned, the relationship between the Wabanaki Nations and the state of Maine is governed by complicated federal and state law jurisdictional systems that were put in place around 1980 by the federal government. This includes the Federal Maine Indian Land Claim Settlement Act, which approved the state law implementing the federal act. This settlement scheme was originally intended by the tribes to primarily address the questionable acquisitions of our lands. But the final product has become known as one of the most archaic and restrictive settlement schemes in the country with respect to tribal nations. For the past decade, the Wabanaki Nations have been working with the state legislature, our allies, to eliminate the restrictions on our inherent sovereignty that were put in place by these settlement acts. We have made some incremental progress, and we are hoping to continue to make more progress. LD 395 attempts to address the application of two provisions in the Federal Settlement Act, Section 6H and 16B. 6H of the federal law is a provision that restricts the application of federal laws beneficial to Indians that were enacted before 1980 from applying within Maine if they affect or preempt state jurisdiction. Section 16B is a provision intended to restrict federal laws enacted for the benefit of Indians after 1980 from applying, unless the federal law expressly indicates that it is applicable in Maine. These restrictions have caused all sorts of confusion and ambiguity among the Wabanaki nations and others, including federal agency, about which federal laws apply to the tribes in Maine. No other federally recognized tribes are subject to such sweeping exclusion from federal Indian laws. These restrictions are also contrary to the long-standing policy of Indian self-determination and self-governance. The overall problem is really twofold. There are no time restrictions on when the state can object or indicate that it believes its jurisdiction is being impacted. And two, there is no requirement or process for evaluating whether the state's objections are reasonable. The Penobscot Nation has encountered several situations over the years where the state has objected to the application of federal laws focusing on improving our health and public safety. The language of LD 395 attempts to shift the burden from the Wabanaki nations having to obtain inclusion of language, expressly covering us in federal laws, and puts the burden on the state to advocate to Congress for language to expressly exclude application of federal Indian law in Maine. LD 395 does this by attempting to render Sections 6H and 16B of the Federal Settlement Act inoperable by enacting state law that affirmatively provides, as a matter of state policy, that federal laws enacted for the benefit of Indian country do not affect or preempt the laws of the state of Maine. We know there are concerns about the scope of federal laws that would apply to the Wabanaki nations in Maine. For the past few legislative sessions, this committee has heard testimony about concerns primarily involving the applicability of federal gaming laws and environmental laws. To address these concerns, the tribes work together with stakeholders, and LD 395 contains language that says Wabanaki nations will continue to be subject to the same regime under gaming laws, and certain federal environmental laws are expressly exempt from this legislation. Full application of all federal beneficial laws to the Wabanaki Nation is a priority for the Penobscot. It is the one thing that we would like to see progress on with respect to eliminating restrictions on our inherent sovereignty. We have been dialoguing with the governor's office and other Wabanaki nations about the language of LD 395 since November, and I've appreciated that process. And we are attempting to come up with some language that will allow progress to happen in this short legislative session. And if we cannot come up with a mutually agreeable language, then maybe it makes more sense to just wait. But at the end of the day, we felt this hearing was important on this issue to continue to create a high-level record and to focus on meaningful progress as we move forward. We appreciate this committee holding a hearing on this important bill. We have appreciated the bill sponsor, Senator Talbot Ross, for continuing to lead this effort. And we appreciate the Wabanaki Alliance and all our allies that show up, express support, and continue to build the foundation of which we will eventually obtain full restoration and recognition of our sovereignty. The process, I will say, over the past few years has been extremely collaborative. In the past 8 months, I've really appreciated the engagement of the governor's office, the attorney general, this committee, the leaders of this committee, and of course, Senator Ross and others. Obviously, my fellow tribal leaders as well. Everybody's working hard to find solutions, and I've really appreciated that process, especially coming from a mindset of this is not about us getting granted anything or given anything. The mindset really has been about the tribes of Maine are sovereign by fact. And what we're really trying to accomplish here is a legal framework that recognizes that and provides accessibility to it for the health and benefit of tribal nations in this state. And I will just close by saying, I also want to send my heartfelt condolences to the committee and to the entire legislative community. I was sad to hear the loss of our friend Jeff Evangelos, who was a real champion in this issue, and I considered him a friend. So I was sorry to hear of his passing. And with that, thank you, Senator. Thank you, Representative Kuhn. And I'm happy to answer any questions.
Thank you very much, Chief Francis. Committee members, are there any questions? Seeing none, thank you for speaking with us today. Are there other tribal leaders who wish to step forward and address the committee at this time? Welcome.
Oh, Quay, Nearly with C. Croft McDonald, Willow Neil, New Jow, Maduxanagiak. Everyone, my name is Z. Croft McDonald. I'm a Willow person from Holton Band and Mousie Indians. Senator Carney, Representative Kuhn, and members of the Judiciary Committee, thank you for the opportunity to speak, and thank you to the tribal leadership and Senator Talbot Ross as well. I currently serve as the tribal ambassador for the Holton Band and Mouseets. I present this testimony today in support of LD 395. Since 1980 and the passage of the Maine Indian Claims Settlement Act, the Wabanaki nations have not had access to federal beneficial laws passed for the benefit of the rest of Indian country across the nation. As I'm sure you are aware, and as Chief Francis just explained very well, there was some subtlety in the wording of this restriction. Technically, we do have access to these laws if they are intentionally written to include us or the state legislature votes to allow us this access. This has had the same effect, however. All tribal nations work with many organizations to bring opportunities to our people and our communities, and without assurance that we have access to these laws, there will always remain fear that access might be limited or taken away should the state choose to do so. The primary way we have overcome this in the past, the only way we can overcome this limitation, is through an expensive process of lobbying the state to allow us access and expend funds which we do not have. I hope you will consider changing the wording of this law and urge you to vote to pass on LD 395. Leewin.
Thank you very much, Ambassador McDonald. Any questions, committee members? Seeing none, thank you. Are there additional tribal leaders who wish to address the committee at this time? Seeing none, thank you very much for doing us the honor of presenting to the committee today. At this time, we will hear from members of the public who wish to speak in support of LD 395. Would the first member of the public who wishes to speak in support, please step forward. Welcome.
Hello. Good morning, Senator Carney, Representative Kuhn, and members of the committee. I'm Molly Bryant. I'm a Penobscot Nation tribal citizen, and I'm the Executive Director of the Wabanaki Alliance. I present this testimony today on behalf of the Wabanaki Alliance in support of LD 395. We extend our gratitude to tribal leadership for their guidance and strength, and we deeply appreciate the bill sponsor, Senator Talbot Ross. Tireless was a word that was used, and I had the same word. Tireless advocacy for Wabanaki rights and self-determination. The Wabanaki Alliance was formed in 2020 by tribal leadership from all of our tribal nations. We educate about the need for securing sovereignty for our people. In 5 short years, we have built a network of support all across our homelands now called Maine. We have worked to build trusting relationships with lawmakers. We have advocated for policies that enhance tribal sovereignty and empower not just our communities, but the rural communities around our tribal nations. Today, I stand here with the support of over 335 businesses and organizations who believe in tribal sovereignty. We have such tremendous allies, and we all have made really great progress. This bill for access to federal laws beneficial to Wabanaki nations corrects an inequity in the Settlement Act from 1980. Currently, the tribes in Maine, as you have heard, cannot reliably access these acts. This bill is about fairness. Since 1980, there have been roughly 150 laws that have provisions for the benefit of federally recognized tribes. The blocking of Wabanaki people from accessing those federal beneficial acts has cast a long shadow of inequity. Federal recognition was achieved by the Wabanaki nations, and we seek the same rights as the other 570 federally recognized tribes. By setting up a system by which the state can decide which laws the tribes can have access to, we are left with less rights, less freedoms, and less success than other tribes across the nation. We worked hard a few years back to ensure inclusion in the federal version of the reauthorization of the Violence Against Women Act. And the state of Maine, as a lot of you know, passed its own version in 2019. This success was the result of really great collaboration with lawmakers, advocacy from tribal leaders, and engagement with legal scholars. It also took a very long time. We envision a future in Maine where the tribes have access to this important body of law, just like other tribes in the country, without having to work years to make each law accessible. I thank you very much for your time today, and I'm happy to answer any questions.
Thank you very much. Committee members, are there any questions? Seeing none, thank you.
Good to see you. Thank you.
We'll now recognize Jerry Reed from the Office of the Governor. Welcome.
Thank you. Good morning, Senator Carney, Representative Kuhn, members of the Judiciary Committee. I'm Jerry Reed. I'm counsel to Governor Mills, and it's a pleasure for me to be here this morning to offer remarks in support of LD 395. I'd like to start by, as others have, recognizing Senator Talbot Ross and her efforts on this bill and on these and other issues like it over the years. Her leadership is commendable and much appreciated. And I want to also recognize the kindness that she has shown me and the trust that she's extended to me as I've tried to do my part to make progress on these issues. It means a lot to me. And I'd also like to recognize the remarks that were offered by the tribal leaders, those who spoke and those who couldn't speak today, and the goodwill and the kindness that they have shown to me and to Governor Mills as we've worked together on these issues. Chief Nicholas and Chief Bassett, Chief Francis, Chief McCormick, Chief Sabatis, former Representative Rena Newell, Aaron Dana, they've all in their own ways at different times extended themselves to me and to the governor. And I want to recognize that because it's very much appreciated. On the substance of the bill, I'm pleased to be able to testify in support, in strong support of the goal of the bill, which, as you've heard, is to put into place a legal mechanism that ensures that the Wabanaki nations and their members receive the same benefits from federal laws as their counterparts across the country, other federally recognized tribes and tribal nations. The policy goal has never been in dispute. It's never been in controversy, and it shouldn't be. It's very straightforward. What's proven tricky for those of us who have worked on these issues is trying to find the right mechanism to do that and to reduce it to words. And that has continued to prove tricky. And we do have concerns with the mechanism that is incorporated into LD 395 as drafted. But as you've heard, we are actively engaged in discussions with my counterparts, the attorneys who represent the Wabanaki nations. And those conversations are constructive and respectful, and I feel like we're making progress. This is a very challenging drafting issue. It's not merely a matter of policy. It's not merely a matter of law. It goes beyond that. and I understand the significance of it. And so we are determined to continue to work on this and to continue to make progress. And whether we can come to a final agreement in time to present something to this committee at a work session remains to be seen. Regardless, we're going to keep at it. And we're determined to work at it in good faith until we can come to some resolution. That's all I had to say this morning. I'm happy to answer any questions you may have. Obviously, I'll be available at the work session.
Thank you. Are there questions, committee members? Representative Henderson.
Yes, thank you, Madam Chair, and good morning, Attorney Green.
morning.
It's good to see you. I'm optimistic, not only of the remarks of the tribal leaders, but optimistic from the remarks from the governor that there seems to be real interest in collaborating. You were bound by a 3-minute timer. Are you able to elaborate where exactly you are in conversations and what kind of major
Sure.
hangup is? And so where you are in conversations, what the major hangup is, and then finally the progress that you've made up to this point.
Sure, I'll try to do my best, and I'm going to try to also avoid getting drawn into the details of the challenge, because as we all know on this committee, we could easily talk about that for hours, and we have. But generally speaking, we have been discussing this as a larger group, the full group of tribal attorneys and me, occasionally with representatives from the Attorney General's office. And more recently, I have been working directly with counsel for the Holton Band of Maliseet Indians, who I think has informally taken kind of a leadership role among the tribal group on this issue. And we have been having calls devoted to it, and we have exchanged written proposals that represent a kind of conceptual framework for how we might achieve the policy goal that we all are committed to. And we've commented on those written proposals. That dialogue is continuing. I don't really, out of respect for the back and forth, I don't want to get into the specifics of it. But I just want to acknowledge again that it's a very constructive dialogue. And I appreciate that. And I don't want to say or do anything that would in any way interfere with continued progress on that.
Are there any other questions, committee members? No. Seeing none, thank you.
Thank you.
The next person in the committee room who wishes to speak in support of this legislation, please step forward. Welcome.
Senator Carney, Representative Kuhn, and esteemed members of the Legislative Judiciary Committee. My name is Troy Jackson. It is great to be here with all of you today to testify in support of LD 395 and, if possible, LD 785, two measures that I believe are long overdue. And I want to thank Senator Talbot Ross for bringing these measures forward, along with a whole bunch of other things in the past. As it's been said, she's been a great stalwart for these issues. I would also like to bring up former Senator Mike Carpenter and Senator Donner Bailey, who had the foresight to bring forward this a long time ago also. As you know, I've had the honor of serving as the president of the Maine Senate, representing the good people of Aroostook County for more than 2 decades in the legislature. This includes representing members of the Aroostook Band of the Mi'kmaq. I've also had the privilege of working alongside and learning from leaders of the Wabanaki tribes as a presiding officer. For too long, the state's leadership with the Wabanaki nations has amounted to nothing more than symbolic gestures and empty promises, and this is in the best of times. For much longer, the state's relationship with the Wabanaki Nation was far worse, and in recent years, the legislature has made great strides in repairing the fraught relationships between our governments. The legislature set up a commission to examine the 1980 Maine Indian Claim Settlement Act and convened for a joint convention of the Maine legislature to hear the chiefs of the Holton Band of Maliseet Indians, Mi'kmaq Nation, the Penobscot Nation, the Passamaquoddy tribe, which Senator Talbot Ross put together, We also passed laws to support economic development, improve access to clean drinking water, recognize the exclusive jurisdiction of tribal courts, and enshrine protections of the Wabanaki children and their families into state law. Yet, I believe we've still fallen short of what we owe our Indigenous neighbors when it comes to respecting tribal sovereignty and self-determination. That is something that I carry with me even as my time in the legislature came to a close. And I believe the time has come and passed for us to rectify our laws and honor the inherent sovereignty of the Wabanaki nations. It is a time for the Wabanaki people to receive the benefits they deserve, the same benefits that the other 570 federally recognized tribes receive. It's time to pass these two bills. And I think today I heard in the testimony, people that were very passionate. Certainly Chief Sabatis, it kind of broke my heart. It's funny to me that you hear people talk about how this is a tough issue, but every other state in the nation has figured it out. But here we are in Maine, in a state that can't figure it out. But our motto, and I'm a proud Mainer that wears the seal that Dirigo, we lead, I lead. But here in Maine, we can't figure this out. We can't lead on an issue that should be so easy that every other state has figured out. And, when I looked it up this morning, maybe we ought to change our motto. We could use Latin term trepidare, which means to cower, shake in fear, or sequacious, which means to follow blindly. Because this is something that I think we should be able to do. And I hope that this committee once again can do it because they deserve it. They've been waiting for a long time for it. And I hope this committee can pull it together and do it.
Thank you for your testimony.
Thank you.
Committee members, are there questions? Go ahead, Representative Henderson.
Thank you, Madam Chair. I have a few.
Sure.
First, did you ever serve on judiciary and do you owe it to?
No,
Okay.
I didn't.
All right. I always ask former legislators. Second, were you here when Chief Nicholas gave his testimony, and he, some of his proposed amendments or hopes that we would add in would be to extend the income tax exemption to tribal members? Would that be something that you would support?
If that's what the tribes want, I'd be very supportive. But in the end, I think that having full tribal sovereignty is the goal, and I would hope that this administration would finally do that.
And then in the same attempt to create parity between the tribes and the state, is a full income tax exemption also something that you would support for all Mainers?
I don't believe that's what tribal sovereignty means, is full income tax, and I'm not supporting that.
Thank you.
Yeah.
Any other questions, committee members? Thank you so
Thank
much.
you very much. Appreciate it.
Presentation. Others who wish to speak in support of this legislation, please step forward.
Good morning, members of the committee. Thank you. My name is Tom Keefe. I'm a retired college professor, associate professor of human rights, and I have a specific interest in Indigenous rights, and I've written prolifically about it. I wanted to briefly touch on a couple of issues from a slightly different perspective. When I used to teach high school and then when I taught college, one of the things we talk about all the time is Article 1, Section 8. It's clear, like we've heard this morning, discussion of like the actual implementing mechanisms through legislation. But when we look at this from a 50,000 foot level, it can't be more clear. Article 1, Section 8 creates tribal sovereignty. And so what we have right now in Maine is an impediment to the constitutional rights that have already been given. Right. What has been discussed earlier was that the Indigenous tribes are not asking for something. They're asking for equality before the law. They're asking for something that, frankly, they shouldn't have to ask for. And when we look at the historical wrongs that have been done 400 years ago, 200 years ago, or even a couple of decades ago, as well-intentioned as Judge Mitchell, former Senator Mitchell's committee worked on, it's still a reduction of rights. It's a harm. So when we look at fairness and equality before the law, as has been said before, Indigenous people and Indigenous organizations in Maine have less rights than other Indigenous people throughout the country. That's not right. And I guess I would use, I very intentionally would use the word disenfranchisement, and because again, that's an act, that's a choice that has disenfranchised versus a positive, proactive enfranchisement. I'll end with just this comment. I think there's not only a legal, but a moral imperative for these two bills. Thank you.
Thank you very much for your testimony. Committee members, are there any questions? Seeing none, thank you. The next person who wishes to speak in support, please step forward.
Senator, thank you, Senator Carney, Representative Kuhn, distinguished members of the committee, Wabanaki chiefs and leaders. Good morning. My name is Michael Cabeda, and I'm Policy Director of the American Civil Liberties Union of Maine. On behalf of our members, I urge you to support this bill. Of the more than 570 federally recognized tribes in the United States, as you've heard, the Wabanaki are the only ones who must be written into each federal law to benefit from it. You've heard of the self-determination era. That started roughly in the late 60s with the American Indian movement, and in Maine culminated with the land claim settlement. The self-determination era has been an era of tremendous economic development for Indian country. As Chief Sabatis said, the Maine Implementing Act and the Land Claim Settlement Act have left Wabanaki nations out of the era of self-determination. That has amounted to economic underdevelopment, not just for Wabanaki nations, but for neighboring communities. To not pass this bill amounts to the economic equivalent of cutting off your nose to spite your face. That's what Maine has been doing for over 40 years. Now, this is a time when our rural healthcare infrastructure, our rural housing infrastructure, and other dimensions of our rural economy are crumbling. It's for that reason that this legislature should wholeheartedly support this bill. A future of shared prosperity. That's the promise of LD 395. The nationwide trend of enhancing tribal sovereignty hasn't just come from the federal government. For the last 25 years, various states throughout the United States have changed their policies quite radically. For example, in Alaska in 1988, the state Supreme Court held that Native villages are not self-governing or in any meaningful sense sovereign. Then 11 years later, the same court in 1999 held that Native villages in the state possess inherent powers of self-government. This bill and the bill scheduled for 1 p.m. today would give Maine a chance to similarly transform its relationship to Wabanaki nations. I urge you all to vote ought to pass, and I'm happy to try to answer any questions.
Many thanks for your testimony. Committee members, are there any questions? Seeing none, thank you.
Thank you.
The next member of the public who wishes to speak in support, please step forward. Welcome.
Thank you. I'm a little nervous here.
Senator Carney, Representative Kuhn, and members of the Judiciary Committee, my name is Sandy McCrae Duchesne, and I live in Hudson. I'm testifying today in support of LD 395, a bill that will allow the Wabanaki nations to benefit henceforth from all federal legislation that applies to nearly 600 recognized tribes in every other state. I view this as a matter of basic fairness. The original residents of the place we now call Maine have been ill-served and economically disadvantaged for nearly 50 years due to Maine's failed policy of treating tribal governments like municipalities rather than sovereign nations. We can't go back in time to right the many wrongs of the past, but we can take action in the present to pass new and better legislation that creates a more even playing field and allows the Wabanaki nations to thrive along with all other federally recognized tribes. When Maine's tribal governments are finally allowed to access federal funds and resources allocated by Congress to improve basic living standards and economic growth opportunities on tribal reservations and lands, new capital investment and higher incomes will create a ripple effect in the local economy, benefiting both native and non-native residents of surrounding communities. As the old saying goes, a rising tide raises all ships. I'm gratified, but I'm not surprised to note that this bill has bipartisan sponsorship. We all understand that basic human principles that we all learned in childhood, like fair play and the importance of keeping one's promises, transcend party lines. The 1980 Compact was originally signed in hopes of starting a more robust discussion of tribal-state relationships between equal partners. Instead, it has been manipulated by state government officials to keep the Wabanaki nations frozen in time and deprived of important resources they could leverage to benefit both Indigenous communities and their rural neighbors. Please take a meaningful step into the future by correcting an old, painful, and expensive mistake and vote in favor of LD 395. Let's return all of Maine to the way life should be. Thank you.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you. Would the next member of the public who wishes to speak in support please step forward?
Senator Carney, Representative Kuhn, members of the committee, and to all those gathered here today, I'm Emily Vale from Brunswick. Just a year ago, I didn't know anything about the fraught issue of tribal sovereignty, and if I had, I wouldn't have felt a personal stake in the matter. But that all changed last summer when I spent several days on Indian Island with other educators learning about Wabanaki culture, history, and survivance. Nothing in my 20 years of teaching has impacted me so profoundly as those days on the Penobscot Reservation. The experience was both gutting and galvanizing. I didn't realize how much we as a society and as individuals have suffered for being disconnected from Indigenous wisdom and ways. We have lost the sense of being in right relation with the earth, with each other, and with ourselves. That loss degrades the lives of all Americans. And once we know better, we have to do better. Although it may seem I have no immediate stake in this legislation, I know now that all Mainers stand to benefit from improving relations with our Wabanaki neighbors. Passage of LD 395 and 785 would be significant steps toward repairing past wrongs and achieving fairness and equity so long denied. This is unequivocally the right thing to do for so many reasons. To name just a few, Harvard researchers project that restoring full rights of sovereignty to the Wabanaki would be an economic boon not only to the tribes, but to the surrounding rural areas as well. And this would also mitigate the crushing effects of child poverty in Wabanaki communities, which only perpetuates the generational trauma and state-sponsored abuse of Indigenous children throughout our history. Finally, please, we need to acknowledge the Wabanaki's expertise in stewarding the land and natural resources. They know better than we do how to protect our woods and waters, so the more opportunities they have to guide us back into right relation with the natural world, the better for all. So, amidst the patriotic fanfare this year, I believe the best way we in Maine could mark the 250th anniversary of these United States is by making good on broken promises to those who have truly cherished this land and fought for this country from the beginning. So please, vote yes on LD 395. Thank you.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you. The next person who wishes to speak in support, please step forward. And if you are a member of the public and you've already provided your testimony, if you wouldn't mind leaving the committee room to make room for those who have yet to testify, and also there's a couple people standing who need seats. Thank you. Welcome.
Senator Carney, Representative Kuhn, and members of the committee, my name is Anthony Irwin, and I am Maine Audubon's policy advocate. Since 1843, Maine Audubon has worked to conserve Maine wildlife and wildlife habitat by engaging people in education, conservation, and action. On behalf of Maine Audubon and our 30,000 members, supporters, and volunteers, we thank you for the opportunity to submit testimony in support of LD 395. Wabanaki people have lived in this place we now call Maine for millennia, with an understanding of and a connection to natural resources far deeper than ours today. Their stewardship was interrupted by the colonization of these lands, which resulted in the Wabanaki nations losing 98% of their population and access to most of the lands, waters, and wildlife that they have lived in relationship with for thousands of years. Signed in 1980, the Maine Indian Claims Settlement Act has kept the Wabanaki Nation from benefiting from more than 150 federal laws, including laws that would help foster job creation, economic development, healthcare access, and environmental protection. It is past time to help restore the inherent power and rights of the Wabanaki Nations to make decisions that affect their lands, waters, and communities. LD 395 would help accomplish that. LD 395 would modernize the Maine Indian Claims Act and the Mi'kmaq Settlement Act so that the Wabanaki Nations can benefit from existing and future federal laws that apply to the other 570 federally recognized tribes in the United States. Importantly, this would include both the Clean Water Act and the Clean Air Act, allowing the Wabanaki Nations to finally assume primary regulatory authority for federal environmental programs on their lands. Above all else, Maine Audubon strives to engage people in the conservation of wildlife and wildlife habitat. We feel that the ability to engage in this important work is significantly weakened if people are disempowered, marginalized, and disenfranchised. Maine Audubon supports LD 395 because it protects and improves the relationship the Wabanaki Nations have with their lands, waters, and wildlife. We strongly encourage this committee to vote in support of this crucially important bill. Thank you.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you. Would the next person who wishes to speak in support, please step forward.
Good morning, Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Carmela Bear. I'm a member of the Penobscot Nation and a first-year political science student at the University of Maine, Orono. I am here today to testify in support of LD 395. Within my community, I participate in an organization called the Penobscot Nation Youth Council. Through PNYC, I have been able to attend conferences around the country from San Diego, California, Washington, D.C., and Portland, Oregon, with plans to go to Oklahoma City this coming July. At each and every one of these conferences, there has been something I've had to explain to other Indigenous youth. Tribes in Maine are different from theirs. Different in the way that there have been over 100 legislative acts that my community and other tribal communities in Maine have been denied access to. During a conversation about climate change at a tribal youth gathering in Washington, D.C., I have had to explain to my peers at the table that the Penobscot Nation has no control over the Penobscot River. I had to recount the ambiguities in the Settlement Act of 1980 that allowed the access of that allowed the state of Maine to revoke the tribe's right to protect the water. Furthermore, because of the lack of access to federal Indian law, retention of our rights and sovereignty is even more fragile. This was incredibly confusing to many of the people sitting with me as they could not understand why something that had been implemented in their states for years would not be extended to tribes in Maine. Having to explain the years of legislation Indigenous communities in Maine have been excluded from to Indigenous peers not from Maine is always challenging. How could something that has been proven to work for 570 other tribes across 34 states not be something that could work for tribes in Maine? When discussing solutions to problems we see across Indigenous communities, conversations often become a continuous cycle of, well, can't Wabanaki tribes do this? And no, we aren't included in that legislation. Alongside the non-Mainer Indigenous youth, I cannot fathom that Maine tribes do not have access to these protections and opportunities. There are over 500 tribes in this country that are examples that this legislation helps tribal communities. Wabanaki tribes deserve to have access to federal Indian law. I implore you as a Penobscot youth to vote to pass this bill. Thank you for your time. Everyone.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you. Thank you. The next person who wishes to speak, please step forward.
Welcome. Thank you. Senator Carney, Representative Kuhn, and honorable members of the Joint Standing Committee on Judiciary. My name is Shirley Hager, and in testifying in support of LD 395, I speak on behalf of the Committee on Tribal State Relations of the Friends, also known as Quaker, Committee on Maine Public Policy. We're a statewide advocacy group. For over 30 years, one of our primary goals has been to support a right and just relationship between the state of Maine and our Wabanaki neighbors. You have heard already that LD 395 would enable the Wabanaki tribes in what we now call Maine to access certain federal laws benefiting tribes. And you've heard how clear access to these laws have been denied the Wabanaki unless each tribe can manage to get their tribe into the law, which has proven to be a near impossible feat to achieve over the years. The Suffolk University report from 2019 that found that the Wabanaki had missed out on the benefits of over 150 laws intended for health, safety, and self-determination, that these same bills that the Wabanaki missed out on have resulted in other states achieving an over 60% growth in per capita income, while the Wabanaki tribes achieved only a 9% growth in the same period. That was according to a recent Harvard study. Notably, these bills in creating access to federal resources would also have brought economic and social benefits to the rural areas surrounding existing tribal communities. Health, safety, prosperity, self-determination, a hopeful future for our children. Aren't these the goals that we all strive for? Yet here in Maine, we have laws that systematically and systemically place obstacles in the paths of our Wabanaki neighbors, preventing them from pursuing these goals for themselves. Surely, we have reached a point in the state where our collective conscience cannot allow this egregious situation to continue. The Tribal State Relations Committee of the Friends Committee on Maine Public Policy strongly urges you to unanimously vote ought to pass on LD 395. Let us remove one more obstacle to a sustainable, more prosperous future for our Wabanaki neighbors and for us all. Thank you.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you. Next member of the public, please step forward. Welcome.
Thank you. Senator Carney, Representative Kuhn, and members of the Committee on Judiciary. My name is Maddie DeVarney, and I'm a student at College of the Atlantic living in Bar Harbor. I'm testifying in support of LD 395. Before moving to Maine, I lived in the heart of Indian country, Tulsa, Oklahoma. I witnessed history being made there just 5 years ago following the monumental McGirt decision. I can only hope to see a similar precedent established here today, a long-awaited restoration of rights. Oklahoma Governor Kevin Stitt perpetuated the fiction that sovereignty would disrupt civil and criminal affairs throughout the state, warned of the destruction that would ensue, claimed that the decision would bankrupt the tribes. This has proved to be erroneous. These same tactics of fear-mongering have been used for years to oppose tribal sovereignty in Maine. Despite Governor Janet Mills' words, the provisions of this proposed bill do not threaten to further divide the state and people. In fact, it's quite the opposite. Support for sovereignty has been notably bipartisan. The last iteration of this bill generated a record number of testimonials in support. This act is about reconciliation, restoration, redress, and revitalization. Tribal governments are the oldest sovereigns on the continent. The diminution of their inherent sovereignty to that of a municipality is unjust. I urge you to support LD 395. Thank you for your time and consideration of my testimony.
Thank you very much for your testimony. I see that there are some committee questions. Go ahead, Representative Pugh.
So more just a comment. I was going to ask you what your major is because I also went to College of the Atlantic. Thank you for being here.
My major is human ecology with a focus in tribal and environmental law.
Additional questions, committee members? Seeing none, thank you.
Thank you.
The next member of the public who wishes to speak, please step forward. Welcome.
Thank you. Chairs Carney and Kuhn, members of the Judiciary Committee. My name is Graham Plattner. I'm an oyster farmer from Sullivan and a candidate for United States Senate. I am here in solidarity with the Wabanaki Nations to testify in strong support of LD 395 and LD 785, both sponsored by Senator Rachel Talbot Ross. Thank you, Senator, for your work on this. Since the passage of the Maine Indian Settlements Claim Act 46 years ago, Maine tribes have been denied the sovereign rights afforded to the other 570 federally recognized tribes in the United States. A study published in December of 2022 details the harms of the Settlement Act to the Wabanaki Nations. Quote, unique to Maine, the Federal Maine Indian Settlement Claims Act of 1980 empowers the state government to block the applicability of federal Indian policy in Maine. As a result, the development of the Wabanaki Nation's economies and governmental capacities have been stunted. Today, all 4 of the tribes in Maine are stark economic underperformers relative to the other tribes in the lower 48 states. According to the Wabanaki Alliance, since 1989, tribal income outside of Maine has grown by 61%. Wabanaki income has grown by only 9%. Child poverty in Wabanaki communities is 3 to 5 times higher than the rest of the state. These are children, families, and communities who bear the brunt of an injustice perpetrated in 1980 by Maine state government and perpetuated today by a powerful few, including the governor, who has fought against tribal self-determination her entire career. Maine tribes are demanding respect, fairness, and meaningful self-determination. Marginal changes to state programs are not enough. Structural injustices demand structural remedies. If tribal rights can be altered at the whim of the state, they can hardly be characterized as rights at all. Anything short of sovereignty is subjugation. We must pass LD 785. We must also pass LD 395 to grant Maine's tribes access to federal beneficial laws that apply to all other federally recognized tribes. If elected to the United States Senate, I will strongly support federal legislation to provide the same. I look forward to working with many of the Maine legislators who have championed this effort. The United States is about to turn 250 years old. Our nation's history is defined by a tension between what it is and what it claims to be. This tension is glaringly clear in our shameful history of oppressing Native peoples while espousing principles of liberty, justice, freedom, and equality. For the state of Maine to continue denying the Wabanaki Nations, who have called Maine home for millennia, their inherent sovereignty, political dignity, and self-determination is unconscionable. We have an opportunity to partially right the injustices of the past, and it is an opportunity we must take. I respectfully ask that you vote in favor of LD 395 and LD 785. Thank you.
Thank you for your testimony. Committee members, are there any questions? Yes, Representative.
Thank you, Madam Chair, and good afternoon, morning. It's still morning.
Yes,
Yeah.
whichever one it is.
I guess I'll ask you the same question that I asked of the Honorable Troy Jackson, and that is, were you here when Chief Nicholas gave his testimony on what he would like to see there be an amendment on this bill in providing a income tax exemption for the tribes? And if you weren't here, would that be some type of an amendment that you'd support?
I'm here to stand in solidarity with the Wabanaki tribes, not to speak for them. And so I really support whatever efforts are put forward by the tribes.
So if that was something that they wanted, that'd be something that you'd support. And in doing so, right, like a lot of this conversation has been, I mean, I've been doing this for a few years, has been about creating a type of equality between the state and the tribes. Would you also, in that same effort, support an income tax exemption for all Mainers, not just tribal members?
Again, like in this exact scenario, I'm here to speak on these bills and to speak in solidarity with the tribes. Whatever the tribes put forward as remedies to these injustices, I'm in support of that.
Okay, thanks.
Thanks.
Any other questions, committee members? Representative O'Halloran?
Do you have any limits on that?
What's that?
Are there any limits to anything that they could ask for as far as you're concerned?
I'll be entirely honest. I find it endlessly frustrating that the Maine state government forces leadership of the tribes to negotiate and scrape and fight for, frankly, their inherent rights. At this point, it would be difficult for me to put a limit on that. I think that what has been asked historically has been entirely reasonable, and I do not envision a future in which that changes. So,
Thank you.
thank you.
Any other questions, committee members?
Thank
Seeing
you.
none, thank you. The next person who wishes to speak in support, please step forward.
Good morning, Senator Carney, Representative Kuhn, distinguished members of the Judiciary Committee. Good morning, Senator Talbot Ross. I'm Eliza Townsend, Maine Conservation Policy Director for the Appalachian Mountain Club. AMC's mission is to foster the protection, enjoyment, and understanding of the outdoors. We have 6,200 members in Maine and own 127,000 acres of forest land in the 100-mile wilderness region of Piscataquis County, managed for multiple use, including sustainable forestry, backcountry recreation, and environmental education. We support LD 395. Due to the 1980 Maine Indian land claim settlement, the nations are unable to benefit from approximately 150 federal laws that apply to 570 other federally recognized tribes. The Maine Implementing Act made the status of the tribes akin to municipalities, and its congressional counterpart, the Maine Indian Claims Settlement Act, specifies that the Maine tribes are excluded from federal law if it affects the application of Maine law. This has left the Wabanaki at a distinct disadvantage, excluded from provisions of the Clean Water Act, Clean Air Act, and Violence Against Women Act, and unable to access federal funds for health programs, disaster response, or COVID-19 impacts, to name a few examples. No wonder then that the Wabanaki experience poverty at a rate more than twice that of Maine overall, 29% versus 14%. This is unacceptable. AMC recognizes that for the state as a whole to thrive, the Wabanaki people must thrive. We stand with the tribes in their pursuit of tribal sovereignty and the many benefits it will provide our Indigenous neighbors, our natural resources, and the state of Maine. We will urge you later today to support LD 785 for that reason. But because efforts to revise the 1980 settlement have failed to date, we support this more narrow bill as well. Your committee has the opportunity to address the wrongs included in the Maine Implementing Act. LD 395 would allow the Wabanaki tribes to benefit from any federal laws passed in the future that will apply to other federally recognized tribes. This is a reasonable and modest measure. While it will do nothing to address the opportunities lost in the past 46 years, including an estimated loss of $70 million in funding, it will set both the Wabanaki people and the state of Maine on a better path. We urge you to vote ought to pass.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you. The next person who wishes to speak in support, please step forward. Welcome.
Hi, Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Mac Thompson, and I am a citizen of Mi'kmaq Nation, and I'm here to testify in support of LD 395. I have learned that it is important not to dwell on what I have missed out on, but to dream of what is possible. As Wabanaki people, we live with the weight of the immeasurable traumas, but we prioritize dreaming of a future where we no longer have these worries and concerns. We look to the future to do what we can to preserve and protect our environment, cultures, languages, and people. Self-governance and respected sovereignty from the state can open opportunities for stronger relationships among the nations and the state. The things we are discussing here are not new. The technical concerns have been addressed and written out for you. I am asking you today to understand the burden that further inaction has on our Wabanaki nations and to recognize the work that has been done to get where we are today. From the tireless work of those who have been fighting long before me to protect our sovereignty, we have come so far as I stand here as a two-spirit Mi'kmaq citizen here in the State House that was built to silence my people. As we adapt, we must acknowledge the exclusion of Mi'kmaq Nation in previous legislation through federal recognition Though federal recognition was granted just before my lifetime, there continues to be exclusion as the Settlement Act has been neglected to be updated as a living document. I often hear the question asked, what would it be like if these bills were already passed, if our nation's sovereignty was respected by the state? I would like to hope there is a lifetime where we do not have to waste our time asking these questions, as our communities are already doing the admirable work to support one another, preserve our culture, and protect our lands. Today, with your support on LD 395, we move closer to a future where our elders can lift the weight from their shoulders to preserve our culture and pass this on to next generations, a future where our next generations can prioritize the joy of community. Thank you.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you. Next person who wishes to provide testimony in support, please step forward.
Good morning, Senator Carney, Representative Kuhn, and members of the Committee on Judiciary. My name is Kaya Lohler, and I am a citizen of the Bunawebskeg or Penobscot Nation, and I'm here today to testify in support of LD 395. During this session, I have the honor, alongside Sage Phillips, of coordinating the Wabanaki Policy Youth Initiative, a vast and growing group of Wabanaki and non-Wabanaki youth that are driven to see full sovereignty for the Wabanaki nations become a reality. A group of youth 14 to 25 that spend their evenings after work and school learning the ins and outs of the legislative system so that they can become better allies to their neighbors, stronger advocates for their people. They take the time to educate themselves, to show up and speak out, even on school vacation, and to build community across these homelands we now all share, so that their generation will not be ignored like so many were before them. As Wabanaki youth, we see the plaque on the third floor of this building honoring the Mayflower's expedition, the start of the genocide on Indigenous peoples. We see the slideshow screened on repeat in the Welcome Center downstairs, glazing over the contributions of our ancestors to this land and failing to recognize our people by name. And we know that this building, meant to uphold and protect the will of the people, wasn't meant for our people. Yet we show up anyway. Federally, we are recognized as sovereign nations, yet unlike any other Indigenous nation, the Wabanaki nations would each need to be explicitly written into federal laws in order for them to apply. Our welfare and governance are held in the hands of the state of Maine, where our two tribal representatives are non-voting members of the legislature. Maine was founded on the principle of leadership, but it has been surpassed by all other states when it comes to relationships with neighboring tribal nations. The youth of the Wabanaki Policy Youth Initiative are here today fighting for a level of sovereignty that should have been seen by their parents and their parents before that. The passage of LD 395 will address over 40 years of missed opportunities, and I strongly and respectfully urge this committee to vote ought to pass. Willie Winnie.
Thank you very much for your testimony. Committee members, are there any questions? Yes, Representative Lee.
Just wanted to thank you for sharing your school vacation with us and assure you that your voice is heard.
Thank you. I appreciate it.
Any additional questions, committee members? Seeing none, thank you. Next person who wishes to provide testimony, please step forward. Welcome.
Thank you. Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Sage Phillips, and I am a proud citizen of the Penobscot Nation. I am also co-leading the Wabanaki Policy Youth Initiative, a group of Wabanaki and non-Wabanaki youth who are passionate about advocacy, policy, and tribal state relations. I'm here with many of them to testify in support of LD 395, an act to restore access to federal laws beneficial to the Wabanaki nations. Over the last several years, I have personally had the opportunity to advocate for tribal rights on the national level alongside countless Native youth who are passionate about tribal policy. When I enter into these spaces as an advocate, I am reminded that my nation is not on equal footing as the Native nations in which my peers are enrolled in. When I explain why that is and introduce the 1980 Maine Indian Land Claims Settlement Act that bars our Wabanaki people from accessing federal laws, the room is oftentimes filled with shock and silence from young tribal citizens of Native nations outside of our homelands. In these spaces, I am surrounded by young people who do not know a world without their sovereignty and are shocked to learn that I do. The Wabanaki nations are the only federally recognized tribes in the nation that must explicitly be named in federal law in order for it to be applied directly to us. When my grandfather and elder, Butch Phillips, now ancestor, negotiated the Settlement Act on behalf of our people 45 years ago, he did so with the understanding that a partnership between the tribes and the state would develop and we would work together to amend it. Today, I stand alongside a group of youth who should not be advocating for change to the Settlement Act this many years later. We say Kachi-Waliwani, many thanks to the tribal leaders, advocates, partners, and state leaders who have worked tirelessly to make this change happen ahead of our time. In our communities, we center our actions on providing a better future for the next 7 generations and beyond, and it is now our turn to step up and do so. As such, I would like to urge the committee to do the same by respectfully supporting LD 395. Thank you, and I'm happy to answer any questions. Oluwan.
Thank you very much for your testimony. Questions, committee members? Seeing none, thank you.
Thanks.
The next person who wishes to testify, please step forward. Welcome.
Okay. Tall. Senator Carney, Representative Kuhn, and members of the Committee on the Judiciary, thank you for your time here today. My name is Emery Bucco-Harger, and I'm the Director of Communications at the Maine Environmental Education Association. I'm here today to voice my support for our organizational support for LD 395. MIA, my workplace, represents over 2,000 K through 12 public educators in schools and also community organizations in what is now called Maine. These educators provide immersive outdoor learning experiences and Wabanaki studies to youth in all 16 of Maine's counties and in the Wabanaki Nations. We strive to honor and uplift the Wabanaki Nations whose homelands we stand on right now, today. The passing of LD 395 should not be in question. It is not imposing anything new or unusual on the people of Maine, but instead is putting us in line with every other state across the land we now call the United States. All of the other 574 federally recognized tribes have a strong and mutually beneficial relationship with the state inhabiting their homelands. Maine's restrictive relationship with the Wabanaki Nations is the one and only. Under the Maine Land Claims Settlement Act, the Wabanaki Nations are the only federally recognized tribes to need to be explicitly written into federal legislation. This outdated law was passed nearly 46 years ago, and in that time, the Wabanaki Nations were restricted from no less than 151 federal laws that could have benefited both tribal citizens and Maine residents. A report released last year from the Maine Center for Economic Policy stated clearly that modernizing the Settlement Act could create 2,700 new jobs in Maine and the Wabanaki Nations and generate $51 million in state and local tax revenue. The Wabanaki are not the only people suffering the impacts of these losses. Maine communities do as well. Passing LD 395 is how we strengthen relationships and empower one another. This move to support the first peoples of our land is a move to support everyone that calls this land home. On behalf of the Maine Environmental Education Association, I strongly urge this committee to vote ought to pass on LD 395, and I thank you for your leadership on this critical issue.
Thank you very much for your testimony. Committee members, are there any questions? Seeing none, thank you. The next person who wishes to testify in favor, please step forward. Welcome.
Thank you. Good morning. Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is Sam Zuckerman. I'm the policy coordinator of the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations. I'm here today on behalf of the Permanent Commission's Policy Committee to testify in strong support of both LD 395 and LD 785. The Permanent Commission strongly supports legislation that recognizes the inherent rights of Wabanaki nations. For too long, our tribal neighbors have been denied the rights and protections that every other federally recognized Indigenous community in our country has access to. These rights and protections are the bare minimum required to begin righting the wrongs that have been enacted on the Indigenous people of this land through state-sanctioned theft and violence. Maine currently stands decades behind the rest of the country when it comes to respecting the will of its Indigenous communities, as Maine currently maintains a system that seeks to keep Wabanaki nations subservient to the state. This treatment is not only morally reprehensible, it also ultimately harms all of us, because we are all connected. And when our Indigenous neighbors thrive, so do the communities and environments around them. And it is long past time to implement the remaining recommendations from the bipartisan task force that were first recommended in 2020, and there's no reason to wait any longer. These two bills would allow tribes to resume stewardship of the lands and waters that they have historically cared for and relied on for vital resources. It would allow them to pursue economic development that is currently stifled by a hostile and inflexible state government, and it would allow them access to federal funding. The potential benefits for sovereignty can be seen in the prosperity experienced by other tribes who do have access to all of these rights and resources. Tribes in Arizona, Washington, Wisconsin, and Montana all operate successful business enterprises that benefit both the tribes and the communities surrounding them. A study from Harvard in 2022 found that between 1989 and 2018, tribes outside of Maine saw economic growth of 61%, while Wabanaki Nation saw only 9% growth. Rural tribes and the communities around them would benefit most from the recognition of tribal sovereignty. In the absence of manufacturing operations, businesses and organizations that have deep roots in and connections to the land itself will create a local economy that is sustainable and invested in the people they serve. Ultimately, however, the most important consideration here is what the communities most affected by these bills are asking of you. And the tribes have been clear. Sovereignty is a necessity for them, and the legislature should listen to their voices because they are the experts when it comes to knowing what will most benefit the tribes. Whether through economic growth, the protection of drinking water, or the ability to self-govern, every community deserves the chance to strive towards a better, more equitable tomorrow by denying Wabanaki nations the same opportunities afforded to other indigenous nations in this country. The state perpetuates an ongoing cycle of harm. Respecting Wabanaki Nation's right to self-determination is a vital step to ending this cycle. Thank you for your time. I'd be happy to answer any questions.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you.
Thank you very much.
We'll hear from one more member of the public, and then we're going to take a very short break, a 5-minute break, and then we'll resume. Welcome.
Good afternoon, Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is Abby Farnham, and I am the Assistant Director of Policy and Research at Maine Farmland Trust. I'm really grateful for the opportunity to be here today to provide testimony on behalf of MFT in support of LD 395. Maine Farmland Trust is a member-powered statewide organization that works to protect farmland, support farmers, and advance the future of farming. Our goals are to keep agricultural lands working and help farmers and their communities thrive. I'm not going to read my full testimony today. I just want to highlight how really what brings our organization to voice our support for this bill today is, in addition to it advancing fairness and equity for Wabanaki nations, equitable access to available resources, including federal programs and funding for all who are engaging or seek to deepen engagement in food production and land stewardship are key to the future of farming and farmland in our state. In addition, farms are drivers of local economic activity in rural areas, and in turn are more successful when the communities and regions in which they are located have robust and resilient local economies. This bill would ensure access to federal self-determination policies and funding programs for the Wabanaki nations and strengthen the capacity of the tribes in Maine to create greater economic opportunities for the Wabanaki tribes as well as surrounding non-tribal communities of rural Maine. Thank you for the opportunity to voice support today for this important effort.
Thank you for your testimony. Are there any questions, committee members? Seeing none, thank you. And we will return at noon sharp to continue our public hearing. Thank you, everyone. We're gonna. Committee members, if you're able to return to the horseshoe, we're going to continue the public hearing on LD 395. So we're going to resume the hearing, and I would ask that the next person present in the committee room who wishes to speak in support of LD 395, please step forward. Oh, just one moment. Adam's going to help you with the microphone. Thank you, Representative Lee.
Okay. Good afternoon, Senator Carney and Representative Kuhn. My name is Richard Farnsworth, and I'm here on behalf of the Council on Indigenous Relationships of the Episcopal Diocese of Maine. I wanted to thank you for the opportunity to offer testimony in support of LD 395, an act to restore federal laws beneficial to the Wabanaki nations. I want to give you a little bit of background about our group. The Episcopal Council on Indigenous Relations was formed by resolution of the Diocesan Convention in 1991. For over 30 years, we have lived into our mission to deepen our relationship with the Wabanaki of Maine, to stand with the tribes in their pursuit of justice, and to affirm their inherent sovereignty, and to support the preservation of the native languages and culture. So that's a little bit about the background of who we are and what we're trying to do. Just to give you some more, on October 22nd, I mean, we were founded in 1991, but on October 22nd, the 203rd Annual Convention of the Episcopal Diocese of Maine reaffirmed its commitment to the sovereignty of the Wabanaki nations located within the state of Maine by passing Resolution Number 1 with an overwhelming majority. Resolution Number 1 urges the 131st Maine Legislature to pass a bill or bills in a form consistent with the goal of tribal sovereignty and the recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementation Act, and urges the governor to sign this bill when it reaches the governor's desk. So this is something that we have been working on, and you've heard all of the other kinds of really good things that have been said about LD 395 contributing to achieving that goal. And of course, one of the important things has been the way in which the original Settlement Act discriminated against the tribes in terms of allowing them to have access to federal legislation, which would benefit them. So what this does, it begins to correct that big mistake that occurred. And we're in full support of that particular thing. I don't need to go on great length because you've already heard all the good possible things that can come out of this. And I would urge you, and we would urge you, to please give this a good boost. And yes, it's been talked about, and we've been trying to do this. And all we can say is, let's get on with it. Thank you.
Thank you very much for your testimony. Committee members, are there any questions for the Honorable Richard Farnsworth?
Thank you.
Seeing none, thank you. But the next person in the committee room who wishes to speak in support of this legislation, please step forward.
Good afternoon. I think it's afternoon now.
It is. Welcome.
Thank you to Senator Carney, Representative Kuhn, members of the Joint Standing Judiciary Committee, and all those present today. My name is Patricia Sprague, and I'm a retired educator living in Portland, Maine. I'm here to testify in support of LD 785 and LD 395. I am a new Mainer. I'm from away. I will never be recognized as a true Mainer. I am from the northeast of this nation and a descendant of the settler colonists in what is now called the New England region. And although I will always be seen as a non-Mainer, I am proud to be able to vote and speak according to my knowledge, values, and conscience here in my new home. I am here to speak because I humbly and urgently recognize that my ancestors grabbed land, claimed ownership, and waged war, suppression, removal, and erasure of the indigenous peoples, specifically the Wabanaki nations across what is now called Maine. I see that this suppression is still happening due to the archaic and condescending 1980 Act. The 1980 Maine Indian Claims Settlement Act, perhaps developed in some good faith at the time, today can be seen clearly as flawed and oppressive to the rightful and inherent sovereignty of the Wabanaki nations, the first people of Maine, the people who have never come from away. It has become a heavy settlement on their rights and sovereignty, and not a settlement for their benefit. LD 395 and LD 785 have been carefully crafted in detail, which you have heard much of, and of course you have read. I urge you to support both these bills, and I urge Governor Mills and her administration to fully recognize the rights of the Maine residents who have never come from away, and sign these bills into law. Thank you for your attention.
Thank you for your testimony. Are there any questions, committee members? Seeing none, thank you. The next person who wishes to speak in support, please step forward. Welcome.
Hi. Good afternoon, Chair Senator Carney and Representative Kuhn, and members of the Judiciary Committee, as well as any tribal representatives who are in the room. Thank you for the opportunity to provide testimony today in support of LD 395 and LD 785. My name is Kelly Merrill, and I serve as the co-chair of the Maine Green Independent Party, which represents 37,000 registered voters, and it is in that capacity I testify here today. We ask that the state restore the sovereignty of Wabanaki people on paper so that they, like the other 575 federally recognized tribes in the country, can benefit from at least 151 laws that have been passed since the Indian Land Claims Settlement Act. Having to use resources to advocate law by federal law is a gross injustice that perpetually robs the Wabanaki people of resources. The 2022 Harvard report cited several times today illustrates this in wage growth disparities of 62% in Indian country versus 9% here in Maine. Passing this bill is a small, long overdue step to affirm the rights of Wabanaki people and cultivate a good and sustainable relationship with our neighbors, one based on some idea of equity and fairness, though it must be noted that the system and the halls of power have historically been places that reveal the contradictions between our so-called love of justice and who actually receives it. We live in a time of revelation, of live-stream genocide upon indigenous peoples elsewhere that demonstrates a through line of colonial imperial violence around the world that boomerangs back to our home, of UN efforts that have been rendered inert, of ICJ rulings that are ignored, of the undoing of the world order and the unraveling of everything that needs to be unraveled. We hope that this conversation is part of a new future, part of the truth-telling, reconciliation, and collaboration that our collective futures rely upon. This is a conversation about relationship, and it's the strength of relationship that will define our futures in the new world order, and a wish for all people to be free of subjugation. We urge this committee vote ought to pass on LD 395 and LD 785 in keeping with the recommendations of previous bipartisan task forces, over 330 businesses, previous legislatures, and the Wabanaki people. Thank you for the opportunity.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you.
Thank you.
The next person who wishes to testify in support, please step forward. Welcome.
Thank you. Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee, it is good to be back before you again. My name is Josh Caldwell, and I am here on behalf of the Natural Resources Council of Maine in strong support of LD 395. For more than 65 years, NRCM has been protecting, restoring, and conserving Maine's environment now and for future generations. We work statewide to protect the health of Maine's rivers, lakes, streams, and coastal waters, promote sustainable communities through initiatives that reduce toxic pollution and waste, decrease air and climate changing pollution through energy efficiency and renewable resources, conserve Maine lands and wildlife habitat, and defend the federal environmental policies and programs that help to protect Maine. Our work is conducted upon unceded Wabanaki land, and it is incumbent upon us as an environmental advocacy organization to work alongside and in partnership with the Wabanaki nations. We've done so on countless occasions, from removing the VZ and Edward dams on the Penobscot and Kennebec River, to opposing the flow of out-of-state waste into Maine, to establishing the Katahdin Woods and Waters National Monument, to blocking mining proposals that would have been damaging to Maine's woods and waters. We are here again today to work with our Wabanaki partners to protect the nature of Maine. The Wabanaki nations have stewarded the land we now call Maine for time immemorial, and they continue to do so today despite innumerable adverse conditions imposed upon them by colonizers. One such condition that cannot continue to stand in their way is the gatekeeping of federal dollars and resources by the state of Maine. You've heard already today that no other federally recognized tribes in the nation, of which there are 574, are subject to this type of restriction. And you've also heard about the 151 laws that the Wabanaki nations have not had access to that other nations have, ranging from the Indian Civil Rights Act to the Indian Economic Development and Contract Encouragement Act, and spanning benefits from healthcare to food access to Veterans Affairs. I in particular want to highlight to this committee that many of these programs and policies from which the Wabanaki nations have been denied would have been immensely beneficial to their ability to implement and sustain sound environmental stewardship practices. These include several historic preservation acts, water quality and safe drinking water policies, gaming regulations, mining and waste management acts, site cleanup and remediation programs, invasive species management programs, land reform programs, and more. The list really does go on. Since 1980, the state of Maine has been standing directly in the way of Wabanaki nations in their pursuit of sound environmental practices that benefit people and wildlife alike. This unjust circumstance translates directly to worse outcomes for Wabanaki nations on all fronts. A report by the Harvard Kennedy School that's been cited today found that the inability of the tribes in Maine to self-govern and access the same federal laws and grants as other federally recognized tribes in Maine had a distinct and measurable negative economic impact on the tribes in Maine. For these reasons, we urge you to vote ought to pass on LD 395, a bill that would help put the Wabanaki nations on more equal footing with those that have full access to federal laws and funding intended for tribes across the United States. Thank you.
Thank you for your testimony. Any questions, committee members? Seeing none, thank you. With the next person who wishes to speak in support, please step forward. And could we have a show of hands of those who are still intending to testify in any regard on this legislation? Okay, so thank you all. That's very helpful. What I'd like to do is just to make an announcement that we'll hear the remaining testimony on 395, with the exception of the people who are online. Then committee members are much in need of a lunch break, and I'm sure others are as well. So we'll take a half-hour lunch break, and then we'll return. We'll do the online testimony, and then we'll start our next bill. All right, everyone, so you may proceed.
Thank you, distinguished chairs, Senator Carney and Representative Kuhn, and distinguished members of the Judiciary Committee. I won't repeat a lot of the points that have been well said already, but my name is Marfine Chan. I am the Executive Director of Kamai Maine, a community organization that serves Maine's Cambodian and Southeast Asian communities, of which there are more than 10,000 who call Maine home. I come before you today as someone whose community knows in its bones what it means to be stripped of land, rights, and the protections of law. The Cambodian community of Maine is composed largely of survivors and descendants of the Khmer Rouge genocide, people who fled a regime that dismantled every institution meant to protect them and left them to rebuild their lives from nothing. That history shapes how we see the world and how generations, second generations like myself, see the world. And it shapes why I and my organization is here today. At Kamai, Maine, we work every day to ensure that our community members can access the healthcare, food security, civic engagement, and cultural resources they need to thrive. We know what it means to navigate systems that were not built with us in mind, and we know what it means when those systems are finally changed to include us. Inclusion is not charity, it is justice. LD 395 is not asking for special treatment for the Wabanaki nations. It is asking that they be treated the same as every other federally recognized tribe in the country. Maine's Cambodian and Southeast Asian communities came to this state as refugees seeking safety and the opportunity to build new lives. The Wabanaki nations did not come here, they were here first, and they have never left. We share Maine and we share a stake in whether this state lives up to its values. Passing LD 395 is one meaningful step toward a Maine where every community, whether it arrived generations ago or is still newly rooted, can flourish on equal footing. I urge this committee to support LD 395. The Wabanaki nations have waited long enough. Thank you for your time and considerations. And I do have copies that I did forget to hand to your clerks. So.
Okay, thank you. Any questions, committee members? Seeing none, thank you. Would the next person who wishes to speak in support, please step forward?
Senator Carney, Representative Kuhn, members of the Judiciary Committee, thank you for hearing me today. My name is Luke Sakara Flanders. I am a member of Community Water Justice, a network of impacted communities across Maine building awareness and grassroots power to protect the rights of water for people, the environment, and for future generations. As tribal leaders have said today, sovereignty is already a matter of fact that cannot be granted nor taken away. It is the responsibility of conscientious leadership of this state to move forward and respectfully stop impeding or denying the tribe's ability to exercise sovereignty. The conditions that have denied Wabanaki nations access to federal programs crafted leading up to the 1980 Settlement Act were not crafted with fairness nor justice in mind. These measures relied on appeals to fear of what might possibly happen if we had, as one governor put it, nations within a nation. Looking broadly, time has shown that these fears were unwarranted. Since the end of the termination era of the 1950s and 60s, which saw federal and state governments, including Maine, attempt to dissolve tribal governments and completely erase the political existence of indigenous peoples, tribal nations across the U.S. have flourished in all metrics, from health outcomes to environmental restoration. It is unjust that the Wabanaki nations within the borders of this state should be denied access to resources and mechanisms to exercise self-governance that all other federally recognized tribes have retained. Wabanaki nations have endured over 400 years of continuous encroachment, erasure, disenfranchisement, and acts of genocide. The weight of that history should not be lost on any of us as we look forward. Let's enter a new era in this state and take decisive action to build a more just and prosperous future. Thank you for your time.
Thank you very much for your testimony. Are there any questions, committee members? Seeing none, thank you. The next person who wishes to provide testimony and support, please step forward. Welcome.
Thank you. Senator Carney, Representative Kuhn, and members of the Judiciary Committee, thank you for your work. Thank you for your service in the legislature. My name is Brian Wenzel. I'm a resident of Portland. I'm here to testify in support of LD 395. I've been working in land conservation in Maine for more than 20 years, from Portland to Moosehead Lake. Last 5 years, I've been in timber investment and sustainable forest management in Oxford and Piscataquis counties. In the last 10 years, working as part of the First Light collaboration, I've been working alongside and learning from Wabanaki leaders to address longstanding inequities around land access and sovereignty. I fully support LD 395 as one critical step in addressing the state's problematic relationship and treatment of the Wabanaki tribal nations. I won't repeat all of the great points that have been made, but want to underline two important points that really stand out to me. I strongly believe that we're all better off as Mainers, all Mainers, when Wabanaki sovereignty is fully recognized. I just think that we've heard some of that, but really want to underline that point. I think it's going to benefit all Mainers, no matter where you are. And secondly, the legislature established a task force on changes to the Maine Indian Claims Settlement Act in 2019. And in 2020, that task force produced the consensus recommendations that is and this bill is a direct result of those recommendations. So that was in 2020, 6 years ago. And here we are in 2026, talking about some of the same issues. And I really commend the work that's happening now between the legislators and the governor's office to figure out some of this stuff. But it's been 6 years. I think there's clear indication of what needs to be done. And I'm hoping we can move forward and take action. So when Wabanaki tribes are really put on level footing with the other 570 recognized tribes, we can and really broadly support steps in the right direction that benefits all Mainers. So thank you very much.
Many thanks for your testimony. Questions, committee members? Seeing none, thank you. Would the next person who wishes to provide supporting testimony please step forward? Welcome.
Senator Carney, Representative Kuhn, members of the Judiciary Committee. My name is Bill Walker. I'm reading this testimony of my fellow parishioner, Cassandra Wright, who could not be here today. I live in Orono and testify today on behalf of St. James Episcopal Church, Old Town, in support of LD 395. St. James Episcopal Church sits within sight of the Penobscot River in Old Town, and it is just a short walk down Main Street to the bridge leading to Indian Island. Being anchored in the great commandment to love thy neighbor, much of the church's outreach effort has supported our Penobscot neighbors with school supplies, holiday meals, heating oil, and food pantry supplies. At a special meeting of the congregation on September 28th of last year, parishioners voted unanimously to join the Wabanaki Alliance. Shortly thereafter, St. James created the Penobscot Nation Neighbors Committee. Though we have not yet adopted an official mission for the new committee, its focus is to support Wabanaki sovereignty and self-determination. We hope to find further ways to extend our friendship and support to these neighbors. In 1980, the Maine Indian Claims Settlement Act resolved claims by the Passamaquoddy, Penobscot, and Maliseet regarding 2/3 of Maine's land. It allowed two of the tribes, the Passamaquoddy tribe and the Penobscot Nation, to repurchase 150,000 acres of their former lands. But it significantly restricted their sovereignty by subjecting them to state jurisdiction, leading to ongoing disputes over tribal rights. And others have discussed the details of that agreement. Not only have the Wabanaki people suffered, but also surrounding Maine communities have been deprived of economic stimulus unencumbered Wabanaki nations might generate, if not thwarted, by this greatly unjust exclusion. We do perceive a new climate in Wabanaki state of Maine relations. The mascots are gone. Maine is no longer celebrating the dominance and genocide created by Columbus. It is important to note that the repudiation of the doctrine of discovery began at St. James Church. The repudiation spread to the Diocese of Maine, the National Church, and other religious bodies worldwide. There is more to accomplish, however. We must stop excluding Wabanaki nations from federal benefits available to every other federally recognized tribe. The passage of overdue LD 395 would continue the progress that our indigenous neighbors deserve. St. James Episcopal Church urges the Judiciary Committee to report this bill ought to be passed. Thank you.
Thank you very much for presenting your friend's testimony on behalf of St. James. We're very appreciative. The next person who wishes to speak in support, please step forward.
Good afternoon, Senator Carney, Representative Kuhn, Representative Dana, members of the committee. My name is Elizabeth Ward Saxel. I'm with Maine Coalition Against Sexual Assault, representing Maine Sexual Assault Support Centers and Children's Advocacy Centers in favor of LD 395. A particular concern to our coalition is the impact of the Settlement Act on the tribe's ability to respond to cases of sexual violence in their own communities. We know that Native women experience sexual violence at one of the highest rates of any population, and that the U.S. attorneys over many, many, many decades have declined to prosecute the majority of sexual abuse, firearms violations, homicide, and other violent crimes occurring in the lives of Native women. Maine Mikasa supports the Wabanaki Women's Coalition and their mission to increase the capacity of tribal communities to respond to domestic and sexual violence and influence tribal, national, and regional systems to increase awareness, safety, justice, and healing for all of their relations. The nations cannot fulfill that mission without access to the tools that sovereignty provides. The legal authority to pursue these policies that are in their community's best interest is integral to any people's autonomy. The nations must have the power to create solutions that are culturally appropriate and sensitive to the needs of the people. Reckoning with our failures begins with giving the Wabanaki people the ability to pursue legal remedies and control and govern themselves. I urge you to vote ought to pass on LD 395. And on a personal note, I am aware that my relatives are among those who murdered the people that they found here when they came in the 1600s. Not theoretically, but actually. I know this, and I know that much of my familial and personal privilege comes from those acts of murder. And in my mind, there is no question that we would live in a very different place had those individuals and the people who they were living with and coming here with, if they had not committed those murders. Thank you.
Thank you very much for your testimony. Representative O'Halloran?
Did you upload a copy of your testimony, or do you have a copy?
You're going to have one, yes. And I did not include the last piece in it, but I'm thinking about doing that. I found a major error in it when I had my little pile, and I was like, oh, I can't turn that in with the error. So
That happens to me all the time.
yes, but I'll add that last piece too when I upload it.
I'm looking.
Yeah.
Thank you.
Thank you.
Thank you. Any other questions, committee? Seeing none, thank you.
Thank you.
Would the next person who wishes to speak in support, please step forward. Welcome.
Hello, thank you. Thank you, Senator Carney, Representative Kuhn, and committee members. Sorry, I'm a little nervous. It's my first time speaking here today. I am here today in support of LD 785 and 395, and I urge ought to pass. As the United States continues to grapple with exceedingly difficult and, in my personal experience, thoroughly repulsive news regarding the ways in which those in power systematically treat those excluded from power, I ask us here today to consider how the settler colonial state of Maine would like to present itself within this context in regard to the very first peoples excluded from power, the indigenous tribes of Turtle Island, here in the land of the dawn. Indigenous wisdom teaches us that time is a circle and that all moments and beings are interconnected. So I ask what this moment in history is teaching us about power, privilege, and abuses thereof in regard to one of America's ugliest contemptible truths, the innumerable abuses of the indigenous peoples. My mother's family is from Quisqueya,
where Columbus and his murderous, rapist, human trafficking thugs landed by miscalculation in 1492. So please hear me today as I give my voice to align with the will of the Wabanaki, the people of the Don, in support of an act to enact the remaining recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act N395. Let us here today move the line closer to the way life should be here in the land of the Don, ought to pass all power to the people. Thank you.
Thank you. Could you please tell us your name and where you're from?
Oh,
That's one
yeah,
of our
I'm so sorry.
committee rules when
Yes, yes, yes.
people
My
testify.
name is June Moreau. I live in South Berwick. I'm a member of the Maine Green Independent Party, and I'm affiliated with Political Dissonance as well. Thank you.
Any questions, committee members? Representative Dana.
Not so much of a question, but I want to just, thank you for recognizing us as the people of the Don and also the land of the Don, because the word Wabanaki that comes from, that we use as our Confederacy is in our language, we call it Chquabanagiok, and that is the people of the First Light, the Don.
Yes, the people of the First Light.
Yeah, so thank you for sharing that with us, because I think you're the first one who's actually used people of the Don in reference to the Wabanaki nations here. So thank you.
Thank you for that reflection. Any other questions?
Any additional questions, committee members? Seeing none. Thank you.
Thank you.
Welcome.
Thank you. And good afternoon. My name is Jackson Chadwick. I am the Advocacy and Organizing Director at Maine Youth for Climate Justice and a resident of Bangor, the unceded land of the Penobscot. MYCJ is part of the Wabanaki Alliance Coalition, and founded in 2019, we support youth under 30 and advocating for climate action through legislative efforts, community involvement, and educational initiatives. And our members range from high school and college students to young adults in our state's workforce. On behalf of MYCJ and our members, I'm testifying in strong support of LD 395. We see this bill as about fairness and respect, and Maine youth believe that climate justice is inseparable from Wabanaki self-determination. We see LD 395 as necessary. Over the past 40 plus years, Congress has passed laws meant to support federally recognized tribes. Because of the settlement acts, though, Maine's Wabanaki nations, in some instances, were left out of those laws unless they were specifically written into them. It's been mentioned already, but a 2019 report by the Suffolk University Law School found at least 151 cases in which the nations were not specifically written into federal law and therefore were unable to benefit. Among the over 151 federal laws and programs include the Clean Water Act and the Clean Air Act. This limits their capacity to safeguard water quality, provide clean drinking water, and protect wildlife. No other federally recognized tribes are treated this way. So why should the Wabanaki nations continue to be treated in this manner? Modernizing these settlement acts not only benefits the Wabanaki nations, but also many of our rural communities. Think of this as raising the ceiling. As is, these settlement acts are a low ceiling for the Wabanaki nations. It's been mentioned already, but that 2022 analysis by the Harvard Project on American Indian Economic Development found that tribal self-determination benefits both tribal and non-tribal communities alike. If we can't raise that ceiling, tribal self-determination is limited, and future opportunities for tribal and non-tribal economic growth are prevented. There's no meaningful reason for the Wabanaki nations to be treated separately from all of the other federally recognized tribes in the United States. So on behalf of Maine Youth for Climate Justice and our members, we respectfully ask you to support LD 395, and thank you for considering our testimony.
Thank you very much for your testimony. Committee members, are there any questions? Seeing none, thank you.
Thank you.
Next person who wishes to provide testimony, please step forward.
Thank you, Senator. Senator Carney, Representative Kuhn, distinguished members of the Judiciary Committee. My name is Senator Rick Bennett. I live in Oxford, and I have the honor of serving the people of 14 communities in Western Maine in the state Senate. I'm a proud co-sponsor of LD 395, and act to restore access to federal laws beneficial to the Wabanaki nations. I have brief testimony that you may have already received. I just wanted to say that you read it, but much of it's redundant. I just really wanted to add my voice at this point because these issues have been before us for years. And I've been personally engaged since my reelection to the state Senate in 2020 with these issues and trying to bring justice. And even in this age where supposedly an age of enlightenment, we have to struggle with these basic issues of justice and fairness. And I do, however, despite that note of pessimism, I have to say I think this is the year. This is the year where we can advance this bill and get it across the line. I'm also a co-sponsor of another bill. I may not have a chance to testify on that one this afternoon, but I have submitted testimony on the LD 785 as well. This is the year. Let's just get this done. We can do it. We have the power. This committee has the power. The House and the Senate have the power to make this happen this year. I think that finally there's a confluence of sentiment, of events, of facts, of data that demand action now to pass this bill and also the other bill and get it done for not only for the Wabanaki people, but for all the people of Maine who will benefit from the improvement in the relations between the state and the tribe that this bill is one part of. And I just want to commend the committee for your approach and ask you to please find the path forward on this. Thank you.
Thank you for your testimony. Any questions, committee members? Seeing none, thank you. The next person who wishes to speak in support, please step forward.
Good afternoon, Senator Carney, Representative Kuhn, and the honorable members of the Judiciary Committee. I'm Lori Osher. I'm proud to represent House District 25, which is most of Orono. It's located in the homeland of the Penobscot Nation. Thank you for the opportunity to speak, and I too will speak about both bills because I won't be able to be here later this afternoon. I really am glad that these are being taken up, and it is time. I agree with my colleague, Senator Bennett, that it's well past time, and this is the year that we could do this, make this right. I have submitted my testimony, but I'll just summarize something I didn't include in my testimony, which is that I'm a field scientist by training, and my field is that I go out in wildlands. That's what I used to do. And I started by doing that for the federal government in the Amazon basin. And then I did it for the federal government in the Forest Service. And I worked in Alaska and in Colorado and California, all before I came to Maine. But every place I worked, the US federal government imagined that they got to decide how to manage the land where they were and where I was sent as a scientist to work. In every place, there were indigenous people that did not have the rights to manage that land. And so since I came to Maine, I've been working with the Penobscot Nation. I did when I was a faculty member at the university to talk about at how we would look at the land if we actually listened to the people who lived here about how to manage that land. And so I come to this as a land manager who understands that people have been on the land for a very long time. And when we come and impose our particular government on them, we're not being respectful. And these laws are ways to be more respectful to the indigenous communities here in Maine. And I give you seen my time, but thank you very much.
Thank you for your testimony. Questions, committee members? Seeing none, thank you. Next person who wishes to speak in support of 395, please step forward.
Good afternoon, Senator Carney, Representative Kuhn, and members of the Standing Committee on Judiciary. My name is Sean Mahoney. I'm the Vice President and Senior Counsel of the Conservation Law Foundation. I won't be redundant either. You've heard a lot of great testimony today. We're an environmental organization, so I'll speak to what I know. This law will make it possible for the Wabanaki nations to take advantage of the funding and tools that are available under the Clean Water Act and the Clean Air Act, which hasn't been available without having to go through extra steps and hurdles. So, for example, the members of the Passamaquoddy tribe at Sapayak had to deal with to call it subgrade drinking water is to give it more credit than it's worth for years, because they weren't included under the Safe Drinking Water Act and the funding streams that would flow to them. That hurt not only the Sapayak community, but it hurt the surrounding communities as well. This act puts the Wabanaki nations on the same footing. And in doing that, it's putting them on the same footing as all other 570 federally recognized tribes in the nation. We should get it done this year. So thank you. I've got written testimony, and I appreciate the work that the Judiciary Committee has been doing, and particularly Senator Talbot Ross. This has been a long-term thing. I think it's almost 6 years to the date that the 1626, I think it was, in 2020, which was the first bill to adopt the recommendations of the commission. So we're 6 years to that date, almost precisely, and it's time to get this done. Thank you.
Thank you very much for your testimony. Any questions, committee members? Seeing none, thank you. Next person who wishes to speak in support.
Good afternoon, Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Megan Smith. I'm a community organizer with Maine People's Alliance, and I live in Milford, Maine. I'm here today on behalf of Maine People's Alliance to support LD 395. Maine People's Alliance is a statewide grassroots organization working to build a more just, equitable, and thriving Maine. We support LD 395 for most of the reasons. I won't read all my testimony that other people have listed. But I did want to also say I'm here today as a tribal member of the Holton Band-O-Malice Indians. I was born in 1981, just 1 year after the Settlement Act was passed. So I've lived my entire life with the consequences of this law, not only myself, but my 26-year-old daughter, as well as the children she plans to have in a few years. So that will be, just 3 generations already that have lived with this law. And growing up, I have often heard my elders, and as I say that now, I'm probably closer to being an elder than I would like to admit, talk about the hardships our tribe faced because of the Settlement Act, especially when it came to economic development and opportunities that other tribes were able to pursue. They spoke about how decision made years ago, which now is decades ago, continued to limit what our communities could build, invest in, and achieve. At the time, I really didn't fully understand that. I was a child, growing up. I began to see how those limitations were still shaping the reality of Maine's tribes today. So for more than 40 years, the Settlement Act has required that Wabanaki nations be explicit. I won't read the rest of this. You've heard this a lot. 40 years we haven't been able to, be in federal laws unless we are in there. So really, a lot of these have just had so many lasting impacts, not just economically, but across generations. It has meant fewer opportunities for tribal communities to grow, fewer tools to support community development, and fewer pathways to build long-term prosperity for both tribal nations and the surrounding communities. And LD 395 is finally going to modernize the Settlement Act and remove these structural barriers. The bill does not give Wabanaki Nation special treatment, simply ensures that we are treated equally under federal law and have the same opportunities to benefit from federal programs as every other federal recognized tribe. And again, Maine People's Alliance and our members stand in solidarity with the Wabanaki Nations, and we urge you to pass LD 395. It's time to correct decades of inequality, ensure that future generations do not continue to face the same barriers my relatives spoke about and that our communities continue to live with today. Thank you for your time and consideration. And thank you, Senator Rachel Talbot Ross, for all the work you've been doing here. Been following that for a really long time. So, and I appreciate all the work the Judiciary Committee is doing and listening to all this testimony today. So have a wonderful day.
Thank you. Are there any questions, committee members? Yes, go ahead, Representative Henderson.
Thank you, Madam Chair, and good afternoon. Did I hear you say that you're from Milford or Rumford?
Milford, sorry.
So
Similar,
close.
both towns that people are like, where? No, so.
My hometown is Rumford. That's why I
Gotcha.
represent. That's why I was asking.
Gotcha.
Any other questions, committee members? Seeing none, thank you.
Thank you.
Can we just do another show of hands? Anyone who's here to testify for, against, or neither for nor against on 395? Just a few people. So if you're in support, please step forward. Welcome.
Thank you. Good morning, Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is Martin Chartrand. I'm here to testify in support of LD 395 testimony I just submitted. It covers both this bill and this afternoon's. I'm a lifelong resident of Maine, or what is now called Maine, what is still Wabanakik. I was raised in Rockland. I spent time in Bangor, and I currently live in Lewiston. And I plan to spend the rest of my life on these land of the dawn also. Through my role in family, community, and my work as a behavioral health professional, I am committed to doing my part to support the next generation of Mainers to also feel pride in who they are and to have a commitment to this place and its people. However, I know that as a settler Mainer, I am a newcomer and a guest here. The Wabanaki are my gracious hosts and my role models in caring for this place we call home. In the years since colonization, Wabanaki land and knowledge has formed the basis of Maine's economy and culture. Settler Mainers like myself continue to benefit greatly from this. However, the Wabanaki have faced many losses due to our presence. They now only control a tiny portion of the lands and waters they once lived in relationship with. The 1980 Settlement Acts, which were meant to offer the Wabanaki some compensation for this loss, cut the Wabanaki out of many beneficial policies at the federal level. Meanwhile, childhood poverty in the Wabanaki communities ranges from 40 to 77% compared to Maine's overall 15%. These facts are connected, and together they leave a mark of shame over what it means to be a Mainer. We are all here together now, Wabanaki, settler, more recent migrants, and those whose ancestors were brought here as slaves. We all share the responsibility to care for this land so that it remains beautiful and bountiful for, let's try to be hopeful, many more millennia. Part of that means making sure our laws are just so that all kids, and particularly Wabanaki children who are the bearers of the culture that has given so much to us all, can grow up with the opportunities to become all of who they dream themselves to be. This bill will not solve all the harm that the Wabanaki have experienced, but it's a valuable step that will also benefit us all. The Wabanaki, I believe, want their children and grandchildren and great-grandchildren to have good jobs, to have opportunities. And so they will seek the same things that will also give our children and grandchildren and great-grandchildren those opportunities if they have access to the policies that will bring that there. So I urge you all to vote to pass on LD 395. Thank you.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you. The next person who wishes to speak in support, please step forward. Welcome.
Hi. Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is Karen Blakelock, and I work for the Nature Conservancy in Maine. I appreciate this opportunity to testify in support of LD 395. The Nature Conservancy is a nonprofit conservation organization dedicated to conserving the lands and waters on which all life depends. We've been working in Maine for more than 60 years, protecting land, restoring rivers and streams, rebuilding groundfish populations in the Gulf of Maine, and developing innovative solutions to address climate change. We are also a part of a global organization active in all 50 of the United States and across the world in over 70 countries. Too often, when it comes to the decisions that affect their lands, waters, and livelihoods, Indigenous peoples have been denied the opportunity to participate in meaningful ways, resulting in the exclusion of important right holders from decision-making processes and management approaches that do not consider the lessons and solutions offered by Indigenous ecological knowledge. As an organization committed to creating a future of healthy lands, waters, and communities, we believe that one of the most effective and enduring actions we can take is to strengthen Indigenous people's voices, choices, and actions in natural resource stewardship. This is a major focus of TNC's work around the world. Here in Maine, we continue to learn about the historical and ongoing injustices faced by the Wabanaki tribes. We acknowledge the urgency of addressing these injustices and believe that LD 395 is necessary as it puts the Wabanaki nations on equal footing with all other federally recognized tribes. At TNC, we know the importance of Indigenous-led environmental stewardship and that Indigenous self-determination is the foundation for lasting quality environmental stewardship outcomes. We believe 395 is a necessary step in supporting the voice, choice, and action of the Wabanaki nations. Ultimately, TNC's vision of a world where both people and nature thrive is not possible without justice and equity for all people. Thank you for the opportunity to testify. I'm happy to answer any questions.
Thank you. Questions, committee members? Seeing none, thank you very much.
Thank you.
Is there anyone else who wishes to speak in support of LD 395? If so, please step forward. Welcome.
Thank you. Good afternoon, members of the committee. I am Peter Fitzgerald. I'm from Bucksport, Maine, and very happy to be on the Penobscot River. And I'm here to speak in support of LD 395 and LD 785. I'm an electrical engineer, so I deal with complicated things a lot, but they're very different than what you're dealing with. So I don't understand all of the complexities of what needs to be done to fix the issue. But I know that things need to be made right. If this was easy, someone would have done it already. And it being difficult does not mean that it is not worth doing. Everyone should have a chance to be able to, well, let me start over. The Wabanaki people are not looking for a handout. They're not looking to be given things to make their life easy. They're just looking to have the freedom and ability to govern their people as any other people would want and would have. And like other Indian nations in the United States have. Thank you.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you. Is there anyone else present in the committee room who wishes to speak in support of 395? If so, please step forward. Seeing none, is there anyone in the committee room? Oh, come on up. And if you are here to testify in opposition to 395, please, you'll be called next. Welcome.
All right. Well, I did have a speech, but I thought I read it and I thought it was kind of boring. So I decided to just go off the cuff, even though I've heard not to do this. But after having read the Maine Indian Claims Settlement Act and reading both bills, I thought what a great opportunity was for me now being able to vote for that, because to right this wrong. But I don't envy y'all, because it is these bills are technical and they're complicated. And like I said, I don't envy you, but I can't wait to vote on this on the floor. And I hope y'all will do the right thing and vote unanimously. So thank you.
Thank you. And could you introduce yourself?
Oh, yes.
please?
Yeah. My name is Rafael Macias. I represent House District 51, part of Topsom.
Thank
All right.
you. Have we heard from everyone who wished to speak in support? It appears that we have. If there's anyone in the committee room who wishes to speak in opposition to 395, please step forward. Welcome.
This side or this side?
The basket right next to you.
Senator Carney, Representative Kuhn, members of the committee. I'm Bill Ferdinand. I'm a lawyer residing in Brunswick. I'm representing the Maine Forest Products Council today, which has members who we represent every aspect of the forest products industry, everything from growing trees, harvesting trees, and making things out of wood. So mills, paper, things like that. Our concern, we've testified on these bills before. It's a very focused concern on environmental regulation. And what we are concerned about is maintaining a uniform and equal regulation of public natural resources, especially those that move around the state like water, air, wildlife. We don't want to have a patchwork of unequal laws throughout our state. It makes it difficult to regulate. And in this case, tribal regulation is in this law, as you know, it cannot be undone or changed without the consent of both sides. So there is a potential for tribal regulation or impact on activities that are outside the tribal lands and members of our association. So we want to avoid that. Chief Francis did mention that they're trying to carve out that area to make sure that that doesn't happen. I think that's the intent. I think the governor's office is still working on that, as you heard from Jerry Reed. What we've done so far under this administration is to have state laws that recognize tribal concerns and perspectives and issues, whether it's a water discharge permit or most recently a landfill expansion application, specifically focused on the rights and interests of the tribes that are involved with that. So that's, if we can continue on that path, so we have a set of laws that does take into account all the needs, that would be a preferable approach to managing these resources that do span different jurisdictions. We don't have anything to say. We fully support the idea that we should be looking at federal laws that bring benefits to the tribes. In fact, we suggest that you go through those laws because there's 151 of them, but you keep on, people talk them as if they're just sort of one thing and they all do the same thing. They do a lot of different things. So I think it would be beneficial to have a process that looks at federal laws and saying, how could these benefit our tribes in Maine, and make sure that we're getting the full benefits for our tribal partners. The amendments that they talked about earlier, we don't have objections to that either. Those deals with tax exemptions for things that happen on tribal land. So we don't really, we're not as involved or have no objection to things that happen on tribal lands. It's really that concern where there's this seam between state jurisdiction, tribal jurisdiction that can get, that we can't even think of all the permutations now going forward. So we want to make sure that it stays uniform and equal throughout the state.
Thank you for your testimony. Committee members, are there any questions? Representative Henderson?
Thank you, Madam Chair, and good afternoon. This might be better served for you to provide us at the work session, but can you, maybe not of the entire 151 federal laws that the Wabanaki nations haven't had access to, but can you identify maybe a handful of those that you feel as though would have been problematic?
I can do it right now.
Okay.
Clean Air Act, Clean Water Act,
Hang
Endangered
on, I
Species
don't write
Act.
that fast. Maybe provide them for the
They're
work
in,
session
they're
as
actually
well.
in the bill. A lot of them are in the bill already. So it's making sure that the bill covers all the things that potentially could be in that category. And so they're already in, I don't know what section of the bill it is, but there's a section that says it doesn't apply to environmental regulations like Clean Air Act, Water Act. We've done some on the Safe Drinking Water Act for waters that are in tribal lands to make sure that they can protect their safe drinking water, which is completely appropriate. But you have to make sure that the state has that same. So right now you'd have primacy authority in tribes and the state, and you have to, how do those two work together? So going forward, but Endangered Species Act is another one. So there are a number of laws where federal, that tribes can assume this state level authority. So you'd have, it would be like two states next to each other, and the tribal lands would be able to have their authority apply on their properties around the state, sort of creating this patchwork. And as we go forward, those jurisdictions could carry forward in different places where they acquire new lands. And that's a going forward issue that we're concerned about.
And is that list something that you'd be able to provide us before the work session? That would be really helpful. Thank you.
Any other questions, committee members? Seeing none, thank you.
Yep.
Is there anyone else present in the committee room who wishes to speak in opposition to 395? If you're in opposition to 395, please step forward. Seeing none, if you are neither for nor against on LD 395, please step forward. Welcome.
Thank you. Good afternoon, Senator Carney, Representative Kuhn, members of the Judiciary Committee. My name is Rebecca Lambert, and I'm here testifying neither for nor against on 395, LD 395 on behalf of the Maine Municipal Association's elected 70-member Legislative Policy Committee. MMA is a nonpartisan, nonprofit member service organization and aims to provide policy solutions that work for all residents in Maine. The LPC guides the advocacy efforts and establishes positions on bills of municipal interest. Municipal leaders recognize the importance of self-governance and self-determination as our roots are deeply entwined with the legislature's longstanding support for home rule authority and trust that our residents have the good intentions necessary to chart their own courses. For that very reason, local officials understand and support the desire among members of the Maine's Wabanaki nations to acquire the same rights and privileges as those extended to tribal nations in other states. With respect to LD 395, municipal officials are most concerned about the potential for being required to address the demands and priorities of both the state and the Wabanaki nations. Absent a clear process in the bill that mandates the use of an evidence-based and predictable process for protecting Maine's natural resources, there exists a potential that future decisions and regulations could shift additional and cost burdens onto communities. While municipal officials understand that the protection of the state's natural resources and investment in our communities and economic assets, Maine municipalities and by extension property tax and fee payers have already spent and continue to invest millions of dollars to build the infrastructure necessary to comply with existing state and federal clean air and water regulations. For example, it is possible that more stringent and costly measures could be implemented that impact the operation of municipal infrastructure located upstream from trust lands. The reverse could also be true, as decisions made by tribes could make it more difficult for communities to meet established state standards. At the very least, the legislation should recognize the dual and potentially conflicting regulatory compliance requirements that may be placed on communities. Further, it's important to municipal officials that language is included in LD 395 that explicitly assigns regulatory responsibilities over municipalities to the state. Should the state want to defer to the tribal governments, then the legislature should incorporate those proposals within their own regulatory framework. It's the only way to ensure consistency in enforcement among municipal entities. Additionally, if it's determined more rigorous regulations are necessary, municipalities will need to be provided the time to implement new requirements and, more importantly, the technical and financial assistance necessary to avoid shifting additional burdens onto the property taxpayers. In summary, the ability to discuss, recognize, and address impacts is an important part of the process of self-determination. Municipal officials encourage the inclusion of provisions that facilitate conversations among all interested parties and ensure municipalities retain the authority to conduct business within their own boundaries, address the priorities of its residents, and mitigate increases placed on property taxpayers. I appreciate your time and for considering the municipal perspective on this important legislation.
Thank you for your testimony.
Thank you.
Are there any questions, committee members? Yes, Representative Lee.
Will Maine Municipal be testifying on 785 as well?
Yes.
Okay.
Any additional questions, committee members? Seeing none, thank you for your
Thank you.
testimony. Sir, anyone else in the committee room who wishes to speak neither for nor against on LD 395? Please step forward.
Greetings to all of you. My name is Laura Noble. I live in Brewer, Maine. I've been here since 2009. I grew up in the state of New Mexico. And as I've traveled and lived across the country, I've recognized that many of the places that I was born in, raised, and lived in across the land have originally been held by Indigenous tribal members who came and arrived and lived here long before we were ever a country or states. And in this way, I recognize the Wabanaki people of the Don in the same kind of way. They've been here for thousands of years. They have a history. They tell that history repeatedly. And if you look anywhere, listen anywhere to the land, to the stories that are held here, you'll know that this is true. I encourage you to think about the structures that we have created in our government in a way that puts these frameworks to disempower people and their voices. We're the United States of America, and we're here to speak with our voices for each other, for the people. I encourage you to think about that. I also want to recognize in Asian cultures and traditions, this is the year of the fire horse. And while that may seem foreign to you, there are many cultures that walk across this land. They've landed here, they live here. We are a people still together, living together. We grow food together, we eat together, we drink the water together. The water is in our bodies together. You poison the waters, you poison the people. This is happening in this now. The Wabanaki speak for these things, and they speak for the waters, they speak for the land, and they speak for the people, and they speak for everyone to pay attention because they've lived here so long, and they remember what it was like before these things came to pass, before we decided to poison the land. They remember what it was like to fish in the Penobscot and eat the fish without having a fear of cancer. I'm a survivor of cancer. I'm alive. Praise God. Some of the people that kept me alive have Wabanaki ancestry. So I'm very grateful to them. And for those who remember these things. And I'm asking you, in this year of the fire horse, horses have this ability, their hearts amplify 5 times greater than a human, right? They can hear our hearts beat from farther away than we are even standing. Their ears listen like that. Maybe we could learn to listen like that and listen to the hearts of other people speaking. I encourage you to think about that. I encourage you to make a good choice today. We can all make good choices. We all have the ability to stand well, be together, eat well, and support each other in our lives.
Thank you for your testimony.
you.
Let's see if there are any questions. Any questions, committee members? Yes, Representative O'Halloran.
Oops. I just want to say it's nice to have another Brewer resident here today testifying, and I appreciate you making the trip. Thank you.
Any other questions, committee members? Seeing none, thank you. So everybody in the committee room who wished to speak on LD 395 had an opportunity to speak. Please step forward.
Williewood. Sagum. Madam President. My name is Henry John Bear. I had the honor of serving here in the Maine legislature for 3 terms and really enjoyed myself. I have my law degree. I have a Master of Laws degree. And some people think I know what I'm talking about every now and then. Others with great trepidation are probably sitting here hoping I don't do it. But let me just say that I'm neither for nor against this LD 395 or any other bill that will presume to include Wabanaki in its language. And there's reasons for that. There's a story. It's called, it's a legal maxim, which I know my friend will know, and others. It's called Fruit of the Poison Tree. And this process, I believe, is an example of such fruit. The tree that is poisoned comes from the so-called Maine claim to Indian lands back in and before 1980, both April, the state version, and October, the 1980 federal version, both of which were different. The problem with the difference is there was a section 31 in the Maine version that poisoned the legislation, that all of this is premised on, that the US Congress deliberated and voted on, but changed the Maine law. When it did that, it killed the settlement agreement. The requirement was to, after Congress visited it with its conditional ratification, that it come back here. It never did. President left office, another one, Ronald Reagan, assumed office, and quickly they have been acting as if all this is legal, when in fact, if you'll look at Section 31, it is my legal opinion as an experienced litigator with treaty and Aboriginal rights issues, and having been in the legislature, that the act you're relying on, the State Act, which was reportedly enacted by Congress, doesn't exist. It's a legal fallacy. All of this is in vain. So there is no transfer of land over which Maine can assume jurisdiction. There is nothing enforceable that can come out of this because the fruit is poisoned from the beginning, from ab initio. Section 31 is a poison pill, and it killed the Settlement Act. Proceed accordingly, I urge you. So I, again, cannot support something that is legally baseless, nor can I, oppose it or suggest additions to it, because Congress did. And I know my time is up.
Yeah, thank you for your testimony.
And
Let's
when
see
they
if there are
did that,
committee
they
questions
killed
for
it.
you.
Any questions?
Committee members, are there any
There
questions?
should be many questions.
Not seeing any. Did you represent Dana?
Thank you.
Yeah, so I guess I just want to get clarification. But are you referring to a US constitutional violation of Article 6 when it comes to the treaty rights for the indigenous people across the US? Is that what you're talking about here when you're stating your testimony? And is that what you're emphasizing on, is the violation of the US Constitution when they implemented the Maine Land Claim Settlement Act and Implementing Act?
I think I understand where you want to take that question, but no, I'm not. I'm saying that there is absolutely no jurisdiction by the state of Maine to enter into direct relations with anybody representing the tribes. It's a matter between the United States and the tribes, but it must include the parties who are parties to the treaties that you talk about, specifically the first one, which was 19 July 1776, as between the Wolastoqiyik, Nugutcook, and the other Maliseet bands, and Passamaquoddy and Mi'kmaq. Not the Penobscots, unfortunately, in this instance. And I speak to that. But the thing is, that is one of the treaties. But for further clarification, all right, there was never a transfer of land over which Maine could have undisputed jurisdiction, nor to the United States. And the treaty protects that from happening. We must consult with all of the affected parties, not just people here, but all 35 entities, all tribal governments, chiefs, councils that are in Canada. The treaties that you talk about are with Canadian Indians. I am a Canadian Indian. Almost everybody here is a Canadian Indian. So please understand that. No one here will dispute me. There may be a few who are not yet members of the Canadian bands that their ancestors come from, but they're eligible to be if they want to. I am one of them. And so if I'm here, I'm indirectly representing all of them, which is some 60,000 tribal members, some 35 tribal governments who own Maine. So.
Let me just check with Roseanne. Are you all set with your
Morning.
question?
Yeah, that's.
Okay, thank
Thank
you.
you.
Thank you for answering that question.
Yep.
Go ahead.
My first one is, do you have a copy of your statement or are you going to upload a copy of your
I
statement?
will.
Okay.
Yeah.
And my second one, I guess I'm trying to understand why, what you're talking about as far as Indian land claims rights and stuff like that would exclude the Penobscot Nation.
The treaty does not include the Penobscots that I referred to, the first treaty with the United States. The congressional record is extensive on that. The Penobscots were presumed to already be within US jurisdiction. So the Treaty of Watertown, this first treaty with the United States after it declared independence from Great Britain, was with the Willistic, the Maliseets, the Passamaquoddy, who was a small band, and the Mi'kmaq, who would 2 weeks later rescind their signing of the treaty because they were under a lot of pressure and surrounded by the British further east. So it ended up only being the Maliseets and the Passamaquoddy. Yeah, and so that's why with the Settlement Act, the parties that were affected were mainly those that signed the treaty, and they were all Canadian Indians, and to this day still are. Yeah, yeah. Just to let you know, tribal land was considered everything north of here and west of the or east of the Kennebec River. You know, that was the original Plymouth and Massachusetts grants. And that's what Washington and Congress had in their minds for territory for the US. Everything south of the 45th parallel, from here to Machias. Everything north was us. Still is, because the Settlement Act never did get legally enacted.
Anything further, committee members? Okay, I see that we're going to have more questions for you and we really need to take a lunch break. So maybe we could just
Oh,
do
wait a minute.
two
We're on a
more.
roll. We're on a roll.
I know, but unfortunately, we've been rolling for many hours and the committee does need to have a little lunch.
We can talk
But
representatively.
why don't you ask your questions and maybe you could either answer them or send our analyst an email with the answers. Go ahead, Representative Lee.
Toward that end, you're making a fairly interesting and complex historical and legal argument. And so I'm wondering if there's, and I don't process things well just verbally, oftentimes reading is best for me. I'm wondering if there's a legal memoranda, and I'm not giving you a homework assignment or anything, but if there's a legal memoranda or some writing to which you could send.
You can ask any one of these people here. I've sent it to all of them many times, but my thesis, my Master of Law thesis, I'll forward to you. It lays it out. I also lay out the ADR process contained in the treaty to resolve misunderstandings over land boundaries and what have you, that courts are required to use, but haven't been told to do it.
That would be great.
None of you have been taught about the Watertown Treaty of 1776, except perhaps the representative here. Am I right? Have you ever read it? Your first law, your first treaty?
I think thank you for sending that to us.
I'll be
And
around.
I know that Representative Lee will circulate it among other committee members. Representative Henderson, what's your question?
Thank you, Madam Chair. This, I think, is the first time I've heard this argument. I've only been discussing this for 4 short years. But you had mentioned section 31. Section 31 of what?
Of the main version of the MIA, the main implementing.
Main
act.
implementing
I'll get you a
act.
copy of that.
Okay, yeah, I do have that, but
All right, good.
I thought you were referring to the Settlement Act and I didn't see anything in the
Yeah, no,
Settlement
the
Act.
Settlement Act was the other wording of that. They were enacting that. Yeah.
Thank
Thank
you.
you.
Any further questions, committee members? I am not seeing any. Thank you very much for your testimony and for your answers to our questions.
It was an
today.
honor. It was an honor.
Thank you. Okay, so committee members, we have not yet completed our hearing on LD 395. We have 4 people who signed up, 5 people who signed up on 4 online to speak on 395. So we're going to take their testimony after our lunch break, but we're going to take a lunch break until 1:50. And then we'll come back and we'll take this testimony and finish 395. And then we will start our next public hearing a little bit before 2. Thank you, everyone. Committee members, if you could return to the horseshoe, please. Thank you, everyone. We're going to resume our public hearing. If people could be quiet in the committee room, please. Thank you. We're going to take the 4 people who are present online who wish to speak with regard to LD 395, and then we will begin the public hearing on LD 785. And so if you are online and you wish to speak in support of LD 395, please raise your electronic hand and please keep it raised until you've provided your testimony. And I realize that you probably won't be able to see the clock, so I'll give you a little heads up when we're close to the 3 minutes. Okay, first, we're going to hear from John Banks. John Banks, welcome.
Thank you. Senator Carney and Representative Kuhn, thank you for the opportunity to speak to the Judiciary Committee today on these important bills. I am strongly in favor of both of these bills, and please consider my testimony applicable to LD 785 as well as 395. By way of introduction, I am a Penobscot Nation citizen, and I was my tribe's natural resources director from 1980 through 2021 when I retired. 1980, that was just 4 years into federal recognition. And so at that time, the tribes were just really starting to develop the various tribal government administrative infrastructure to be in a position to take care of its tribal members and lands through the land claims case. So what I did early in my career in 1980 was I wanted to become familiar with what other tribes are doing across the country in their various natural resource programs. So I joined up with many of the natural resource organizations, the national organizations. I became board member on many of these organizations representing the Northeast tribes. And through that, I had the opportunity to travel throughout Indian country, and to visit many, many tribes, particularly tribes that have a land base and run natural resource programs. It was a great opportunity. It was a wonderful learning experience. And I was able to take what I learned and bring it back to my tribe, Penobscot. Also, in the year 2000, I took a road trip throughout the United States. This was a personal thing. And I visited many tribes across the country. I started in Maine, went to Connecticut, to upstate New York, down through the Ohio River Valley, to Oklahoma, and then continuing to the southwest and then north to visit some of the tribes in the Pacific Northwest. And one thing that I did, also I wanted to mention that I was one of the Penobscots delegates to the Maine Indian Tribal State Commission for about 30 years of those 40 years that I worked for Penobscot Nation. So during that trip, that road trip, I made the point to stop. Every time I crossed into a new state, I would try to find the first information booth or welcoming center so that I could look at how tribes in other states work with their states. And I saw a lot of instances where there was great cooperation and collaboration between tribes and states, which provided for very meaningful opportunities in economic development, and cultural enrichment, and so forth. And Then I came back to Maine after that 6 weeks. And, on returning back to Maine, I was reminded that Maine is very different than the rest of the country as to how it relates to its Indian tribes. And, when I get
John?
back to Maine, yeah.
I'm sorry to interrupt you, John. The 3 minutes has run. If you want to wrap up in a couple of sentences, please.
Okay, I'd be happy to. Anyway, I returned to Maine, and what came to me is why aren't we working cooperatively as they do in other states? And it seemed like the state of Maine was more taking the attitude of they would be happy for us to go away. So, the questions that came to my mind is, what is that? Why is that? Is it a fear of the unknown? What's going on? Is it a lack of trust? What is going on? The tribes are very different now than they were in 1980. They've developed full-fledged government programs to take care of their tribal members and lands. And so, here we are. Here we are, a half a century later. And I'm asking the same question. What is it? What is it? Is it the fear of the unknown? Is it a lack of trust? Yeah.
Thank you, John. Let's see if there are any committee.
Thank you for
Let's
the
see if there are any
opportunity.
committee questions for you. If you can just wait a moment. Committee members, are there any questions for John Banks? Not seeing any, but thank you for sharing your experiences with us and for your testimony.
Thank you.
Oh, I'm sorry, Maggie. Needs to open her camera.
Maggie Summers is next. Maggie, if you could please open your camera. And John, you can turn off your audio and video if you wouldn't mind. Thank you. Maggie, you may begin.
Hello, thank you so much. I am Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee. My name is Maggie Summers, and I'm the Outreach Director for Maine Conservation Voters, and I'm reading this testimony on behalf of Sarah Woodbury, our Legislative Director, who couldn't be here today. MCV is a statewide nonprofit with 13,000 members and supporters dedicated to building a just, thriving future for all by acting on the climate crisis, protecting the environment, and safeguarding our democracy. I am here to testify in support of LD 395, an act to restore access to federal laws beneficial to the Wabanaki Nations. This legislation seeks to correct a long-standing inequity created by the Maine Indian Claims Settlement Act and the Implementing Act. These laws have excluded the Wabanaki Nations in Maine from benefiting from more than 150 federal Indian laws passed since 1980, laws that apply to nearly every other federally recognized tribe in the country. Though the Wabanaki Nations are sovereign governments, the unique structure of the 1980 Settlement Acts have denied them access to federal laws that support tribal economic development, environmental protection, public health, child welfare, criminal justice, and self-governance. LD 395 would put the Wabanaki Nations on equal footing with the other 570 or so other federally recognized tribes nationwide. And I know we've heard a lot about this, but removing these barriers would let the Wabanaki access federal policies, programs, and funding with economic benefits reaching both our Wabanaki neighbors and rural communities across Maine. As people have referenced, a 2022 Harvard report shows that when tribal nations elsewhere access federal benefits, it creates thousands of jobs and generates hundreds of millions of dollars in native-owned goods and services, boosting both tribal and surrounding rural communities. The Wabanaki have been blocked from programs under key federal laws like the Violence Against Women Act and the Indian Healthcare Improvement Act. They've also been excluded from environmental programs such as the Clean Water Act and the Clean Air Act, hindering efforts to protect water quality, ensure clean drinking water, and restore wildlife and marine habitats. As the original environmental stewards of this land, the Wabanaki should be able to care for it as they see fit. For over 40 years, Maine has isolated the Wabanaki Nations from the broader framework of federal Indian law, a situation that is unique among federally recognized tribes. This issue is not about partisanship. It's about fairness, economic common sense, and honoring tribal sovereignty. And for all of these reasons, MCV urges the committee to please vote ought to pass on 395.
Thank you for your testimony, or for your reading the testimony on behalf of Sarah Woodbury. And we won't ask you any questions since you are not her. And then next we will hear from if you are online and you wish to speak in any regard, for, against, or neither for nor against on LD 395, that's the federal beneficial laws legislation. If you could please raise your electronic hand and keep it raised, we will bring you onto the panel to provide testimony. James Mile is going to join us. Welcome. You may begin.
Good afternoon. Can you hear me?
Yes.
Okay. Good afternoon, Senator Carney, Representative Kuhn, members of the committee. My name is James Mile. I'm a policy analyst at the Maine Center for Economic Policy. I'm here to testify today in support of LD 395 because the Wabanaki deserve the same protection of federal laws as other federally recognized tribes, and because doing so will benefit all of Maine economically. Last year, MESET released our report titled Sovereignty Starts Here, Land, Economy, and Tribal Rights in Maine, in which we demonstrated the value of tribal sovereignty to Maine's economy. We looked at several aspects of tribal sovereignty in that report, but I wanted to highlight a couple of findings that are relevant to this bill. The unique legal relationship that currently exists between the Wabanaki nations and Maine creates uncertainty that discourages outside investment in tribal projects and holds back economic development on tribal land. Applying federal law via LD 395 will provide clarity through a familiar framework which is already in use across the country by 570 other tribes. It will also allow for more innovative forms of economic development than Maine law currently permits. Across the United States, other federally recognized tribes have built on thousands of years of indigenous knowledge to build ventures in tourism, responsible resource management, and conservation. LD 395 will also open up more opportunities for the Wabanaki nations to apply for federal grant funding. MESET's comparison of federal funding received by tribes across the country and the Wabanaki nations suggests that the Wabanaki could be missing out on millions of dollars in federal grant funding each year due to the current restrictions. Importantly, the success for the Wabanaki nations benefits all of us. Those funds are not just investments in Wabanaki nations, but also in Maine communities. Experiences elsewhere in Indian countries show that tribal projects employ many non-Indigenous people, and increased economic activity in tribal communities also boosts neighboring economies. In Maine, this means much needed development in the most rural parts of the state. Tribal sovereignty is a moral imperative. Mainers have an obligation to correct centuries of a colonial mindset that has disadvantaged Wabanaki people and held all of us back. LD 395 does not do that fully, but it does take an important step that would bring legal consistency under federal Indian law and could bring millions of dollars in grants and investments to the Wabanaki and their Maine neighbors. For those reasons, we urge you to vote ought to pass on LD 395. Thank you, and I'm happy to answer any questions.
Thank you very much for your testimony. Are there questions, committee members? I'm not seeing any. Thank you for your testimony today. Next, we are going to hear from Cage Johnson. If you could please activate your audio and video and begin your testimony. Welcome.
Thank you. Yeah, Senator Carney, Representative Kuhn, members of the Judiciary Committee. My name is Cage Johnson. I am a resident of Winslow, Maine, and I'm testifying in favor of LD 395 on behalf of myself as an individual and also on behalf of Healing First. I am a transformative justice practitioner and a steering member of the Maine Restorative Justice Coalition, MERGE, and I'm also co-executive director of Wabanaki-led nonprofit Nabisen. And Healing First is in full and earnest support of LD 395, and Healing First is a Maine-based transformative justice collective led by survivors of serious harm. We advocate for restorative and transformative justice as accessible options for everyone. And part of our vision includes a world in which pathways for justice and healing are widely accessible for everyone. We believe in collective liberation, and that includes upholding and supporting the inherent tribal sovereignty of all Indigenous peoples. Honoring and upholding tribal sovereignty is akin to supporting basic human rights. From our perspective, sovereignty is essentially self-determination. It's considered a fundamental human right under international law. I feel actually, as a citizen of Maine, deep shame on behalf of the state of Maine for the continued decades-long subjugation of the Wabanaki Nations, the first peoples of this land, who have stewarded and continue to steward the land of this region that we all love. The average age of death of Penobscot, Passamaquoddy, and Maliseet people is 54 years old. And I ask us to consider, what role has the state of Maine played in creating or maintaining the conditions for that reality and for such statistics to exist? Maine has directly impeded laws that would benefit the well-being of Wabanaki communities across the Dawnland, including but not limited to a number we've heard from today, the Indian Healthcare Improvement Act, environmental protection laws. In a sense, the state has positioned itself in opposition to Wabanaki well-being. And so, Maine has blocked access to many of the 150 plus federal laws that have been mentioned here today, that other tribes have had the benefit of experiencing throughout the country. And without access to these things, Wabanaki nations and their surrounding rural communities here in Maine have really suffered stunted economic growth and have suffered greater disadvantages in terms of health and well-being. And so I want us to think about those things in terms of poverty is strongly correlated to poor health outcomes, less access to higher education. It's a leading predictor of both experiencing or causing violence, perhaps incarceration. And I think we as humanity should be focused on resourcing and empowering and creating healthy and flourishing communities. And so by not upholding and investing in Wabanaki tribal sovereignty, Maine is in fact disadvantaging Wabanaki people in our collective future. And there's a bunch of other things that have already been said today that I'll skip, but the real question here is, why should Maine continue to subjugate Wabanaki people, our fellow neighbors, to being treated differently than other federally recognized tribes in ways that negatively impact them, rural communities, and our wider communities throughout Maine for generations to come? So I passionately restate my and Healing First position of being in full support of LD 395. Please ensure that the Wabanaki are not excluded from legislation.
Thank you for your testimony.
Their federal tribes. Thank you.
Any questions, committee members? I'm not seeing any. Thank you for your testimony.
Thanks so much.
And at this point, I believe that we've heard from everyone who signed up online to speak on LD 395. That is correct. Okay, so we'll close the public hearing on LD 395. And we're going to move right into our next public hearing, everyone. So we'll open up the public hearing on LD 785. This is legislation entitled "An Act to Enact the Remaining Recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act." And our colleague, Senator Talbot Ross, is here once again to introduce the bill.
Good afternoon. Senator Carney, Representative Kuhn, and esteemed colleagues of the Judiciary Committee. I am Rachel Talbot Ross. I represent Senate District 28, which includes part of Portland, Cascabel Islands, and is the home to the University of Southern Maine. It is my honor to present LD 785, an act to enact the remaining recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act. While I am honored to be the lead sponsor of this legislation in the 132nd Legislature, its current form is the result of several years of work by this committee, the Wabanaki Nations, the executive branch, the Attorney General, the allies, advocates, partners of the Wabanaki Alliance, and so many Mainers who have been fighting for the restoration of tribal sovereignty. I want to acknowledge and thank them all for the decades of work that they have put in to fighting for these issues. I also want to acknowledge and thank the co-sponsors of LD 785, the presiding officers, Senate President Daughtry, Speaker of the House Fecteau, the Honorable Billy Bob Buckingham, Representative from Winter Harbor, who is the current House Minority Leader, members of this Judiciary Committee, the Chair, Senator Carney, Representative Kuhn, Representative Lee and Representative Babin, and Senator Moore and Senator Bennett. Hopefully, that will illustrate the very strong bipartisan support for the self-determination of the Wabanaki Nations and to usher in a new period of positive tribal-state relations. 785 is the product of then Speaker Sarah Gideon and then Senate President Troy Jackson, affirmatively reaching out to the tribes in Maine in the spring of 2019 to express the desire of the state legislature to modernize the settlement acts that govern the relationship between the state and Wabanaki nations. Their desire to modernize the settlement acts came as a result of the 2016 roundtable to review the Maine Indian Claims Settlement Act that was hosted by the Maine Tribal State Commission. The state legislature agreed and enacted a joint resolution to support the development of mutually beneficial solutions to the conflicts arising from the interpretation of an act to implement the Maine Indian Claims Settlement and the federal Maine Indian Claims Settlement Act of 1980. It established a task force to develop recommendations on changes that should be made to these laws and submit any necessary legislation to move them forward. The task force worked vigorously over the course of several months. Many of the chiefs that are here with us today participated in that work. They took testimony and developed a report that was presented to this committee in January of 2020. That report, as you well know now, set forth 22 recommendations for modernizing the Maine Implementing Act. Then, Representative Donna Bailey introduced a bill in the 129th legislature, LD 2094, that sought to implement most of the task force recommendations. That bill, sadly, was ultimately approved by this committee, but sadly was not brought to the full House or the Senate for a vote, in part due to the COVID-19 pandemic. As this particular bill, LD 785, moves through this legislative process, I think it's important to remember that it was the legislature and not the Wabanaki nations that initiated this process of modernizing the settlement acts, which proves that this legislature is interested in taking action. It's important because we've asked the nations to invest significant time and resources towards this effort over and over and over again. Previous Maine legislatures have set up a task force to look at this issue, the most recent one in 1996. But given all of the resources being devoted to this work, it is my sincere hope that LD 785 will be voted on by the House and the Senate and passed into law during the 132nd legislature. I think it is equally important for the public and my colleagues to understand that the purpose of LD 785 is to modernize the government-to-government relationship between Maine and the Wabanaki nations. This relationship has been governed by federal and state settlement acts since 1980, as you know. Those settlement acts were the product of federal litigation involving the Wabanaki nation's claims to much of the lands of Maine, which a federal court in the United States Department of Interior found to be valid claims. The settlement acts were supposed to focus on resolving the land claims, but they turned into an effort by the state to severely limit the inherent sovereign rights of the Wabanaki nations in order to prevent, quote, a nation within a nation scheme and inconvenience the state's jurisdictional authority. The past 40-plus years of living under the Settlement Act system has shown that the state has benefited far more than the system than the tribes. In fact, every time a study is conducted on how the tribes fared under the Settlement Acts, it concludes that the tribes suffer and have been unable to progress at the same rate as most other tribal nations within this country. I am going to take some time to walk through a few examples because they're extremely important for your understanding. Although the Settlement Act supposedly guaranteed the tribes the full right to govern their internal affairs, lawsuits brought by three paper corporations led to a state court decision in 2001, finding that the Settlement Acts required the tribes to release a substantial amount of their internal documents to the paper corporations under Maine's Freedom of Access Act. In 2012, Congress enacted amendments to the Federal Stafford Act that would allow federally recognized tribes to directly request a presidential disaster and emergency declaration rather than go through their respective states. Maine opposed these amendments applying to Wabanaki tribes. And they argued to Congress that the Settlement Acts prevented the amendments from applying. The Stratford Act amendments would have allowed the Wabanaki nations to seek federal resources when there are disasters on their tribal lands. The Penobscot Nation reported that Maine's efforts specifically prevented them from accessing federal resources when ice jams caused flooding on their tribal lands. The failure of these amendments to apply in Maine also delayed tribal access to federal resources to combat COVID-19 pandemic. A 2012 report of the United Nations Special Rapporteur on the Rights of Indigenous Peoples found that the Settlement Acts create structural inequities that limit the self-determination of the tribes in Maine and contribute to Maine tribal members experiencing extreme poverty, high unemployment, short life expectancy, poor health, limited educational opportunities, and diminished economic development. In 2013, Congress enacted a law that restored the criminal jurisdiction of Wabanaki nations over non-Indians who commit certain acts of domestic violence on tribal lands. The Penobscot Nation was set to be a pilot project for the U.S. Department of Justice. However, the state of Maine challenged the application of the new federal law to the Maine tribes. That result was that the tribes in Maine could not prosecute non-Indians for crimes of domestic violence, and the Penobscot Nation was not allowed to be the pilot project, lost out on millions of dollars of federal law enforcement resources, and women who are victims of domestic violence on tribal lands continued to have no access to justice. Then, in 2014, the Maine Department of Professional and Financial Regulation, which issues licenses to healthcare facilities in Maine, began sending letters to the Passamaquoddy Tribes Health Clinic demanding that the facility only hire Maine licensed medical professionals. However, Congress enacted a law in 2010 that allowed all Wabanaki nations to hire any medical professionals that were licensed by any state. Congress did this to address the shortage of medical professionals willing to move to and work on tribal lands. But Maine argued that the Settlement Acts prevented the new federal law from applying to the Wabanaki nations, and the conflict led to the Passamaquoddy tribe continuing to struggle to recruit medical professionals to work at its health clinics. Those are just a couple of examples. We could go on and on and on about how this has led to not only hampering the progress of Wabanaki nations, but it's also led to the hampering of progress for nearby communities and indeed the entire state of Maine, who are losing out on opportunities to partner with the tribes and access federal resources that could be used to improve the entire rural regions of Maine. I'm going to skip through some of my testimony. You've heard a lot of it through others this morning, but I do want to just say that I have long heard that the goals of the 1980 Settlement Acts were to prevent the existence of a government within a government. The state of Maine somehow thought that recognizing the full political existence of our Wabanaki nations would somehow diminish us as a state. Whatever the cause for those feelings in 1980, they simply have not turned out to be true in Maine or in other states. Instead, state governments that have embraced their tribal nations and developed productive and meaningful political relationships with them have seen those relationships bring progress to their entire states. There remain disagreements. To this day, there remain disagreements. Just like there remain disagreements between Maine and our other neighboring states, other relationships at this time. But having respectful, equal political relationships seems to be much more productive than what Maine has done for the past 40+ years. The Wabanaki nations pre-exist the state of Maine. They are not looking to harm the state. To the contrary, the tribes of Maine are not looking for special treatment. To the contrary, rather, they are looking for the restoration of their legal sovereignty and to benefit from the opportunities that other tribes in the country have in order to elevate the lives of those who are living within and near their communities. I would walk you through this bill. It is highly technical. I know that we will get there during the work session. I want to thank you for your patience and your time in listening to me this morning. There are many, many, many others, including tribal chiefs and tribal representatives. I see the governor's office is here that will add to this discussion on LD 785. But I believe that this is truly momentous legislation that can provide meaningful benefits to the Wabanaki nations as well to all Mainers. And I hope that you will join me in passing this significant legislation. Thank you for your time.
Thank you. Committee members, are there any questions for our colleague, recognizing that she'll, I'm sure, be with us for the work session?
I
Not
appreciate
seeing
the
any.
opportunity to present this bill. Thank you.
Thank you. At this time, the committee would like to welcome any member of tribal leadership who wishes to address the committee, and we're
Good afternoon.
Honored to have you with us
Just to
today.
like to restate that my testimony earlier was on both bills and that we're here to support this as well. And thank you all. And thank you, Senator Ross, for outlining that. And you got my testimony in writing from the Passamaquoddy tribe, and that's what we'll go with.
Thank you so
Thank you.
much. Would anyone else wish to step forward? Thank you.
Hey there. Give me a sec. All right, Senator Carney, Representative Kuhn, and esteemed members of the Committee on Judiciary, I again stand here before you in support of LD 785. Sorry, I need to introduce myself, Chief Clarissa Sabatis for the Home Band of Maliseet Indians. I will keep it short. I think that a lot of my testimony earlier applies to both of these bills. I think, fail to talk about some of the things that Senator Talbot Ross did, and I would like to say that I am so deeply appreciative of how the process started to really re-engage with the tribes. I think that a lot of this has always been led by the tribes coming and trying to do things, and I think that then Speaker Sarah Gideon, Senate President Troy Jackson, and I think Senator Michael Carpenter at that point really pulled us in. And I have to say, I was really skeptical. I think a lot of us were, but we engaged, and I'm really happy that we did. And I do think that even though, this hasn't been just everything got fixed all at once, it has been important. When I first came here, you probably have heard this in my testimony in the past, as a tribal leader, which wasn't really that long ago, maybe a little over 8 years ago, I remember going to an event with a lot of lawmakers, some who are still here, some who aren't, and they didn't even know that we existed. Some of them did not even know there were tribes in Maine. Some didn't know that there were Maliseets, but knew that there were, Passamaquoddy, Penobscot. I don't think that's the case anymore, and I think that the work that this legislature's done, the work that we've been able to do with the governor's office, the work that all of our tribal leaders, the alliance, and everybody has been able to do, has really kind of pushed this so that we're able to be out in front and having these conversations. And again, I will say, I think that, I don't know what the finished product will be with LD 785, but I still feel like these public hearings are so important. And we spent a lot of time down here having one-on-one conversations, meeting with people on both sides of the aisle to try to educate and really get people to understand. You probably could recite a lot of the things, all of you, in your sleep now, but that's good. I think that for me, it's important that people understand when they're looking at these things. I know as someone who brings laws in front of our tribal council, and we have to vote and make decisions and have to be fiduciary responsible for or to an answer to our citizens. I understand that responsibility that you all have too. So I feel like it is important to have these issues up front and center, even if this is not the final product this session. So again, I always support our sovereignty. It's at front and center for me as well. And I appreciate your time today, and thank you for listening.
Thank you very much. Would
Yeah.
you be open to any questions from the
Sure.
committee? Okay, thank you. Are there any questions for Chief Sabatis committee members?
Great.
Seeing none, thank you. there are other tribal leaders who wish to step forward and speak with the committee? Welcome.
Welcome. Yep, thank you. Senator Carney, Representative Kuhn, Senator Ross, and distinguished members of this committee. Again, my name is Craig Sanborn. I work with the Mi'kmaq Nation. I am a citizen of the Penobscot Nation. And I am here to speak in support at the direction of the Chief and Tribal Council of the Mi'kmaq Nation in support of this bill. As I stated earlier, we have been working fairly diligently with the governor's office and coming to some kind of a negotiated agreement where we enter it realizing that this is a long game, the changing of Maine Indian policy to make it more in line of the self-determination policy of the federal government. That being said, we go back and forth, and I did hear that there were a couple of questions regarding taxation issues and whether certain candidates were going to wanted to support all banishment of taxation. And I wanted to clarify that each of these are nuanced issues that we deal with. And so they're very specific, which parties, where they're residing, who's their employer. It's not a blanket, we're going to change and make, state tax law completely exempt the tribal people. It's in negotiation. So when it comes to you, it will come to you in a very specific set of facts. I'd like to talk to one of those facts, and that has to do with the taxation of personal income for tribal members working for tribal government but living off reservation. And so oftentimes we go around and round about the legal ins and outs, and sometimes I don't think that people understand the context of where these issues arise. And I wanted to share a little bit about that with you. I have been working within the tribes, not just as legal counsel, but as their directors of housing for 25, 30 years. And so when I first started working for the tribe in that capacity, and I came to the Penobscots, I was stunned that this was a community, a town, where there wasn't one mortgage on that reservation. It took me a while to get over that, and I had to dig to find out what the reasons for that were. And essentially what it was is the trust status of the land, or the reservation status of land in this case, created a restraint on alienation. And so what that meant, though, it was designed originally to protect the tribes, right? So people wouldn't be able to steal the land from tribal folks over the course of time. But the other side of that sword is that banks would not issue mortgages on tribal land because they couldn't get at the collateral in the event of a foreclosure. So this is one area, a community in the state of Maine, up until like 1980, that had no mortgages. Every house was essentially, the value of that house was the value of a car, because those are the only types of loans that the bank would be willing to lend. So it struck me, it was a form of institutional poverty. So in America, the number one way that people from middle income rise is through the ownership of a home. That has been denied up, in our lives. Like, we hear about things that have always occurred, and it seems like they've always occurred in the past. This actually was happening now. So the tribes, we created our own bank, Four Directions. We worked with the federal agencies to establish a lending law procedure, and we enacted them, and we started to create a private housing market, and the value of all people on the reservation whether they participated in mortgages or not, their net worth increased. But this is like our lifetime. When I came to work for the Mi'kmaq Nation, they haven't had a single mortgage. There's no homeowner living on the reservation land that has a mortgage. That's now. I believe the same is with the Maliseet. So what happens, how this affects is that many members of the tribe, you have this huge segment of the tribe that cannot live on a reservation. They can't live at home because they can't get mortgages to buy their own homes. So that's why. So you have a huge percentage of the tribal population that lives in surrounding communities that want to live on the reservation, that choose to work for the tribe, choose to give back to their communities, but they don't get the same tax benefits now that people have to have that trifecta, right? You have to live on the reservation, you have to be tribal, and you have to work for the tribal government. And you're denying this other part, it affects that. And so these are the types of things that we deal with on a day-to-day basis that I don't think people understand, that these are institutional barriers to wealth creation. So all of these little nuance that you can create and allow to flourish will benefit us. The other thing I wanted to just share before I leave, and I know that I've run out of time, and I beg for your forgiveness. I've seen my first cousin, John Banks. I see Chief Newell, who has spoke at the State of the State address or tribal address in years past. She remarked on how her great, I forgot how many greats are in front of it, grandfather had actually spoken in front of this legislature. And she spoke his same words in her own tongue. I first came in front of the legislature at the bequest of Chief Dana of the Penobscot Nation and Donna Loring, who is the father of Bullion and the grandfather of Camille. And I look at this game that we play, or this exercise that we play, that we come and we try to work together to change policy for the better. And we've been on this land for 10,000 years, and our relationship with you has been active for 250 years. I don't worry about the future so much. I do wish to make my life useful and to facilitate gains, to move the ball forward, whether it's in a small increment or not. That task will always remain. And looking at the young women that have come here today, my heart is lifted up. Kai, her mom was one of the first people to get a mortgage on that reservation and come back home and be able to raise her daughter. She's Harvard. So I have no doubt about the future, that our children, my community's children, will be back and speaking with your children. And we just hope to be able to move the ball a little bit. Not everything, nuanced. Thank you for your time.
Thank you very much. Are you open to
Yes,
answering
ma'am.
questions? Okay. Representative O'Halloran?
I have a curiosity question. You mentioned Four Directions, who I've actually worked with in my job. And I know that they also finance homes off of tribal land as well as on tribal land. And I know that they're government-backed loans. So I'm not sure how it is that other banks can't, that have the same government-backed loans, how come they can't finance properties on tribal land when Four Directions can?
So eventually we hoped
With the same program.
that to occur. So the program that they were able to do is the federal government, those agencies, HUD, USDA, and the VA, they've come up with a workaround of the restraint on alienation where they don't recognize a deed, they take an interest in a lease, a long-term lease that's in excess of the normal 30-year lease, so that you're able to convey it and sell your property. So that's the mechanism that they utilized, and so we were able to adopt it. That's the other thing with the northern tribes. We had to wait till we got our jurisdiction through the Restoration Act, which was 2 years ago, in order to create a court system so that our court system is able to hear and adopt the foreclosure laws and the enforcement measures. So we've been working with you in growing. There are other barriers, and so we are trying to look at different ways of doing that. And again, we're looking at nuanced right now. But eventually, we hope that Maine State Indian policy will become more of a self-determination model that the federal government is at now. And you folks are the ones that create Maine Indian policy. And we ask for your assistance.
May I just ask one quick follow-up?
Go ahead.
So with the development of your court systems, then is you're implying that you would handle the foreclosures? So then you could have a rule that says, like, let's just say it was, oh my gosh, I can't even think of the name of a bank right now. Like a JP Morgan Bank or something like that, or Chase Bank, those, they would not be able to, when they foreclose, they would not be able to sell it to anybody other than a tribal member. So you'd have control over that.
Yeah, that's correct. It's but we've developed a workaround for that as well. So in the event that there is a foreclosure, which is extremely rare, the tribal government will come in and work through their housing department to find another ready and willing enabled buyer.
Thank you.
Yes.
Any other questions, committee members?
Thank
Seeing
you.
none, thank you. And Chief Sabatis, I believe, wants to address the committee again.
Yes, thank you for allowing me to come back up just briefly. I think I wanted to kind of talk about the nuance too with, I think, the malice seats. While it is similar to that, we also have some challenges around home ownership because of the laws here and the ambiguities. We have federal land that we've actually leased to tribal citizens to put modular homes on. The town has the taxation or is taxing people on our federal land. So if that happens, then they can have a lien for property. So if they build, they could have a lien for that person's personal property on our federal land. So these laws have kind of made it difficult for us to do this. And there are special loans for tribal citizens on our land, but because of the laws here, it makes us hard to access those. And it's more than just like Bangor Savings even does, I think, the 184 loans, right? The other piece is when it comes to taxation, I mean, much like the state government, the towns, we have not had that taxation authority because the state has portions of it, the town has portions of it, so that as a government, we don't have that. We can't tax people. We could tax people twice, but I don't think that's a fair thing to do. So we lose out on that revenue. So when you're talking about like giving up the taxation on the state side, it means that we get the opportunity to make our own tax codes and tax our own people versus the state doing it. So that helps support our government and some of the expenses. So that helps at all.
Yeah. Thank you very much.
Okay.
Yes, go ahead.
Understanding on my part. So on your tribal lands that you have now that are undeveloped, do you pay taxes on those?
There's two types of properties. We have some that are in federal trust, they're federal lands. I mean, I guess you could compare it to like the post office and stuff like that, but we have also fee lands that we pay. So if we don't have them in trust, we haven't bought them with the money in our account for that, they stay fee lands. So we pay taxes just like everybody else would. But we have federal lands that are in federal trust on behalf of the tribes that have people living on them. They have to pay taxes to the town, not us. And that's so because of the laws that we have here, it's made it like that. And so it just creates challenges where other tribes would be able to help with home ownership. And I think, as Craig said, as a public health professional, I know that home ownership is really one of the big key indicators when you're talking about personal wealth and even your health. So it really does create barriers. And while I appreciate HUD housing, not everybody is low income, but they would like to live in our lands. So thank you. You're welcome.
Thank you for sharing that additional information. Other questions, committee members? Representative Henderson?
Thank you, Madam Chair, and thank you, Chief Sabatis. I feel like even after 4 years of dialogue on this, you kind of connected a couple pieces there when it came to the tax piece, so thank you. Another question that's come up while you're discussing that is where the tribes or the reservations are kind of viewed as a municipality, do you engage in municipal revenue sharing? Do you receive any state funds?
So I don't think that is this. I think we're the only ones that are not viewed as a municipality. We don't have that same structure. It's not something that I think we're interested in. I don't know if Big Ma. Okay, I wasn't sure if the Restoration Act. Yep. Okay. Yeah, so I think that our tribes are not, we're not operating in that status.
Okay, thank you.
Yes, Representative O'Halloran?
Do you know if the Penobscot Nation, if they're viewed as a municipality? Or the Passamaquoddy?
Chief Francis is going to be our next speaker, so you could
Okay,
ask
yeah,
him.
I have to say, I know the answer. I don't want to speak for any other tribe. That's okay.
Any other questions, committee members? Thank you.
All right, thank you.
Yes. Chief Nichols.
Chief Nicholas, Passamaquoddy Tribe, just following up on some of the comments that were made. So I've been at this about 20 years. In the last 16 years, I'll finish my term here for 16 years as chief. And some of these same questions come up and there's just new faces here. And, we answer them. What we've had to shift to for the Passamaquoddy Tribe at Indian Township with homes. Now, everybody around us in the surrounding towns are losing population. The Passamaquoddy Tribe is growing. So we have more people that stay, but you have the bigger need for the homes. Now, we're the largest land-based reservation with two communities within our reservation, Peter Dana Point and what they call the Strip. So the infrastructure is huge. The housing need is very, very necessary. We've done some patchwork because of the loan and borrowing side of it for tribal members. And we've purchased mobile homes and we've done some things so people have, good standard of living for a short period of time. Our goal now in the next phase is that once we start building these homes, we have an agreement where we sign them over. Because the tribal members aren't able to go to a regular bank and even go to 4 directions without so many loopholes. I'm going to give one example. My son's a military veteran. He's 100% disabled. He's able to get a VA loan. He got his lease. It's been 3 years of red tape, and his lot is ready for him to build his own house. But if he moved 5 miles off reservation and he went over on Princeton and he bought a piece of land, to say an acre, his house would have been done 3 years ago. So as a parent and also a tribal member and a tribal leader, I'm trying to keep my children and my grandchildren within our community because that's our safety zone. That's what we know. We know our culture, we know our language, we know our people, we know our next door neighbors. So it's more personal for us, and it gets even more personal when we come in and we have to do this over and over again. So it's not so much that we have a big expectation that there's going to be a huge change in the sovereignty bill. The taxation that was mentioned earlier, and you've asked some questions, Representative Henderson, in reference to some of the taxation issues. Our employees, which are about 200 employees within tribal government, that includes our law enforcement, fire and rescue, all of our infrastructure, health services, everybody, with the exception of the school. No, actually, the school is involved too because they're on reservation. 585 was set up when it was passed a while ago in reference to that tax so that tribal members that work for the tribe would not have to pay state tax. But if Aaron lives 300 feet over the bridge and my administration is over here and I live 300 feet on this side, I get a tax break and he doesn't. But yet he resides that close. So it's really a small fix to that individual tax part. Now, we all have fee land. All these tribes that are in here, we have fee lands because we can't get them into trust. We pay taxes on them. And then when we get them into trust, we have to pay the towns in lieu of them taxes forever to put it into trust. So the towns aren't actually losing any tax revenue. The valuation, they're still getting paid the taxes over time. Am I correct? So if they don't want us to put our land into trust because they're afraid of losing a tax base, but yet they're receiving the tax anyway, then what's the real reason? I don't want to speculate what that real reason is. But around our reservation, just at Madocmigoog, we own about 9,000 acres of fee land that all of our tribal members can live on, but it's not reservation. So that tax piece and them borrowing pieces are something that as tribal leaders, we have to deal with every single day. We're in the phase right now, we're building, depending on what the cost is going to be, because costs have gone up with trade. We're looking at building 12 to 14 homes. We were going to build 17. Once we're done with that, with a 5-year agreement and we move some families around, them homes will then be given to the individuals because they're not going to be able to borrow against them. So just a little bit of history there and just a little bit of sharing. I don't think I'll be here for another 20 years. At least in here testifying. I hope I'm around for 20 more years, but try to take care of myself. But I just hope we don't have to do this for another 20. And even if it is, as I said earlier today when I testified, them little pieces, eventually we're going to get more. And eventually there's going to be some change. There already is. All these people behind us that have testified today are all here because they want to support the tribes and their sovereignty. We understand what our agreements are and what we've been working on because of this short session and what it's going to take. And we're thankful for all of you being able to ask them questions and listen to what we have to say because you've heard it 100,000 times. So some of you have. So some of your parents were probably sitting here when we was in here testifying 20 years ago. I don't know. But, you know, it's always in a respectful way. And it's always because we want to improve the lives and the standards of our people and our independence. You know, I don't want to be a ward of the state. You know, I want to be the tribal leader that set the precedents and work with all the other tribal leaders that tribal sovereignty was the #1 thing that we were going to accomplish during our time. Thank you. Any questions?
Any questions, committee members?
Thank you.
Oh, yes, Representative Dana.
I just want to put on record that I'm 273 feet and a half from the chief's house, but we can round up.
Thank you.
Thank you.
Chief Francis, would you like to join us and address the committee? If you could turn on your camera and thank you for joining us.
Thank you for the opportunity again. And Chief, I'm sorry that Aaron lives that close to you. That is way too close. But I appreciate the opportunity to speak again. I'll try not to be, I'll abbreviate some of my testimony because I know it's been a long day for everyone. But, Senator Carney, Representative Kuhn, and members of the committee, again, for the record, my name's Kirk Francis. I'm chief at Penobscot Indian Nation, and I'm happy to be here to testify in support of LD 785. I want to, again, start by thanking the bill sponsor, Senator Talbot Ross, and this committee for introducing the bill and holding this hearing. There's a lot more value in these conversations as you're hearing today in these hearings. This committee possesses an authority that exists nowhere else throughout the United States. The plenary authority over Indian tribes exists within the United States Congress, typically exclusively. It's a huge responsibility, and I know that the complexity of it sometimes doesn't fit quite neatly into a legislative session or the timeframes that we have. So I want to thank the Penobscot people, the Wabanaki Alliance, and many allies, supporters within Maine who spent their time and resources to help advocate for the restoration of sovereignty within the Wabanaki tribes. Progress would not have been made without your friendship and commitment. And I honestly believe that those partnerships, those hundreds of organizations, the ability of the Maine tribes to really participate in the political process and educate candidates and all of those things has been a wealth of not only knowledge but also in return to the tribes in terms of successes. So together we're accomplishing a lot, and 785 is a continuation of the effort has been stated from 2020 when the Legislative Task Force on Changes to the Land Claim Settlement Act, the Implement Act, presented a report to this very committee that contained the 22 recommendations intended to help restore back to the Wabanaki nations the rights, privileges, powers, duties, and immunities similar to those other federally recognized Indian tribes across the nation. The recommendations require making significant changes to the state and federal settlement acts that were passed in 1980 and that severely restricted the inherent sovereignty of the Wabanaki nations. When the Penobscot Nation agreed to the 1980 settlement acts, it was primarily for the purpose of obtaining fair compensation for the lands that were wrongly taken from us. We never intended to give up our sovereign rights of civil, criminal, or regulatory jurisdiction over our lands, and we never agreed to the provision limiting access to future beneficial acts intended to benefit all tribal nations. At the time of the settlement acts, and I'll speak for our tribe, and we all have similar stories. We were a very impoverished people with very little political savviness in terms of having the clout or persuasion within state and federal government. Unfortunately for us, our opponents had plenty of that. And times have changed now. And we know that 45 years under the settlement acts have held the Wabanakis back in progress, which has harmed the tribal nations and surrounding rural communities. Studies by the Harvard Kennedy School and the United Nations found that the 1980 settlement acts and their consequences have led to significant underdevelopment of the Wabanaki nations compared to tribal nations around the rest of the country. And you've heard some of this earlier in terms of the Wabanaki economy's growth of 9% between 1989 to 2020, compared to a 61% growth for other tribes in 47 contiguous states. As the Harvard Kennedy School report concluded, tribes with more autonomy develop stronger governance systems, which encourage investments and spur economic opportunities. Progress has been made since 2020 with the help of all of you and our tribal partners, in large part because of the support, again, from our allies and the work of the legislature. Since 2020, we were in regular dialogue with the governor's office, the attorney general's office about these issues, and the entire legislature. And we've gotten some laws changed to address the several issues. Much of our criminal jurisdiction has been restored, allowing our courts and police departments to get stronger and coordinate more with local law enforcement. State tax laws were amended to start treating the Wabanaki nations and our citizens similar to every other federally recognized tribe. Provisions were added to the state law to strengthen collaboration between us. State law legalized internet gaming exclusively for the Wabanaki nations, which will allow us to generate revenues for housing, healthcare, roads, other infrastructure, and many other programs. Currently at Penobscot, we operate over 115 programs to benefit our people from a direct service standpoint. I want to specifically, and I think it's important to recognize people when they do good things. We often see in the paper when we're at odds or not agreeing. But Senator Hickman and the governor on the gaming authorization really took the time to see the differences between tribal economic development when it comes to gaming. These are functions of tribal government. Even though neither one of them were fans of tribal gaming or gambling in general, they both saw the value in tribal governments and local economies to authorize these limited licenses. So we appreciate this new economic development tool. LD 785 sets the stage for additional progress to be made. The legislation outlines the remaining issues that need to be addressed from the 2020 report of the Legislative Task Force. LD 785 focuses on restoring our civil and regulatory authority over our lands and natural resources. It limits the ability of the state to take our lands using eminent domain and restores our government's sovereign immunity. It amends the land acquisition provisions of the Settlement Act to ensure that we finally are able to obtain replacement lands for those long lost. And it includes alternative dispute resolution provisions to better develop processes for the Wabanaki nations in the state to resolve our differences. We have been in discussions with the governor's office since November about the provisions of this bill and are working towards finding progress on the issues of land acquisition and, as you've heard, additional tax reforms. These conversations require dialogue amongst the Wabanaki nations and also with the executive, so it's taken time. And our hope is to have something meaningful for this committee during the work session. But again, we understand this is a short legislative session and we'll continue to do the work collaboratively to try to figure out solutions. I'll conclude by recognizing that these conversations about tribal sovereignty can be uncomfortable at times, but we owe it to the people of Maine to evaluate the consequences of this 1980 Settlement Act. Have the uncomfortable conversations and try to develop paths forward that benefit all Mainers. I again thank the committee, the bill sponsor, the executive, the attorney general, and of course, all my tribal colleagues for their continuous work in this area. And as you've heard here today, there's no greater issue facing the Wabanaki nations in our future than our rightful place and recognition in terms of our sovereign status. So thank you all again.
Thank you, Chief Francis. Are you open to questions if committee members have them?
Of course.
Committee members, are there any questions for Chief Francis? Not seeing any questions for you. Thank you very much.
Thank you.
Are there other tribal leaders who wish to speak with the committee? Welcome.
Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Z. Cross McDonald. I serve as the Tribal Ambassador for the Holton Banamousie Indians, and I'm presenting this testimony today in support of LD 785. First off, I want to thank the tribal leadership and as well as Senator Talbot Ross. Thank you for everything you've done. I also wanted to express some gratitude to everyone who testified this morning. I just feel a lot of gratitude after listening to everyone's words. As I'm sure you're all aware, the origin of this bill is the 2019 Task Force recommendations. In the years since, we have worked tirelessly to educate and advance every one of the proposed recommendations. And we have had some success over the years, and we hope to continue the collaborative process to advance more of these recommendations. Tribal sovereignty has and will always be a top priority for myself and for the Holton Banamousies. And I hope we can continue to work together and bring us closer to equality here in the state of Maine. Willie Wynn.
Thank you, Ambassador. Any questions, committee members? Seeing none, thank you. Would other tribal leaders like to speak with the committee? Seeing none, thank you for speaking with the committee. I would now ask if Jerry Reed, Counsel for Governor Mills, wish to speak with the committee.
Thank you. Good afternoon, Senator Carney, Representative Kuhn, members of the Judiciary Committee. I'm Jerry Reed, Counsel to Governor Mills, and it's a pleasure for me to be here this afternoon to speak with you about these issues. I'll be brief. I really just want to endorse what you've already heard from the testimony from several of the Wabanaki chiefs, most recently Chief Francis and also Chief Nicholas, to confirm that we in the governor's office have been actively involved in discussing a set of priority issues with my counterparts representing the Wabanaki nations. And this is a discussion that is further along than the discussion that I described this morning in connection with LD 395. in this context, we are exchanging actual legislative language addressing a set of issues. You've heard about the importance of a variety of changes to the tax laws. So the Wabanaki Nations, that's certainly going to be a big part of it. There is also potential to bring forward proposed changes to the land acquisition provisions in the Implementing Act. And we intend to make amendments to Title III that would recognize and establish a legislative representative from the Mi'kmaq Nation to the legislature for the first time. And there may be other issues as well, but that gives you some sense of the issues that are being discussed. And I want to be careful in a setting like this not to overpromise, but here I am confident we're going to be able to deliver something for your review at the work session. So I'd be happy to answer any questions.
Thank you. Committee members, are there questions? Not seeing any. Thank you.
Thank you.
Secretary of State like to address the committee?
Good afternoon, Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee. My name is Shenna Bellows. I serve as Maine Secretary of State, the constitutional keeper of all state records, and I oversee Maine State Archives. I've also testified a number of times before your committee without bringing the tribute that I was due as a former member of Judiciary sitting in these same hearings for several years. So I've got a bag of tribute here for you. And it includes jelly beans, which were my favorite when I was on Judiciary.
The committee
here-
is grateful. Thank you.
I'm here to testify in support of both LD 785 and Act to enact the remaining recommendations of the task force on changes to the Maine Indian Land Claims Settlement Implementing Act and LD 395. I want to draw your attention to the records kept at Maine State Archives, which is the records holding institution for all of state government, and available at digitalarchives.maine.gov are extensive collection records from the Maine Land Office and the various land agents for the state through the state's Executive Council. These extensive records of maps, surveys, and correspondence document Maine's long history of controlling Wabanaki inhabited land and managing its use often without the consent of the tribal communities living there. And Section 5 of that bill refers to that. In fact, I was reviewing some of these records this morning, and what it shows is a record of exploitation of Wabanaki communities with land transfers, sometimes coerced or pressured. This bill is an opportunity to correct the record, to allow for continued Wabanaki ownership and control of their own lands, to recognize tribal sovereignty. And I'm confident that the records and our government can and should support this effort. So finally, as Secretary of State, it is my honor to fulfill the obligations of this office under Title III, Section 601, to continue to ensure smooth communication between the state and tribal leadership when these bills pass. Thank you, and I'd be happy to take any questions.
Thank you very much. Questions, committee members? Seeing none, thank you.
Thank you.
Thank you.
Well, so it's kind of history, right? Oh. Treaties and clearly.
Would the next person who wishes to speak in support of this legislation, please step forward? Welcome.
Thank you. Good to see you again, Senator Carney, Representative Kuhn, and members of the committee. I am Mullian Bryant. I am a Penobscot Nation tribal citizen and Executive Director of the Wabanaki Alliance. I present this testimony in support of LD 785 on behalf of the Wabanaki Alliance. Again, we were formed in 2020 by tribal leadership to educate the people of Maine about the need for securing sovereignty for our people. And you heard from so many of our allies and friends throughout the day. We're so thankful for the tribal guidance and leadership, all of our friends in our coalition, the bill sponsor, Senator Talbot Ross, the co-sponsors, I've seen them coming in and out, Secretary Bells. It feels really good to feel like we're moving forward on a lot of these things. And you also heard from my kid, Carmela Bear. I didn't want to tell you before. I want her to be her own person. But so it's so neat for me, and Craig touched on this. The first time I testified in this building, I was 15 or 16 years old, and it was in this committee. And it didn't feel as hopeful or respectful or open as it does now. So it's great to hear that there's ongoing discussions and we are working towards something that feels really good, even in those moments where we feel like we're not moving fast enough. The bill we heard earlier was about fairness, and this one is about parity. The remaining issues of jurisdictional control, stewardship of land and natural resources, and tribal self-determination are priorities for the Wabanaki Alliance. This bill would recognize our inherent tribal sovereignty, and it would allow for our tribal governments and people to be able to operate in ways led by tribal policy and process and not under the state. A huge part of the Wabanaki Alliance's work since 2020 has been to educate Mainers on why there is such a disparity in our state about tribal rights. We have hosted community panels and forums to discuss treaties, the 1980 acts, the work of the task force that we're discussing today, and the progress we've all made together. Mainers are excited about these improvements, and they embrace the Wabanaki people as partners and friends. It's in this spirit of friendship that we support these measures today, and we all have hope for a much brighter future together. Thank you.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you.
Thanks so much.
Next person who wishes to speak in support of this legislation, please step forward.
I kind of feel like we're at the 8th grade dance and, I'm one of the first out on the dance floor, but Senator Carney,
Welcome.
Representative Kuhn, members of the committee, my name is Ed Spencer. I'm pleased and honored to be here today. I prepared some remarks and left them on my kitchen table, so I guess I'll just have to wing it. But what I want to tell you about is what it's like to live in close proximity to one of the headquarters of the tribes on Indian Island, and it gives me a real good feeling, because they're like us. They have very similar values. They love their children. They love their elders. They love the creatures of the forest and of the water. And, where I live, along Pushaw Stream, which used to be like a side highway between Indian Island and, points up to Pushaw. There was a historic native fishing village 5,000 or 6,000 years ago. Well, it just makes me feel good. I work in the woods. I spend a lot of time alone in the woods, and I'm not saying I hear voices, but I feel things. And you walk up there in Hirundo along those trails, it just gives you a sense of history, And something John Banks was saying, it really struck me as like, where's the disconnect? Where's the distrust amongst us, people of Caucasian descent? And frankly, I don't understand it. I mean, every person I know in the tribe is an honorable, respectful person, member of society. And I think basically what's good for the Wabanaki is good for the state of Maine. I don't, you might quibble, like they say, there's nuances. We might disagree on small ways, but basically, it's true. Even if you just had a crass capitalistic look at it, they're fully vested tribe in the United States. They have all the rights and privileges to things like education, and they will take advantage of that. We just need to help a little bit. So I'm encouraged that we are seem to be making good progress here. And I applaud all your efforts and everybody here. And for people who aren't ready for it yet, all I can say is, if not when, now when? You know, what are we waiting for? You know, and in closing, I think in order for the individuals and the whole of the state of Maine to realize our potential as a society, we need to respect the Wabanaki and their culture and give them every opportunity. Questions?
Thank you very much.
Thanks.
Questions, committee members? Seeing none, thank you. The next person who wishes to speak in support, please step forward.
Gotta get it out here.
You could just put it right in the basket.
Oh, she's coming to get it, I think. Thank you. Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Sandy McCrae Duchesne, and I live in Hudson. I'm testifying in support of 785 as a non-native ally who has long supported the restoration of sovereign rights to all of Maine's tribes. This legislation is personally important to me. I live on Pushaw Lake, the distance of an easy canoe paddle from the Indian Island Reservation of the Penobscot Nation. I've worked professionally with the Penobscots and both Passamaquoddy tribes. I have volunteered as a birding field trip leader for the Holton Band of Malice Indians at their Summer Youth Day Camp program. Wabanaki people are my friends, my neighbors, my colleagues, and my fellow UMaine alums. Go Blue. An injustice to our only true native Mainers is an injustice to all of us. And there is no doubt at this point in history that the settlement acts have resulted in great injustice for all of the Wabanaki nations. LD 785 will implement the remaining recommendations of the 2019 MIXA Task Force, helping to restore tribal sovereignty and provide greater economic opportunity for Maine's tribes and surrounding communities. You've already heard and read the statistics. Wabanaki income has increased by just 9% since the 1980s. Childhood poverty far exceeds the statewide average. For tribes outside of Maine, where the federally guaranteed rights of tribal sovereignty have been respected and upheld by state governments, economic growth has averaged 61% during that same period. It's increasingly clear that the status quo is not meeting the basic needs of our original Mainers, who have lived on this land in harmony with the natural environment for over 10,000 years. With LD 785, we can seize the opportunity to address decades of unfair treatment and nearly continuous lawsuits over the legalistic interpretation of a clause in an agreement that dates back to 1980. It's time for a change, and this committee is poised at the right time and the right place for positive change to start. The MIXA Task Force recommendations were reached through thoughtful discussions, public meetings, more discussions, and eventual consensus. There is nothing revolutionary or threatening to non-native Mainers in their report. All the Wabanaki nations want is the right to be treated like every other sovereign tribe in the United States and in Canada, for that matter. Maine stands embarrassingly alone in treating its tribal governments as municipalities. The Settlement Act is part of our history as a state, and sadly, it followed a pattern. We've spent over 400 years getting things wrong. I know that we can do better. LD 785 is our opportunity to take the MIXA Task Force report off the shelf and agree to start implementing all of its recommendations. It's the fair and the right thing to do. Thank you.
Thank you for your testimony. Committee members, any questions? Seeing none, thank you.
Thank you.
I see we've organized into an on-deck circle of sorts. Thank you, everyone, for being so organized and cooperative.
I
Welcome.
appreciate the efficiency, in fact. Senator Carney, Representative Kuhn, members of the Judiciary Committee. My name is Bob Duchesne. I'm following my wife, as I so often do in life. You have to forgive me. I haven't been in this room since the 125th legislature when I was testifying against a bill I really, really hated. It's all coming back to me, but I've gotten older and I no longer study history. I just remember it. And I remember when the Land Claims Settlement Act was passed and how controversial it really was at that time, and it was. And ever since that time, there's been an attitude of saying, well, that can never be changed. We finally reached agreement. It was like carved in stone on a mountain and carried down on tablets. And that was the attitude for an awful long time. And even when the cracks in this started to show up, it was really difficult to address. I think that has started to change. What I'm not conveying to you is fact or opinion. It's just impatience. This has been going on a very long time, as you well know. And I'm impressed by the tribal chiefs' patience on this because they put up with this a lot longer than I have. So to be real quick, we went from that period where we can't ever change this to saying, well, it needs change, but there are roadblocks in the way. And you heard some of those roadblocks earlier, the taxation, the Maine Forest Products Council, which is a group I really respect and love. They have their concerns too. When you have multiple jurisdictions within the same borders, you're going to have problems. I realize Maine is not is the first one to go down this path, except for every other state. So we should have been at some point able to learn some of these lessons. I'm going to invite flipping the argument on its head. What we've been trying to do, I think, in the legislature for years is what are all the roadblocks? What are all the hurdles to getting this done? What if we just say, let's get the policy done and then work out the details and work them out as partners? Because I think it's going to be faster and more effective. And that's pretty much the way we do it anyway. I say we because I was downstairs for 12 years. That's the way it's frequently done with a lot of other policy. The legislature passes the policy. I now chair the Board of Environmental Protection. You send the problems to us, we fix them or try to implement them. That's what tends to be the process. For whatever reason, this has never been the kind of thing the legislature does when it comes to these tribal issues. I would invite to flip it on the head, pass the policy. Then I'm gratified to hear the governor's office may have already worked out a lot of these issues and bring it to you at work session. But get the policy and then work out the details as partners. And I think that's going to be more effective, and I encourage you to do it.
Thank you for your testimony. Let's see if there are questions. Committee members, any questions?
Thank you.
Seeing none, thank you. Welcome.
Good morning, Senator Kerry and Representative Kuhn and honorable members of the Judiciary Committee. My name is Patricia Houghton. I am a Passamaquoddy tribal member on the Pleasant Point Tribal Census. I am in support of LD 785, an act to enact the remaining recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementation Act. I'm here today to ask consideration be given to add an amendment to protect an inherent right of individual Native sovereignty. Far too long, Passamaquoddy voters have been shut out of meaningful representation in shaping policies that affect our natural resources, constitutional rights, and enterprises with our future generations in mind. All Passamaquoddy tribal members have a right to have a seat at the table. There are roughly 3,300 Passamaquoddy tribal members, of which between 750 reside at Township and 680, 750 at Pleasant Point. According to Indian Health Service, 42 CRF 1362.23, see handout number 1, Indian Township has added Hancock County to Indian Township's Health Center service area, adding 257 newly enrolled members for health services. The health service areas requested by tribal governments has been used to determine the voting rolls for election. Not all census members can vote on the Passamaquoddy tribal rolls. Will they now qualify, the Hancock new service area members? The present system allows a minority group to dominate present policies and elections by excluding out-of-service area and off-reservation members the right for representation and to vote. Considering that tribal voting is a sovereign issue, I have tried all available avenues to have my voting rights restored, as well as other disenfranchised tribal members to no avail. See handout number 2. And I take a moment for some Senator Talbot's words. Uniformity. I am looking to follow my fellow Penobscots and Maliseets who use their census and allow all of their census members to vote. The Passamaquoddies do not. Thank you for your time.
Thank you for your testimony. Are there any questions, committee members? Yes, Representative Hagan?
Thank you very much.
Excuse me, Senator Hagan.
Oh, titles are nothing. It's nice to see you again, Patty.
Yes.
I see in here you had two amendments. The second one, State of Maine oversight jurisdiction for financial reporting disclosures. Did I miss that explanation on that one?
Well, initially, my ask was 2. Voting rights restored so that all tribal members in the state of Maine can participate in the voting process for our tribes. My second ask was that our general fund would fall under the jurisdiction of the state. That was a big ask. If we have full voting rights, I would hope that we could take care of the financial reporting and jurisdiction of our general fund, because that general fund theft, I mean, I'm not saying anyone's stealing. Who prosecutes our general fund mismanagement? State? Federal? Has that been considered? So I eliminated that ask.
Thank you. Any other questions, committee members? And I would just remind or caution committee members that these proposals seem to be not within the scope of our jurisdiction as a committee. So if you have a question, if you could please ask it regarding something that is within the jurisdiction of our committee. This is about the Passamaquoddy Constitution, as I understand it.
I would like to have it etched in stone so that no elected tribal government can ever take it away. And be it at however, I'd like to have a conversation. There's a relationship between the tribes, the state, and the feds.
Understood. Let's let Representative Henderson ask her question.
Okay.
Go ahead, Representative.
Thank you, Madam Chair. Without, having you re-give us your testimony, am I understanding that tribal members who don't live on either fee lands or trust lands don't have voting rights?
Correct. We are not allowed to vote for our representative.
Or tribal members? Or tribal chief or council
Tribal
members?
chiefs,
Okay.
yes, we cannot vote on constitutions, we can't vote in referendums, petitions, recalls, anything.
Thank you. Any other questions, committee members? Seeing none, thank you.
Thank you.
Welcome.
Thank you. Hello. Senator Carney, Representative Kuhn, and honorable to the Judiciary Committee. My name is Asna Nobuto'olo, and I'm a resident in Orono, and I'm a student at Orono High School. I'm speaking today in support of LD 785, an act to enact the remaining recommendations of the Task Force on Changes to the Maine Indian Claims and Settlement and Painting Act. My own family is a part of the Bamileke people of Cameroon, a community with its own traditions and own governance, and its own way of passing knowledge and identity from one generation to the next. Growing up connected to that heritage, I was taught that your tribe your language, and your land are not just a history, but they are who you are. Growing up listening to the stories my father would tell me at the dinner table that was my initial foundation. And when outside forces strip away your right to govern yourself on your own land, the damage runs deep and lasts for generations. That is why I cannot stay silent about what has been done to the Wabanaki nations here in Maine. The 1980 Settlement Act left the Penobscot, Passamaquoddy, Maliseet, and Micmac nations in positions unlike any other tribal nation in the United States. For over 40 years, more than 150 federal laws meant to protect Indigenous people simply have not applied here. Economic tools, healthcare resources, and environmental protections, doors that are open to every other federal recognized tribe in this country, have been closed to Maine Wabanaki nations. When I hear that, I recognize it. In Cameroon, across Africa, colonial powers borders imposed outside laws that told sovereign people how much authority they were allowed to have in their own lives and lands. We saw that at what cost? In culture, in language, in community. Those wounds do not disappear overnight. The Wabanaki nations have never surrendered their sovereignty. They have been simply denied the tools to fully exercise it. LD 785 is not asking for something extraordinary. It's asking for Maine to implement the recommendations of what task force that Maine itself created. It is asking the state to say, finally, that the original peoples of this land deserve the same rights as every other Indigenous nation in America. What makes Wabanaki people undeserving of what every other Indigenous nation in America already has? I close with that, and I urge this committee to support LD 785. Change is possible, starting with all of us. Thank you.
Thank you for your testimony. Are there any questions, committee members? Seeing none, thank you.
Thank you.
Next person, please step forward.
Senator Carney, Representative Kuhn, and distinguished members of the Committee on Judiciary. Good afternoon. My name is Paige Loud. I live in Old Town, Maine. I'm a social worker, graduate student at the University of Maine, and candidate for the United States House of Representatives in Maine's 2nd Congressional District. I am also the first registered citizen of a federally recognized tribe to run for federal office in Maine. I am a proud citizen of the Cherokee Nation and a descendant of survivors of the Trail of Tears. I write today in strong support of LD 785. For my people, sovereignty is not an abstract concept. It is survival. It is dignity. It is the right to care for our own, protect our land, and shape our future. I have watched the Cherokee Nation grow into a strong and prosperous nation, investing billions of our own dollars into healthcare, education, housing, language preservation, and economic opportunity, because it has the authority to govern itself. Sovereignty has allowed the Cherokee people to rebuild, heal, and ensure that future generations inherit strength rather than hardship. Here in Maine, the Wabanaki nations have not been afforded the same opportunity. The framework created by the Maine Indian Claims Settlement Act placed unique limitations on tribal self-governance that exists nowhere else in the United States. It's shameful. And the state of Maine should be ashamed. These restrictions have constrained self-determination, limited opportunities, and contributed to hardships that continue to affect families and children today. They're unnecessary and they are cruel. LD 785 aims to correct this inequity. It continues careful, bipartisan work to modernize a relationship that has too often been defined by limitation rather than partnership. This legislation is not about special treatment. It is about fairness. It is about ensuring the Wabanaki have the same tools that other tribal nations use to build healthy communities and sustainable economies. It is also about healing relationships. For too long, uncertainty and legal conflict have stood where trust and collaboration should exist. Passing LD 785 offers an opportunity to move forward together as partners, neighbors, and stewards of this shared place. The Wabanaki peoples have protected the lands and waters of this region for 10,000 years. Strengthening their sovereignty strengthens environmental stewardship, cultural preservation, and the well-being of rural communities across Maine. As a descendant of people who endured forced removal, genocide, cultural erasure, and generations of hardship, I understand what is at stake when sovereignty is denied. And I have seen what is possible when it is respected. The Cherokee Nation and the other recognized tribes in Oklahoma have experienced this success. The Cherokee Nation was able to rebuild because sovereignty was honored. The Wabanaki deserve the same opportunity. This is a step toward dignity, equity, and shared prosperity.
Thank you. If you can finish up in one sentence, please.
Yes. When in federal office, I will prioritize advancing and protecting tribal sovereignty so that all tribal nations are treated equitably under federal law. I hope Maine can restore and uphold their sovereignty so we don't have to hold that shame in the state any longer.
Thank you very much. Are there any questions, committee members? Not seeing any. Thank you.
Thanks.
I did want to let everybody know that we're going to take a brief 10-minute break. I know we've got the on deck circle here. And is there anybody in the on deck line that absolutely has to speak now because they have a commitment at home or elsewhere? No. Okay. So just remember your places and we'll be back at 20 minutes before 3. So a little bit less than 10 minutes. Committee members, excuse me, committee members, if you could please take your seats. We're about to resume our work.
85, holy cow.
Would the next person who was on deck please step forward? And could you please turn on the microphone? It's right in front of you on the desk. Up. Thank you. Thank you, Representative Sinclair.
Thank you.
Welcome.
Thanks. Senator Carney, Representative Kuhn, and members of the Judiciary Committee. Hello again. My name is Sage Phillips, and I'm a proud citizen of the Penobscot Nation. I'm also co-leading the Wabanaki Policy Youth Initiative, a group of Wabanaki and non-Wabanaki youth who are passionate about advocacy, policy, and tribal state relations. I'm here with many of them to testify in support of LD 785, an act to enact the remaining recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act. When I was a young child, I learned at an early age that my grandfather and elder, Butch Phillips, now ancestor, was on the 1980 Land Claims Negotiating Committee as a representative of the Penobscot Nation. Throughout our conversations, he would share stories about his time on the committee, what the negotiations were like, and what the intended outcomes were for the tribes. Every time we spoke of the Settlement Act, he was very clear to underline that from the start, this was said to be a living document, an agreement that the Settlement Act would be amended over time and change with the needs of our people throughout the years to come. I stand before you today, now 45 years later, urging you to support equality and fairness for our people that was promised to tribal negotiators and citizens. Our people are excluded from the 570 federally recognized tribes who have inherent self-governance and sovereignty in this nation. It is clear that per the 22 consensus recommendations put forward by the task force, the Wabanaki nations deserve to make their own decisions that are not supervised under the state's control. Our young Wabanaki people deserve to live in a world where their sovereignty is not questioned and their rights to self-governance do not waver. Even as youth, we understand that we must use our voices to take action that will benefit the future generations to follow in our footsteps, just as our ancestors have done for us. We ask that you respectfully join us by supporting LD 785. Thank you, and I'm happy to take questions.
Thank you for your testimony. Committee members, are there any questions? Oh, is your testimony, do you have your testimony in writing?
I submitted it ahead of time, but I think I might have accidentally registered to be here on Zoom.
That's fine.
But it has been submitted.
That's great. Thank you. We
Thank you.
very much appreciate that. Thank you.
Senator Carney, Representative Kuhn, Senator Talbot Ross, and other distinguished members of the Judiciary Committee. My name is Diane Olterzeski, and I live in Belfast. I'm speaking today in support of LD 785 on behalf of the Friends Committee for Maine Public Policy. As many of you know, we are a statewide group of Quakers working for right relationship between Indigenous and non-Native citizens of Maine. We are aligned with the advancement of Wabanaki interests for the betterment of all who live in Maine. With this latest, and we hope final iteration of legislation embodying the recommendations of the 2019 task force, Maine once again has the opportunity to free itself from misrepresentation of inherent Indigenous rights and to restore the full authority and protection of federal Indian law as it pertains to federally recognized tribes and nations in the United States. Several of us on the Friends Committee faithfully attended those day-long sessions of the task force over a 6-month period. At the outset, the non-Native members of the task force openly admitted to knowing virtually nothing about federal Indian law, and they had lots of questions and concerns. As the weeks and months went by, as each topic was presented, experts consulted, and questions answered, each task force member became more comfortable both with the proposed changes to the implementing act and with each other. The result was overwhelming agreement on all 22 recommendations to amend the state law. Proof that when you take the time to understand the issues and are able to see things from the point of view of the people most impacted, minds and hearts can open. It is time to remove the barriers that have kept the Wabanaki and their rural Maine neighbors from the economic resurgence achieved by tribes across Indian country. We appeal to each and every legislator to sustain this breakthrough of real justice and honorable dealing, to clear the stale air that has been hovering over Maine for decades, and with mutual respect and tribal state collaboration, breathe fresh, honest, hopeful air again. 785 ought to pass without exception. Thank you for your consideration.
Thank you for your testimony. Committee members, are there any questions? Not seeing any. Welcome. That's just right. Thanks.
Senator Carney, Representative Kuhn, and honorable members of the Committee on Judiciary. My name is Akuvi Komeja. I am a resident of Orono, a high school student, and a rural youth organizer for Just Me for Just Us, a rural youth nonprofit. I am writing in support of LD 785. When I was in 7th grade, I was asked to join a meeting and share what I'd been taught as a student about Wabanaki studies. I'm sad to say that my answers were short and scarce. My own experience was a confirmation of what many of my educators already knew. Wabanaki studies were significantly lacking in our school's curriculum. Following this meeting, which served as a wake-up call for me, I took it upon myself to learn more about Wabanaki culture and history in our state. I learned about the Wabanaki nations in our state and their deeply rooted historical connection to Maine's land and waters. But I also learned how through the 1980 Indian Claims Settlement Act, Maine has robbed the Wabanaki nations of their sovereignty for over 40 years, being the only state in the country that blocks Wabanaki nations from accessing federal programs and limiting their self-governance. We all can agree that the Penobscot, Passamaquoddy, Mi'kmaq, and Maliseet nations of Maine have persevered through many years of unjust treatment. But these tribes have also made endless contributions to Maine's culture, sustainable stewardship, military, local food systems, and much more, helping our state's culture, economy, and workforce to thrive. The question that I continue to ask is why is our state the only one in the nation that continues to deny its native tribes the self-governance that they deserve? Wabanaki sovereignty in Maine is long overdue, and I hope that our state will finally provide the Penobscot, Passamaquoddy, Mi'kmaq, and Maliseet tribes with the sovereignty and access to federal programs that every other federally recognized tribe in the nation has. For all reasons above, I urge you to vote ought to pass on LD 785. Thank you.
Thank you. Committee members, any questions? Not seeing any. Thank you.
Hi, Senator Carney, Representative Kuhn, and honorable members of the Judiciary Committee. My name's Nina Mitchell, and I'm a junior at Orono High School, as well as a rural youth organizer for Just Me for Just Us, and I'm writing in support of LD 785. At the beginning of my sophomore year, I had a teacher who assigned us a mini research project on Wabanaki sovereignty, which was my first introduction to this issue. This education didn't come until I was 15 years old. Later in the year, I got invited to join a Wabanaki sovereignty legislative team. This was a small group of students who researched Wabanaki sovereignty, came to the State House, and lobbied for Wabanaki history education. Coming into this project, I was one of the only students who had already understood this issue. We all grew up in Maine, we all went to school in Maine, and somehow this had never been part of the conversation. That gap in my knowledge told me something. If a kid who grew up here didn't know, something was wrong with how Maine was treating this issue. I recently held a testimony writing party at my school for this bill as well as LD 395. Only 4 students showed up and almost all of them already knew about the issue. This told me something. The kids who care are already here. There just aren't enough of them yet because Maine hasn't given them the education to know why they should be. Because the truth is, Maine structured the 1980 Indian Claims Settlement Act to override federal tribal law, leaving the Wabanaki Nations without a say over their own land. No other state does this. For over 40 years, these restrictions have blocked the Wabanaki Nations from accessing federal self-determination policies that have helped 574 other tribes across the country. Researchers project that tribal self-government would add $330 million to Maine's GDP annually, create over 2,700 jobs, more than half filled by non-tribal rural Mainers, and generate $39 million yearly in state and local tax revenue. When the Wabanaki thrive, rural Maine also thrives. For all of the above reasons, I urge you to vote ought to pass on LD 785. Thank you.
Thank you. Committee members, are there any questions? Not seeing any. Thank you.
Thank
your
you.
testimony. Welcome.
Hey, good afternoon. Senator Carney, Representative Kuhn, distinguished members of the Judiciary Committee. My name is Gia Drew. I'm the Executive Director of Equality Maine that has been advocating and advocates on behalf of Maine's LGBTQ plus community that makes up 10% of Maine's population. We are humbled to be part of the Wabanaki Alliance, and we strongly support LD 785 and its goal of restoring to the Wabanaki Nations many of the rights to self-determination enjoyed by other tribes. While not the same, LGBTQ plus people know a little about not having the freedom of living our lives authentically without government approval, oversight, or interference. For decades, the state of Maine has used the Settlement Act to deny Wabanaki Nations the same rights, powers, and privileges as the other 570 federally recognized tribes in the United States. I'm going to skip over some of the other items in here because you've already heard them earlier today, and it's been a long but very important day. In addition to being an affront to tribal sovereignty, this injustice has meant that tribes suffer unnecessarily from significant stifled economic development. We urge you to support this bill and vote ought to pass on LD 785. It is well past time to implement task force recommendations and remove the barriers that prevent the Wabanaki Nations from exercising their inherent right to self-govern. Thank you for your time and your consideration today.
Thank you for your testimony. Are there any questions for Gia Drew? Not seeing any. Thank you.
You're welcome.
Good afternoon again, Senator Carney, Representative Kuhn, and members of the committee. My name is Sean Mahoney. I'm with the Conservation Law Foundation, presenting testimony in strong support of LD 785. As I noted earlier today, I was here 6 years ago in support of, it's actually LD 2094. And in that testimony stated that there was much to be proud of as the state of Maine was about to celebrate its bicentennial this year. But our history with the Wabanaki tribes, for whom this land was home long before Europeans first set foot here, is a shameful one. We joined many other organizations in calling for the enactment of the unanimous representations of the task force that was encapsulated in LD 2094. Over the last 6 years, some progress has been made in moving towards such a relationship. And it's actually quite empowering, quite good news to hear how much conversation has happened between tribal leadership and the legislature and the governor's office over the last, just the last year, probably. But now it's time to finish the journey, and to finally adopt all of the recommendations of that task force. My organization does environmental law, so I can speak to the things that I have experienced over the last actually 2 decades. Over those last 2 decades, I've had the privilege of working with the Passamaquoddy tribe, the Penobscot Nation, and/or the Holton Band of Maliseet Indians on issues ranging from river restoration, mining, solid waste management, water quality, clean energy and transmission, fishery management, and land and ocean conservation efforts. In all of those efforts, across the board, the Wabanaki tribes and their professional natural resource staff approach the issues with a reverence and respect for our natural resources that is all too lacking in those who look to harness or exploit the resources outside of the Wabanaki nations. CLF continues to recognize and support the sovereignty and rights to self-determination of the Wabanaki nations, and believe that enacting the remaining recommendations of the task force contained in LD 785 is another step in the long journey back from the place of injustice, bigotry, discrimination, and physical and spiritual harm that the Wabanaki have suffered here in Maine. Thank you for the opportunity to testify.
Thank you. Committee members, are there any questions? I'll ask a question. Can you describe with some specificity, if you can, how sovereignty would impact environmental protection?
Well, I think if the more we could empower the Wabanaki nations to control the management and protection and restoration of their resources, the better for the state. So I could, would you like a specific example?
If one comes to
Sure.
mind.
A specific example is, there was a proposed metallic mineral mine for near the Katahdin Woods and Waters. And it was really the work of the natural resource staff of the Penobscot Nation that made the difference, I believe, in whether or not that project was going to be permitted or not. It made the difference before the Land Use Planning Commission. And I think we might be looking at a mineral mine on the edges of Katahdin Woods and Waters, a national monument, had it not been for the participation of the Penobscot Nation.
Thank you. Any other
Thank you.
questions, committee members? Not seeing
you.
any. Thank you for your testimony. Just in the basket, please.
In the basket.
Yep, thank you.
Senator Carney, Representative Kuhn, members of the Judiciary Committee. My name is Luke Sequeira Flanders. I am a public health worker in Bangor and speaking on behalf of Community Water Justice, a statewide network of communities working to build grassroots power and education to protect water for people, for the environment, and for future generations. 4 years ago, I spoke before this committee on LD 1626 in support of the bill. That was a predecessor of the bill before you today. This committee heard from over 1,500 of us speaking and writing in defense of tribal sovereignty. Fundamentally, nothing has changed since then. The moral necessity of this bill is as urgent today as when these recommendations were written 7 years ago. And the burdens resulting from the Settlement Act certainly have gone nowhere. Indeed, there has been historic progress in recent years toward building new relations between the state of Maine and Wabanaki nations. But looking through our history and considering the depths of poverty and dispossession that the state has subjected Wabanaki peoples to, one must recognize that incremental reforms to the Settlement Act do not constitute a resolution of the core tension at hand, which is that the state of Maine has entrapped Wabanaki tribes in a fundamentally unfair legal framework that denies their inherent sovereign rights as tribal nations. Before offering an opening prayer in the Senate chamber in 2022. Then Vice Chief Daryl Newell of the Passamaquoddy tribe at Madocnico said that tribal state relations are broken and irreparable until the state recognizes the sacred inherent sovereign rights of the Wabanaki. You'll see many youth in this room today. We're here because we've studied our history and are determined to end the state's paternalism toward Wabanaki people. This is a defining issue for our generation and a determining issue that will shape who we support in future elections. Allowing a status quo that places tribal children at poverty rates 3 to 5 times higher than the state average to continue is a stain on the reputation and legacy of this state's leadership. This struggle has spanned generations. Despite genocide and immeasurable loss, Wabanaki people are still here, building incredible futures for their communities. The question for this committee is whether these futures will continue to be built despite the state of Maine, or whether this will be done in partnership and collaboration moving forward. Today is my first time in the State House since Representative Jeffrey Evangelos passed on. I learned a lot about integrity, friendship, and solidarity from my conversations with him and observing his leadership in support of tribal sovereignty. As it has in the past, I'm hopeful that this committee will advance these recommendations and stand on the right side of history. I believe that, to quote the late Representative Evangelos, something wonderful is about to happen. Thank you.
Thank you. Just a moment. Committee members, are there any questions? Not seeing any. Thank you.
Thank you.
Senator Carney, Senator Kuhn, Legislative Committee, Judiciary Committee. My name is Bill Walker. I'm reading the testimony again of my fellow parishioner, Cassandra Wright, who could not be here today. I live in Orono and testify today on behalf of the St. James Episcopal Church of Old Town in support of LD 785, an act to enact the remaining recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act. We, as St. James Episcopal Church, approach the work of supporting Wabanaki sovereignty and self-determination as a fundamental issue of justice and striving to live out Jesus' directive to all his followers to love our neighbors as ourselves. In our baptismal covenant, we are asked if we will, quote, strive for justice and peace among all people and respect the dignity of every human being, unquote. Multiple books and passages of the Bible proclaim the imperative of humans to seek justice in all aspects of our lives. Extensive evidence has been presented today concerning the unjust provisions of the Implementation Act. Many of these injustices were identified and discussed during the Task Force on Change to the Maine Indian Claims Settlement Implementation Act. LD 785 proposes making law all the unaddressed recommendations from the task force process. Their enactment is long overdue. We cannot undo, but we can learn from it. Let's look at the relevant historical event that happened over 250 years ago while Paul Revere was making his famous ride in April of 1775. Trouble was also brewing some 300 miles north in the village of Machias. That summer, Loyalist merchant ships arrived accompanied by the sloop Margarita Townspeople tried to arrest the captain who escaped. Two ships, one captained by Jeremiah O'Brien, overcame the Margaretta, and the settlers won the first naval battle of the Revolution. The settlers had some pivotal assistance in this landmark battle. The Passamaquoddy supported this effort and helped in the capture of the ship. 50 of them, led by Captain Selmore Soktoma, then captured a British schooner and brought it to Machias to add to the growing settler fleet. Both O'Brien and Soktoma went on to play major roles in the fight for independence. It is important to note that the Wabanaki have always served in America's military in positive and disproportionate numbers.
Mr. Walker, I'm sorry to interrupt. Your time has elapsed. Could you finish your testimony in just a sentence or two, and we'll be sure to review your written submission.
Sure. Let's do the last paragraph here. This war for independence brought an end to the oppression of a foreign government and resulted in sovereignty for the American settlers. However, homemade colonialism continues to oppress the Wabanaki nations. In the 250 years since our ancestors fought together in the bay at Machias, the Wabanaki have suffered genocide, dehumanization, broken promises, the removal of children from their homes, and the lack of access to support from the federal government.
Thank you.
Despite everything done to the Wabanaki, they have survived, demonstrated incredible resilience and faith to their ancestors and future generations.
Thank you. Let's see if there are any questions. Committee members, any questions? All right, thank you very much.
Thank you.
Senator Carney, Representative Kuhn, and members of the committee. My name is Anthony Irwin, and I'm Maine Audubon's policy advocate. Since 1843, Maine Audubon has worked to conserve Maine wildlife and wildlife habitat by engaging people in education, conservation, and action. On behalf of Maine Audubon and our 30,000 members, supporters, and volunteers, we thank you for the opportunity to submit testimony in support of 785. As you've heard today, the Maine Indian Claims Settlement Act has kept the Wabanaki nations from benefiting from more than 150 federal laws, and for more than 40 years, the Wabanaki nations have endured a different, more restrictive status than all 570 other federally recognized tribes throughout the United States. LD 785 would help rectify these wrongs. This bill is designed to restore many of the rights to self-determination that the Wabanaki nations have not benefited from. Importantly, it recognizes the exclusive authority to regulate fishing, hunting, trapping, and other natural resources on Wabanaki lands. Maine Audubon strives to engage people in the conservation of wildlife and wildlife habitat. And the Wabanaki people have been protecting the environment and maintaining sustainable ecological practices for thousands of years, long before European settlement in Maine. They would continue to do so in enacting the remaining recommendations of the 2019 task force, allow for the Wabanaki nations to exercise their rightful authority over tribal lands in line with all the other federally recognized tribes in the United States. I'll end with that. We strongly encourage this committee to vote in support of LD 785, and thank you for your consideration.
Thank you. Committee members, are there any questions? No, thank you.
Good afternoon, Senator Carney, Representative Kuhn, distinguished members of the Joint Standing Committee on the Judiciary, and a shout out to Senator Talbot Ross. I'm Eliza Townsend, Maine Conservation Policy Director for the Appalachian Mountain Club. As I mentioned this morning, Our mission is to foster the protection, enjoyment, and understanding of the outdoors, and we own 127,000 acres of forest land in the 100-mile wilderness section of Piscataquis County, which we manage for multiple use. We support LD 785 to establish that the Passamaquoddy tribe, the Penobscot Nation, and the Holton Band of Maliseets enjoy the same rights, privileges, powers, duties, and immunities as 570 other federally recognized tribes in the United States. Further, by ensuring that the tribes can benefit from the 151 federal laws passed since the 1980 settlement, LD 785 has the potential to bring much-needed resources to our state. We recognize that the status of the tribes under the 1980 settlement has led to significant conflict in the past 4 decades, particularly over issues of environmental protection. The Wabanaki make clear that their identity and culture are inseparable from the lands and waters that have sustained them for 10,000 years. We are confident that they can steward those resources as well as the state of Maine has done. We especially support the provisions of LD 785 that address the regulation of natural resources. And it was music to my ears to hear the chair of the Board of Environmental Protection say much the same thing. The 1980 settlement created a process for the tribes to expand their land holdings in Maine and set aside federal funds for that purpose, but the tribes have not acquired the agreed upon acreage. This bill addresses several obstacles so that the tribes can acquire more land, as agreed to by all parties nearly a half-century ago. No document is perfect. The United States Constitution, which has been amended more than 24 times, is just one example. In 2026, it is appropriate to recognize the shortcomings of the 1980 land claims settlement and to improve upon it. We ask you to support LD 785. And if I could freelance on the topic of environmental protections, Representative, today, the endangered Atlantic salmon are able to reach their historic headwaters at Gulf Haggis in Piscataquis County, adjacent to our land, for the first time in nearly 200 years. That is a result of the Penobscot River Restoration Project, which was led primarily by the Penobscot Nation, with the foresight of John Banks, who was their Director of Natural Resources. When Europeans arrived, cod were plentiful along the coast of Maine and across the coast of New England. They depleted since European contact. The nature of our forests has changed substantially since European contact. So those are all examples of ways in which I think it is appropriate to take the leap of faith that our fellow human beings can do at least as good a job.
Thank you. Thank you for sharing that information. Are there questions, committee members? Not seeing any. Thanks.
Good afternoon, Senator McCarney, Representative Kuhn, and members of the Judiciary Committee. My name is Peter Garrett, and I live in Winslow, and I'm here to testify in support of LD 795. I am a relative newcomer to Maine, having come from England, yet married a descendant of a passenger of the Mayflower. I've delved into Maine history enough to realize that the colonization of North America by Europeans does not represent a pretty picture. Guns, germs, and steel benefited the colonizers, not the native peoples, and I've been hearing all kinds of things, as you have today, that it's not just guns, germs, and steel. My wife and I own hundreds of acres of beautiful land in Winslow. We often think this beautiful land was once Wabanaki land, and we wonder how we can share with our neighbors in ways equivalent to the Wabanaki way of owning but not sharing land. Sorry, not owning, but definitely sharing land. We do so to the extent that we can, and we're now making arrangements to donate our land to the Sebasticook Regional Land Trust under a conservation easement. Though your predecessors in the legislature worked on the Maine Indian Claims Settlement Act in 1980, Yet tribes in Maine have been unable to benefit from more than 150 federal laws. You've heard all that before today. However, your predecessors called the 1980 Settlement Act a living document, expecting revisions would come as necessary, as I think you've heard again today. I trust that LD 785, I beg your pardon, will achieve what is necessary. And I'm not alone. More than 1,600 Mainers testified in support of tribal sovereignty legislation based on the consensus recommendations of the bipartisan legislative task force. By the way, I'm so glad, Senator Ross, to see that your bill is very bipartisan. I really appreciate that. So it's not time to remove the barriers that kept the Wabanaki from their rural Maine neighbors from the economic resurgence achieved by tribes elsewhere. Thank you.
Thank you for your testimony. Are there any questions, committee members?
Thank you.
Not seeing any. Thank you.
Good afternoon, Senator Carney, Representative Kuhn, members of the Joint Standing Committee on Judiciary. My name is Martin Chartrand, and I'm here also in support of LD 785. As I mentioned this morning, I'm a lifelong Mainer, and I really love our wild natural places, our lakes and rivers, our springs and summers, and even the falls and winters, and our unique local crops like blueberries and the creative spirit of so many of our residents. I know I'm a newcomer and guest here, and the Wabanaki are my gracious hosts. They cared for and sustainably harvested this land's wildlife and non-human gifts for thousands and probably tens of thousands of years before any of my European ancestors touched this continent. They taught the earliest settlers how to navigate the lakes and rivers, how to survive the winters, how to tend and harvest the native plants and hunt the animals for food. In short, Maine would not be Maine without the Wabanaki. Yet, let's be honest, Maine has visited a legacy of harm upon the Wabanaki. From the Spencer Phipps Proclamation of 1755, which put a bounty on their heads of the Penobscot Nation, to being pushed off land that was never ceded, like where I live in Lewiston, in order to make room for Maine's industries, to the 1980 Settlement Act, restricting the remaining tribes' ability to self-govern. I'm autistic. I don't want to say in any way that I know the experience of Wabanaki people. I can resonate, though, with the dull anger and the undermined confidence that come for me when someone else who doesn't know my experience tells me what is good for me. I believe in, and in my work now with youth, I aim to support self-determination. I'm here to support the same for the Wabanaki. I support their full sovereignty, and I support any and all priorities and strategies that they choose to use to put this forward. Respecting the Wabanaki Nation's right to self-govern will unleash the Wabanaki's full creativity and resourcefulness that we already see despite that. And it will help us as settlers begin to heal the historical injustices we have been part of and move towards right relationship with this land of the dawn and its people. So I urge you to vote ought to pass. Thank you.
Thank you. Committee members, are there any questions? Thank you.
Good afternoon, Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. You heard from me this morning. I'm happy to be here before you again. My name is Abby Farnham, and I'm the Assistant Director of Policy and Research at Maine Farmland Trust. I'm providing testimony on behalf of MFT in support of LD 785. Maine Farmland Trust is a member-powered statewide organization that works to protect farmland, support farmers, and advance the future of farming. Our goals are to keep agricultural lands working and help farmers and their communities thrive. Equitable access to land and the ability to produce food, as well as fair distribution of and access to resources, are key to the future of farming in Maine. MFT supports LD 785 because recognizing the inherent rights of the Wabanaki nations to self-govern is a matter of fairness and equity for Wabanaki communities and is essential for restoring the tribe's rights and abilities to access and steward land, regulate natural resources and land use on tribal lands, and provide for the needs of their communities. MFT also supports this bill based on our understanding that the Wabanaki Nation's ability to thrive economically will have positive impacts that extend to rural communities across Maine, as was documented in the Harvard report that you've heard a good deal about today. LD 785 would implement changes to the Maine Indian Claims Settlement Act that were recommended by a bipartisan task force, and in doing so, ensure the Passamaquoddy tribe, the Penobscot Nation, the Micmac Nation, and the Holton Band of Maliseet Indians enjoy the same rights and authority as other federally recognized Indian tribes across the country. These recommendations include restoring the tribe's rights to regulate hunting, fishing, natural resources, and land use on tribal lands and waters, as well as removing some of the barriers the tribes have faced in acquiring land, including trust land. Economic activity on Wabanaki trust land has primarily consisted of natural resource management, including through several Wabanaki-run agricultural operations. A 2022 report by the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations also describes how for many Indigenous communities in Maine, the benefits of local food production lie in Wabanaki people's ability to maintain ancient land-based knowledge and practices, restore ancestral relationships with the land, and support community members who struggle with food insecurity and food-related illnesses. LD 785 would advance fairness and equity for the Wabanaki nations and strengthen Wabanaki land access and stewardship opportunities, opening up potential for the tribes in Maine to sustain and grow agricultural operations and continue to contribute to Maine's broader agricultural community and economy. This bill would also help to honor and uplift the abilities of the Wabanaki nations to provide for the food security and cultural needs of their communities while strengthening the economic resilience of rural Maine. For all these reasons, we urge you to support LD 785 and restore the sovereign rights of the Wabanaki nations to self-govern. Thank you.
Thank you. Committee members, any questions?
Thank you.
Thank you.
Good afternoon, Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Luke Frankel, and I'm the Woods, Waters, and Wildlife Director at the Natural Resources Council of Maine, or NRCM. NRCM is a nonprofit, nonpartisan membership organization dedicated to protecting, restoring, and conserving Maine's environment now and for future generations. On behalf of our nearly 20,000 members and supporters, I'm here today to testify in support of LD 785. For more than 65 years, NRCM has worked to safeguard the woods, waters, and wildlife across what we now call Maine. Through this work, we recognize and honor the Penobscot Nation, Passamaquoddy Tribe, Micmac Nation, and the Holton Band of Maliseet Indians who have stewarded these lands for time immemorial. It is well past time for the state of Maine to recognize the inherent sovereignty of Wabanaki people and restore the full rights to self-determination. We are proud to have worked with the Wabanaki nations on many important environmental initiatives over the years. These include efforts to restore fish passage on the Penobscot and Kennebec rivers, a campaign to oppose a poorly planned mine in the Katahdin region that would have threatened water quality on tribal land, multiple initiatives to stop the flow of out-of-state waste into Maine, and more recently, an effort to provide Wabanaki representation on the Land Use Planning Commission, the Planning and Zoning Authority for Maine's 10.4 million acres of unorganized territory. We are deeply grateful to assist the Wabanaki nations in their effort to protect the forests, waterways, and wildlife that are central to their culture and sustenance practices. However, despite the environmental progress that has been made, it remains true that the federally recognized tribes in Maine have limited regulatory authority over the natural resources that sustain them. By enacting several of the consensus recommendations on the task force on changes to the Maine Indian Claims Settlement Implementing Act, LD 785 would restore the exclusive authority of the tribes in Maine to regulate natural resources on their lands. This would allow the Wabanaki people to continue stewarding the environment through sustainable ecological practices in line with their culture as they have done for millennia. This environmental aspect of LD 785 is just one part of a much larger picture. Recognizing the inherent sovereignty of Wabanaki people is about fairness, justice, and respect. After a long history of broken treaties, forced relocation, and genocide dating back to the first colonial settlements in New England, the time to correct previous injustices is long overdue. By restoring full sovereignty to the Wabanaki nations, as this bill would do, this committee can take a critical step forward toward correcting the wrongdoings of the past. As a proud member of the Wabanaki Alliance, NRCM is committed to actively using our voices, resources, and power to support our Wabanaki partners in their pursuit of sovereignty. to help build a Maine that is more just and to ensure that our natural resources can be stewarded as they have for millennia. We urge the committee to vote all to pass. Thank you for your time and consideration. I'll gladly answer questions that you have.
Thank you for your testimony. Are there any questions, committee members? Not seeing any. Thanks.
Thank you.
Senator Carney, Representative Kuhn, and esteemed members of the Judiciary Committee. My name is Eli Dren McDonald. I'm from Bar Harbor, and I work as a policy director at Maine Youth Power, a youth-led youth movement working throughout rural and suburban Maine to win human dignity, equity, and a livable future for all. Maine Youth Power is also a proud member organization of the Wabanaki Alliance. Today, I'm testifying on behalf of my organization and our members in support of LD 785. At the start of this legislative session, we surveyed more than 100 of our members from all across the state, asking what legislation they would like to see prioritized. As responses began to stream in, it soon became clear that the expansion of Wabanaki sovereignty was a top priority, as it had been in previous years. Our members saw the urgent and long overdue need for Wabanaki nations to determine their own futures and to benefit from crucial federal laws. Simultaneously, the sentiment is not just shared by young people. There's massive bipartisan support in the State House, across businesses and organizations, and within our neighborhoods that we need to rectify the antiquated Settlement Act, which unfairly constricts the Wabanaki nations. As I noted in my introduction, and as echoed by our member responses, Maine Youth Power envisions a future with human dignity, equity, and a livable future for all. In perfect alignment with that vision, LD 785 would finally allow Wabanaki nations the right to self-determination and remove significant hurdles to a new era of growth. I think many people have touched on this, but it's impossible to highlight every positive feature of this bill in 3 minutes. But as an organization focused on making sure young people thrive, we're especially passionate about the effect this bill would have on Wabanaki youth. As the Wabanaki Alliance notes, and I'm sure as you've heard today, childhood poverty in Wabanaki communities ranges from 40% to 77% compared to Maine's overall rates of 15%. The economic ripple effect that would be created by passing LD 785 would be crucial to addressing such a massive and unfair disparity affecting Wabanaki youth. We know it is time to act and time to do the right thing. I urge you to support LD 785.
Thank you for your testimony. Are there any questions? Not seeing any. Thank you.
Hello again. Senator Carney, Representative Kuhn, and respected members of the committee. Hello again, my name is Jackson Chadwick. I am the Advocacy and Organizing Director at Maine Youth for Climate Justice, another Maine Youth advocacy organization, and I live in Bangor. On behalf of MYCJ and our members, I am testifying today in strong support of LD 785. We see this bill similar in purpose to LD 395. This bill is also about respect and fairness for the Wabanaki nations. And if passed, it would implement the remaining recommendations of the 2019 task force. As I mentioned earlier, we believe that climate justice is inseparable from Wabanaki self-determination. The settlement acts weren't just a legal failure, but an environmental failure as well. The settlement acts were supposed to provide the Passamaquoddy and the Penobscot with a federal pathway to reacquire thousands of acres of trust lands. To date, this hasn't fully happened for either tribe, nor did the settlement acts extend that provision to the Holton Band of Maliseets or the Mi'kmaq Nation in the first place. I'd like to bring your attention to LD 2007 from the 131st Legislature. That included several of the consensus recommendations of the 2019 task force, and it amended the settlement acts to give the Wabanaki nations more opportunities to pursue and acquire conservation and trust lands without state or local government approval. That was a very welcomed change, but that took 44 years to achieve, 44 years. And I think it highlights the broader issue of the status quo, where each of the task force's recommendations is considered separately or in very small batches. And that's why LD 785 is so important. It doesn't take a piecemeal approach, but a fair and respectful one that matches the moral responsibility I think we owe to our tribal nations. The settlement acts were designed to evolve, as many have pointed out today, not to remain static documents. When things are wrong, when things could be better, we have a responsibility as people to correct those wrongs as best as we possibly can and better the mistakes of the past. And we look to you as legislators to help make that happen. So once again, we please ask you to support LD 785. Thanks for considering our testimony, and just want to thank the committee for all the attention and work you're putting into this issue. Thank you.
Thank you for your testimony. Are there any questions, committee members? Not seeing any.
Thank you.
Thank you. Is there anyone left in the room who would like to testify in support of this bill? Please come right up.
Thank you, Representative Kuhn, distinguished colleagues on the Committee of Judiciary. Good afternoon and Ramadan Mubarak. My name is Ambreen Rana. I represent House District 21, which includes Bangor, and I'm here to testify both in support of LD 785 and 395, just briefly. Maine is an outlier in tribal state relations. It has long past time to lift the restrictions imposed by the Maine Indian Claims Settlement Act and the Implementing Act. Maine was one of the first states to generate a treaty of this kind with the federal government and the tribe. This treaty was meant to be a living document, yet since the 1980s, no changes have been made. So of course, it only makes sense to look back and see where there's room for updates. Because of the way the treaty was originally written, Wabanaki nations have largely found themselves unable to benefit from federal funding the way that other tribes in the country have. As is always the case with sovereignty, we want to create parity. The Wabanaki nations should benefit from federal laws and funds just as any other federally recognized tribe across this land does. We talk in this building often about how we can close gaps and reduce disparities. These bills are another step towards combating the existing inequalities that we have allowed for far too long in the state. These bills are decades in the making, as you've seen from testimony that has come before me, as you've seen as members of this committee. It is time for us as the legislature to take the lead in righting the wrongs of the past. These bills are steps towards healing our state's government relationship with the tribes. Ultimately, we are guests on this land. It is our responsibility as lawmakers to continue to honor the original stewards of this beautiful land, the Wabanaki nations, by passing laws that help create this parity. From first contact on this land, people indigenous to the Americas have endured unconscionable devastation at the hands of colonization. It is our responsibility to have a hand in putting an end to this harm. Any delay on our part brings us closer to the completion of the erasure of these people. Wabanaki nations are sovereign nations, and they must be treated as such. I urge the committee to vote ought to pass on both of these measures. Thank you so much.
Thank you. Are there any questions for Representative Rana? Not seeing any. Thank you. Is there anyone left in the room who'd like to testify in support? Please come right up.
Hello, my name is Laura B. Noble, and I live in Brewer, Maine. I'm here to speak in support of LD 785. This is a bill whose time has come. It's time to update the living document created and so named as the 1980 Settlement Act. You who sit on this committee have the opportunity to repair some of the harm that this broken deal created 46 years ago. A bipartisan task force has already done the deep and powerful work of finding 22 recommendations that they could agree on by consensus. The bill was co-sponsored by a bipartisan group of more than 100 legislators. In this day and age, that's fabulous. We should celebrate that work and all of everybody who put their time in to make that happen. Consensus means this opinion of support was reached by a group as a whole. What does it mean? The dictionaries pull up ideas around agreement, accord, and from the past participle of consentir, to feel together, and from the assimilated form of calm, meaning with and together.
The Latin word sensus, perception, undertaking, meaning, sentir, to perceive, feel, and know. We know what is right. We know what is justice. Consensus has already been reached. Researchers already project that tribal self-government would add millions annually to Maine's GDP. How amazing and fantastic. Passing this bill would be a win, 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 win. Let's do this. Thank you for your time.
Sorry. Any questions, community members? All right, not seeing any. Thank you. All right, is there anyone left in the room who'd like to testify in support of this legislation? Please, please come right up.
Good, I hope it's not evening. Good afternoon, Senator Carney, Representative Kuhn, members of the Judiciary Committee. My name's Amy Winston, and I live in Edgecombe, and I'm testifying today on behalf of CEI Coastal Enterprises. We're an economic development organization, a community development financial institution based in Brunswick, and our work is building a just, vibrant, and sustainable economy for people and communities in Maine and rural regions. And we do this by integrating finance, business expertise, and policy solutions. We strongly support both LDs 395 and 785. We've long worked with Four Directions Development Corporation, a native CDFI based in Orono, and I serve as the CDFI representative on the Maine's Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations. The Permanent Commission has prioritized tribal sovereignty and for its ability to advance racial equity and economic justice in Maine. And in 2022 and 2024, we testified in support of LDs based on the basis of the economic benefits of self-determination. You've heard a lot of testimony today. I just got here, but I've been listening all day on audio. And so talked about disparities and persistent poverty in tribal communities, and the lack of the legal basis for sovereignty that is asserted by both bills. They would provide needed access to capital that would allow communities to build infrastructure and institutions, start and sustain businesses, provide health and social services, education, and job training. These are critical to rural prosperity, and they will be critical, as others have said, to all of Maine, not just the tribes. I submitted written testimony online through the portal, and so I did cite sort of literature and the economic impact studies that other folks have cited. Those are really significant impacts for all of Maine, and that really depends on Maine's ability to engage with the Wabanaki tribes in a government-to-government fashion in a way that will really yield economic benefits and also cultural benefits. I also noted, like many other tribes have used tribal self-government, and they are like cruising and manufacturing, retail, cultural tourism, generating a lot of jobs and increasing incomes for both tribal and non-tribal residents. So just driving that point home. For 4 decades, almost 5, our organization will turn 50 next year. And we've been working in economic development and have really learned that when local people are empowered to exercise agency over their own livelihoods, people's lives improve, businesses grow, and communities flourish. This bill was, sorry, I see my time's up, so I just wanted to close by saying, I know these are the recommendations of a task force that was set up for this purpose. So really just driving home that and that these are bipartisan bills. So thank you for the opportunity to provide an economic development or community development perspective. And I just support both bills.
Thank you for your testimony. Are there any questions? Not seeing any.
Okay.
Thank you.
Thank you so much.
All right, it's last call here in the committee room. Is there anyone left who'd like to testify in support of this legislation? Is there anyone who would like to testify in opposition? All right, and is there anyone who'd like to testify neither for nor against? All right, Just one moment. Okay, we're going to move over to the folks who have been waiting on Zoom. If you are on Zoom and you'd like to testify in support of this legislation, please raise your electronic hand and leave it raised. And you will be moved over to the panel to provide your testimony. Okay. You'll be provided a prompt that you need to accept in order to move over to the panelist screen. All right, first we have Kevin Slater. If you could please activate your camera. Hello. Oh, I believe you're muted. We're unable to hear you.
Can you hear me now?
Yes, we can. Please go right ahead.
All right. Hello. First, I'd like to thank members of the committee, Senator Carney and Representative Kuhn, for all the time and energy you put into this very important topic. My name is Kevin Slater. I live here in Newry, Maine. I run Mahoosic Guide Service along with Polly Mahoney, and I'm here to testify in support of both LD 785 and 395. So a long time ago, I did my student teaching on Indian Island, and I'm fortunate to this day still have many friends that are Wabanaki. And so I've seen firsthand how it's affected some of my friends, the effects of the 1980 land claim settlement. It's not just facts and figures to me. You've gotten plenty of them today. I can't really add anything else to that. But what I would like to point out is it's not just a piece of new legislation that you'll be voting on. You are basically making a very important moral decision. And the question is it morally right to deny the Wabanaki the same tribal sovereignty rights that all the other First Nations have? And I think most of you know the answer to that question. I've watched all the testimony today, and the reasons for why it should pass as opposed to any concerns or reasons why it shouldn't pass, it's greatly outweighed in favor of why it should pass. So the root word that in Wabanaki, Waban, means the dawn. The dawn is a new beginning, a new day. Maine needs a new beginning with its Wabanaki people, okay? And the way we get that new beginning is to pass both LD 785 and 395. Thank you very much for the opportunity to offer my opinion. Appreciate it.
Thank you. Committee members, are there any questions? Not seeing any. Thank you for your testimony.
Yep.
Next, we're going to have Dan Bergen. If you could activate your camera, please. Welcome.
Hi, can you hear me?
Yes, we can.
And it's Berger, Berger, depending on what side of
Oh.
the border you're on, I guess. But no, you could. Dan Berger. Hi.
Apologies.
It's okay. Senator Carney, Representative Kuhn, and members of the Committee on Judiciary, and a special walala and thank you to Senator Talbot Ross. Gwe, Nindaluisi, Dan Berger. Hi, my name is Dan Berger. I'm a direct maternal descendant of the First Nation Mi'kmaq through Madeline Angelique of Gallaudet, Signet, Mi'kmaqi, the meeting of two rivers in the drainage district of Mi'kmaqi, what we now call Caracat, New Brunswick. My grandmothers have lived on these lands since time immemorial. Wedabexi Mahukanuk Amisohendeg, Bosnawigi Huzik. My roots are from the people of the waters that are never still, place where the small fish are caught, but I live in the beyond place. We now call Hoosick North Adams, Massachusetts, and we now call Mahuckanock and Missahendek the Fish Creek in Schuylerville, New York, which lies on the traditional borders of the Mohican and Abenaki peoples. It is where my grandmothers are buried, and where in the archaeological record we see documented year-round habitation of Algonquian peoples, of whom my Mi'kmaq ancestors belong culturally and linguistically, as well as the Greater Wabanaki Confederacy of the Abenaki, Penobscot, Wolastoqey, Passamaquoddy, and the Mi'kmaq collectively. One of the only acknowledged year-round habitations, at least that I found in this area. How is this relevant to me? My family members are direct maternal descendants of Madeline Angelique, a member of the First Nation Mi'kmaq, who are our closest maternal relatives when it comes to our mtDNA, our mitochondria. Descendants of the daughters of the wife of Chief Madagawando, members of the Penobscot, considered the quote-unquote Eastern Abenaki. Where is there another place named Amisohendeg? Along the Sandy River in Farmington Falls, Maine. There's a creation story in the Wabanaki tradition of the first mother, the Corn Mother, walking these riverbeds and sacrificing herself, giving us the crops we were able to grow to sustain ourselves and our families for generations. The fact that my grandmothers ended up back down in Amisohendeg, where they operated a boarding house along the Champlain Canal, and where my mom was a librarian for 30 years, seems like no small coincidence. They were living in the Abenaki equivalent of our Penobscot sisters in Amisohendeg, living in a place and being buried where one of the few acknowledged year-round Algonquian settlements I've found is located, in the tradition of our grandmothers since time immemorial. I also point you all toward the stories of Madeline Angelique and the daughters of Madakawando to help conceptualize what our Wabanaki grandmothers were doing in their lives. They lived during a time when the Council of Grandmothers was operating in a real way. They had a real role in domestic affairs and way more of a role in the matriarchal societies they were born into than our European counterparts would like to let on. Our maternal ancestors specifically helped give refuge to the fleeing Acadians, whose descendants, myself included, still frequent the shores of Caracat, being there as a refuge as we have for generations. They also dispatched war parties, were active in diplomacy, were catalysts for treaties, and were in charge of shared resource protocols of the area, and I could go on. It is in this spirit that I reach out, as my ancestors have reached out before me. Joseph Orono, the hereditary chief of the Penobscot during the Revolutionary War, is my maternal cousin. We share a common maternal ancestor and a common cause. In 1775, Orono pledged to fight alongside the Americans. The following year, on July 19, 1776, the Treaty of Watertown was signed by delegates from the Mi'kmaq and Wolastoqey, uniting the Americans with our Wabanaki communities and binding us to the common fight for freedom. When the fisheries in the Chaleur Bay that my family were associated with began to be raided by American privateers in 1777, Madeline Angelique's greater kinship networks would have been involved in these resistance efforts. I'm not the only person with Mi'kmaq ancestry who has stories like these. When the international and state borders were drawn that we are now forced to cross, many of the sacrifices of our communities were muddied and forgotten. We all deserve, all of us Wabanaki, not just as the first allies of this nation and as the First Nations of these lands, but just as people. We deserve the same dignity and respect of all of the federally recognized tribes. Our ancestors did not sacrifice for this, and our current and future generations do not deserve to suffer. This is why I write and implore you to support LD 785 and Act 2 enact the remaining recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act.
Thank you. Thank you for your testimony. Let's see if there are any questions from committee members. I'm not seeing any. Thank you.
Well, Aliak, I thank you all.
Thank you. All right, next up, we have Maggie Summers. Hello.
Hello again. Thank you so much for having me again, Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee. It's lovely to see you again. My name is Maggie Summers, and I'm the Outreach Director at Maine Conservation Alliance, and I'm reading this testimony on behalf of our Legislative Director, Sarah Woodbury. And I gave some more information about Maine Conservation Alliance in the submitted testimony, but we've all been here for a long day, so I'm just going to let you guys read that. But amongst other things, Maine Conservation Alliance is the facilitator and a member of the Environmental Priorities Coalition. And today I'm testifying on the coalition's behalf in support of LD 785. The Environmental Priorities Coalition is a statewide alliance of 40 conservation, climate, and public health organizations. Every year, we collectively identify a slate of policy priorities to act on the climate crisis, advance environmental justice, protect land, water, and wildlife, and cultivate healthy Maine communities. And LD 785 is one of these priorities. The EPC supports 785 because it is long past time to recognize the sovereign rights of the Wabanaki nations. We know that Wabanaki sovereignty is central to protecting the air, land, water, and our shared future, climate future in Maine. And beyond that, Wabanaki people predate the United States, predate the state of Maine, and hold inherent rights to self-govern. For the last 40 years, however, the MISCA and the Implementing Act have restricted the Wabanaki Nation's ability to regulate land use and natural resources on their own lands. The state of Maine has used these acts to limit Wabanaki self-determination in multiple ways, harming the tribes, putting public health and the environment at risk, and leading to legal disputes. We've heard arguments before that environmental protections could become weaker, while at the same time, we've heard concerns that they could become more stringent. These opposing claims stem from a lack of understanding, fear of losing control, and a fear of change. Those of us who have worked closely with our Wabanaki neighbors know that these fears are not grounded in fact. Wabanaki people have lived in the Dawnland, now called Maine, for thousands of years, maintained a close relationship with the land and the water, and protecting natural resources so that future generations can thrive. But at the end of the day, it is not for us or industry or the state of Maine or anyone else to judge what tribes may do on their lands or decide whether their rights should be restored based on those predictions. These rights are inherent and they're not for any government to grant or revoke, including the US and the state of Maine, which have only existed for a blink of an eye relative to the Wabanaki nations. This is a principle that's recognized across the country, and it's time for Maine to do the same. The Wabanaki people are the original people of the place that we now all call home, and so 785, based on bipartisan recommendations, would restore their inherent rights of self-governance and help set tribal-state relations right. There's no better way to protect lands and waters in Maine than to restore Wabanaki sovereignty. And
Thank
so
you for your
that,
testimony.
yes, the EPC urges you to vote ought to pass. Thank you so much.
Thank you. Let's just see if there are any questions from committee members. I'm not seeing any. Thank you for your testimony. Next, we have James Mayall. If you could activate your camera, please. Hello.
Hi, good afternoon, everyone. Good afternoon, Senator Carney, Representative Kuhn, members of the committee. My name is James Mile. I'm a policy analyst at the Maine Center for Economic Policy. I'm here to testify in support of LD 785. MISA believes that recognition of Wabanaki sovereignty is a long overdue moral imperative for Maine and an economic development tool that will benefit all of us. MISA's recent report, Sovereignty Starts Here, Land, Economy and Tribal Rights in Maine, lays out this moral and economic case. We find that over the course of 2 centuries, Maine has benefited to the tune of hundreds of millions of dollars in land sales, tax revenues, and the sale of natural resources like timber from Wabanaki lands. None of that has gone back to Wabanaki nations. Cumbersome state laws under the Settlement Acts and the need to get local and legislative approval have stymied Wabanaki efforts to purchase the 200,000 acres that was envisaged in the 1980 settlement. Tribal nations with full recognition of their sovereignty have seen much higher rates of economic growth in both the United States and Canada. As you've heard before, in the US, per capita incomes on Indian reservations have grown more than 6 times faster than per capita incomes in Wabanaki Nation since 1989. What's more, evidence from Canada shows that areas in which First Nations could exercise more autonomy saw faster income growth for non-Indigenous as well as Indigenous residents. Across the United States, 344 federally recognized tribes operate more than 5,500 businesses in a variety of sectors. These tribal enterprises can employ hundreds of non-native people, attract investment, and provide much-needed economic development to rural areas. While many people think of casinos or other gaming operations, there are plenty of examples of other successful tribal enterprises in tourism, conservation, and conscientious resource management. These efforts build on thousands of years of Indigenous knowledge and a deep sense of connection to the land. Meanwhile, here in Maine, the Settlement Act's restrictions on federal law hurt the Wabanaki nations and by their neighbors by cutting them off for millions of dollars of federal grant funding every year. LD 785 should not be controversial. It corrects a historical injustice that should not have been allowed to persist for 200 years. It is the result of the work of a bipartisan task force and has the support of many of your fellow legislators. If any more reason we're needed to support this bill, we hope that MECEP's research confirms that when the Wapanaki thrive, all Mainers thrive. I would urge you to vote all to pass on LD 785, and I'm happy to take any questions.
Thank you. Committee members, any questions? Not seeing any. Thank you for joining us. Paige Johnson, I believe you have your hand up. If you wish to testify, you need to accept the prompt that's been sent to you. Okay, great. If you could activate your camera, please. Hello, welcome.
Hello, sorry, it always lags for me with the invitation. Good afternoon again, good evening almost. Thank you for the time. Senator Carney, Representative Kuhn, and members of the Judiciary Committee. I'll be brief because I spoke earlier today. My name is Paige Johnson. I'm a resident of Winslow, Maine. I'm testifying in favor of LD 785 on behalf of Healing First and as an individual. Healing First, part of our vision includes a world in which pathways for justice and healing are widely accessible for everyone. And that includes collective liberation and upholding and actively investing in the inherent tribal sovereignty of all Indigenous peoples. Something that has stood out to me is learning more about the 1980 Settlement Act and hearing that politicians who drafted that had called it a living document, which to me signifies that it's intended to be updated and to evolve. And so for this law, it's meant to be amended. I think to call something a living document and to not end up amending it is a way of essentially it's been weaponized against the population of Wabanaki people and being able to truly and fully experience their inherent tribal sovereignty. And so I think harm's been done, and 40 years later, it's time for this to be amended. There's a lot of statistics in my testimony that I would speak to that have already been shared today about childhood poverty in particular, as well as the Harvard Project on American Indian Economic Development study data that projects that $330 million annually would be added to Maine's GDP if this were to, pass and move forward, benefiting the economy for really everyone in Maine. So when Wabanaki thrive, the rest of rural Maine and the rest of us do as well. And I think I just want to encourage us to really imagine if instead of lagging more decades behind in what is happening federally for tribes, imagine if Maine were to become a state leading the charge, actually working to advance and strengthen tribal sovereignty and protect that, therefore improving life for all of our communities across the state. It's, I think, imagine the world and the Maine that we all know and love, if that were what we were investing in, if Wabanaki tribal sovereignty were, first and foremost, and we have the opportunity to do so, is the good news. And so, over 1,600 Mainers have testified in favor for this very, similar things before in record numbers for testifying. And there are over 300 orgs and businesses that have joined and supported the Wabanaki Alliance Tribal Coalition. So I think there's a resounding chorus of voices before you to listen to. And I hope that you'll do that duty in listening to our ample voices demonstrating what Maine stands for. So again, passionately restate my and Healing First position of being in full support of LD 785. And please do so and invest in our collective future. Thank you.
Thank you for your testimony. Are there any questions, committee members? Thank you. Are there any questions, committee members? Not seeing any. Thank you for your testimony.
Thank you.
And I think we have one person left on Zoom, and it's Jane Field. If you could activate your camera, please. Welcome.
Thank you. It's good to be with you all again. It's been a while. Senator Carney, Representative Kuhn, members of the committee. I'm Jane Field. I'm the executive director of the Maine Council of Churches. And as I think you all know, we're a coalition of 7 Protestant denominations who have more than 400 local congregations across the state with over 50,000 parishioners in their care. I'm testifying on behalf of the council tonight in support of LD 785. The Maine Council of Churches is a proud member of the Wabanaki Alliance Coalition, and as such, we continue to affirm the sovereignty of the indigenous tribes whose land is now called Maine. We support the right to self-determination, self-governance, self-sufficiency, and cultural identity, and we lament that certain decisions made in the 1980 MIXA Act have deprived them of these rights. We lament that for 40 years, restrictions in MIXA have blocked the Wabanaki nations from accessing all of the federal self-determination policies that have helped 570 other tribes in the United States. As you've heard many times this afternoon, those who drafted MIXA were clear. It was meant to be a living document that should be updated as necessary. And 6 years ago, a bipartisan task force was clear in the recommendations for what needs to be changed. It's high time the council believes that all of those recommendations are acted upon so that what is broken in the original document can finally be repaired. It's the moral thing to do, we believe. It also happens to be the right thing to do for economic reasons, and you've heard all of those numbers over and over again this afternoon. I won't repeat them now. In asking you to vote ought to pass on LD 785, the Maine Council of Churches is asking the legislature to honor our state's responsibility to the tribes and to honor the work of the task force by implementing their recommendations for changing MIXA. It is a necessary step toward repairing the terrible damage that has been done for so many years, and toward promoting harmony and reconciliation and mutual understanding between our communities. That's a step that's long overdue. Thank you.
Thank you. Any questions for Reverend Jane Field? Not seeing any. Thank you for joining us.
Thank you.
And if there's anyone left online who wishes to provide testimony on this bill, either in support, in opposition, or neither for nor against, if you could please raise your hand and leave it raised. Okay, I think we've taken all the testimony on this bill, so we'll close the public hearing on LD 785. And I do think we have some language review before we go.
Very improving.
You don't want me to cry, do you?
All right, can Janet have the floor, please?
So this is just one quick language review. This is LD 2142, an act to establish guidance for awarding general spousal support. This was the bill submitted by FLAC. It was unanimously supported with one member absent, not voting. You already saw the preliminary language that I sent over to the revisor's office, and I wanted to point out to you some slight changes that I think were very helpful clarifying changes. A lot of times we, throughout the amendment, talked about money spent in support of the children of the marriage, and they wanted to be clear that it could be just one child or children. So that type of language is added throughout. There was a place where we talked about a second award of general spousal support that would commence at a certain time. The better phrases take effect. So that was changed. And then I did not succeed in getting two numbered paragraphs connected by a but instead of an and. So I restructured the language on page 4 so that there's an and there, but it should still say the same thing substantively. There is now a fiscal analysis and there's no fiscal note needed.
Any concerns, committee members? Is there a motion to adjourn? So moved. And all those in favor?